ನಾನು ಕಾಸು ಕೊಟ್ಟವನಿಗೆ
ಏನ್ ಅರ್ಜೆನ್ಸಿ when the order is passed 24/3 notice ಆಯ್ತು ಫಸ್ಟ್ ಆರ್ಡರ್ ಫಾರ್ ಪೇಮೆಂಟ್ one second page wise
page 1 seal number 1 to 5, page 2 seal number 6 to 12,
serial number 10, my lord. Pray for 2 weeks time, my lord.
fourth time you only have more than one.
Yes, my lord. Senior is not well, my lord.
one ನಿಮಿಷ.
Senior 7 and 9 yes, which is your matter?
Serial number 10, my lord.
Non-compliance. Yes.
Page 3, page 4 seal number 13 and 14, page 5 seal number 15, page 6 seal number 16 to 25,
One second.
page 7 seal number 26 to 33,
Hardipur. 20 to Pradeep Kumar. Agenda at the request of the petitioner's counsel. Yes.
page 7
20. Hi, Pierre. Who is Shekhar? Hello, colleagues. When do you want it? There are two for 19, 20 even 20 only. As it was the petition's counsel less than 5.
Page 7 seal number 26 to 33.
Who has moved a memo? Somebody has moved. You are for?
In serial number 30, I am for the petitioner, my lord.
They are seeking adjournment.
My lord, I have no objection for 1 week adjournment. Interim stay is required to be extended, my lord.
What is the interim stay has not?
Interim stay is there. It is there till today. Till the next.
It is there. Already it is there.
It is there. It is there. It is required to be extended.
And at the request of the council.
Maybe adjourned by 1 week, my lord. Interim stay. In the meantime, interim stay may kindly be extended.
Concept of second respondent. Interim order granted earlier is extended till next November. Yes. Adjourned ಅಂತ ಅಷ್ಟೇ ಹೇಳಿದ್ವಿ. ಅದಾದ್ರೆ ವೆಕೇಶನ್ ಬರುತ್ತಲ್ಲ 2 weeks. Vacating stay application is also listed. ಈಗ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಅದು ಎಲ್ಲ ಒಂದೇ ಆಗುತ್ತೆ ಮಾಡಿಬಿಡಿ ಕೊಡೋದಿಲ್ಲ ಟೈಮ್ ಸಾರಿ ಸರಿ ಸರಿ ಯಾಕೆ ವೆದರ್ ಶಿ ರಿಟೈರ್ಡ್ ಆರ್ ನಾಟ್ ರಿಟೈರ್ಡ್ the matter is listed for final disposal. You are enjoying an interim stay. All right, if you have a meritorious case, I argue it. Right. We do not know why it was approved, but it is. So in the presence of both of you only it was done. Then how can you complain that now? Fourth ಒಂದು ತುಂಬಾ ಹೆವಿ ಇದೆ ಬೋರ್ಡ್ ಅಂತ ಹೇಳ್ತಾರೆ. I will consider the application 6 adjournment. I will consider the response opposed. Hagiದ್ರೆ why it should be decided only on the application? Let it be disposed of finally. The final class this one like 4th.
Page 8, 34 and 35. Page 9, serial number 36 to 41.
Serial number 38, my lords. Petitioner, settlement will happen, my lords. Paying for one short date, my lord. Settlement. Serial number 38, my lord. 38.
But other side council is not. This is a workman's fiction.
Yes, my lord. Already spoke with the parties. Settlement will happen, my lord. All accommodation may be granted.
Fixed adjournment on the ground that the parties are trying for settlement is stopped at 2 weeks. Yes. 2 weeks.
My soul.
ಯಾವಾಗ ಬಂದ್ರು ಅವತ್ತು ತಗೋಬೇಕಂದ್ರೆ ಇನ್ನು ಯಾರೋ 10:45 ಬಂದು ಕೊಡ್ತಾರೆ. But while doing this, you only remember in the school of your children, when the bell rings, your children will not be allowed into the school. When the children have that discipline, why can't you have that? Format is there ತಗೊಳ್ಳಿ. ಇಲ್ಲ ಅಂದ್ರೆ ತಗೊಂಡು not in format ಅಂತ ರಿಜೆಕ್ಟೆಡ್ ಅಂತ ಕಳಿಸಿ. Yes. How long he was absent? How long? No, during the inquiry, whether he had appeared. So what will be the total absence period? He remained absent from? So 9/3/2005 onwards, he did not report at all till this order was passed.
By suppressing this fact, he has again appeared before the tribunal. He succeeded, and from after that, when we noticed this thing, was dismissed again from the submission. No document documents or records.
Reinstated with continuity of service. Consequential notice to the respondent. Just in order. Orders. One is on fairness and the other one is on impugned orders. See, final order is stayed. Yeah, sought interim order of annexure N and P both. Order. Impugned award. Impugned award. Till exchanging date. They are connected to each other. 17 day. 17 day. 17. Correct. Anybody, any of their advocate who was representing them before the trial court? Or penal advocate? Or copy sir ಮಾಡ್ತೀರಾ ಹೇಗೆ? ಎರಡು ಕನೆಕ್ಟ್ ಮಾಡೋಣ. Serial subsistence allowance in the industrial dispute. Copy sir ಮಾಡಿ ಆಯ್ತು here ಮಾಡ್ತೀನಿ. These two matters are connected to each other. Copy sir ಮಾಡ್ರಿ ಇಲ್ಲೇ ಇರ್ತಾರೆ ಸರ್ ಮಾಡಿ here ಮಾಡಿ ಮಾಡ್ತೀವಿ ಆಯ್ತು. These two matters are connected to each other. Therefore, list them together. There are other matters also. File ಆಗಿದೆಯಾ? ನಂಬರ್ ಕೊಡಿ ಮಾಡೋದೇ. ಆಯ್ತು ಅಲ್ಲಿ ನೀವು ಕೊಟ್ಟಿರಿ will pass orders so that the writ petition numbers will be mentioned. It is submitted that these matters are connected to WP number so and so. Number ಕೊಡಿ ಆಯ್ತು. Learned counsel for the petition is permitted to serve a notice on the list all the matters together. Learned counsel for the petition is permitted to serve a notice on SN Murthy ಅಲ್ಲಿ ಇದಾರೆ ನೋಡಿ ಕಾಣ್ತಾ ಇದಾರೆ ಸೋಮಶೇಖರ್ ಅಂದ್ರೆ
ಸೋಮಶೇಖರ್
ನೋಟಿಸ್ ತಗೊಳ್ತೀರಾ ಅವ್ರಿಗೆ?
which company ಮೇಡಂ?
Toyota.
Yes, madam. Yes, we'll take notice. We'll take notice. We'll take notice, madam.
Respondents accepts notice. Okay. List on. Adinnu 5 matters ಇದೆ ಅಂತೆ.
Yes, madam.
ಆಯ್ತು list ಕೊಡೋಣ.
Yes, madam.
When do you want it? Or copy serve ಮಾಡಿ so that he can take it. 2 ವಾರ ಬಿಟ್ಟು ಹಾ ಸರಿ. ಕಾಮನ್ ಆರ್ಡರ್ ಇತ್ತಾ ಅಲ್ಲಿ? ಟ್ರಿಬ್ಯುನಲ್ ನಲ್ಲಿ ಕಾಮನ್ ಆರ್ಡರ್ ಅಲ್ಲ, ಐಡಿಸ್ ಡಿಫರೆಂಟ್. ಆಯ್ತು ಆಯ್ತು ಆಯ್ತು.
Appear for the respondent in the first case and the petitioner in the second case. This, my lord, the agency was retired from this case. Therefore, if notice had been ordered, court notice had been ordered by this honorable court.
Then no such person anta bandide. No such person in this address anta bandide.
Because he had given the care of the union address, my lord, in the caste title before the labor court on all that. Then you will have to kindly see in the connected matter, there is one address, my lord. In the connected matter, may kindly see, my lord, at page.
In charge sheet, his name may be.
Page 13 may kindly be seen, my lord. In the connected matter, madam.
This was to be given in both the matters.
Yes, madam. Because agency was retired in both the matters.
Page 13.
Page 13, madam.
Whitefield Post, Kadukodi Colony, Bangalore. Ashte ide.
In fact, next page may kindly be seen 14. he writes the address as Kalago. Next page, madam, 14, madam. It is
All right.
because that's the only address we have got. Even at the page 17, you will actually get it. We have communicated only to that.
We'll direct to send the notice to that address.
Both the address. Yes,
He's
madam.
not
Please.
interested in prosecuting the matter. Or?
I don't know. A.J. Srinivasan said that he is not coming, therefore he retired, my lord. A.J. Srinivasan in both the cases. Therefore, court found that.
What was his age?
My lord?
What was his age?
Age, he was 45 when it was filed in 2010. He must be about now 55, 58, my lord.
Only one notice person. In annexure A and B in writ petition. In annexure, issue notice to the petitioner.
His father name may be added, my lord, in that address. Son of Sri Nallappa. Because there it is father.
Son of Nallappa.
Nallappa. Because in Kal.
At the address shown in annexure A and B. Annexure A and B in writ petition number 31,038 of 2009. You the 2009-2010 matter, sir.
Yes, my lord.
ಏನು ಸುಮ್ಮನೆ ಕ್ಲೋಸ್ ಮಾಡಿಬಿಡ್ಬೇಕಾ ಹೇಗೆ?
The court felt that another notice should be issued, my lord. It is come back, but we will try it for this address, my lord. If he does not appear,
It
then
shows since January 2021 there is no representation for the petitioner. His counsel retired in 2019. 4/6/2019.
but order was passed, my lord.
But such retirement was not after issuing notice. Notice ಕೊಡದೇನೆ ರಿಟೈರ್ ಆಗಿದ್ರು ಅವರು. This one. Wait. Application.
335. Number 5. Ramya Hassan.
My lords, I appear for the petitioner in this matter, my lords. My lords, the office objections have been complied.
Page initiation to be redone after compliance. Copy to be served to the K-waiter and acknowledgement to be filed. Annexure J to be filed. Pages stitched after wakalat to be clarified.
My
There
lords,
are 4 episodes.
they have been complied, my lords, but I'll have a look at it if there is any other pending, my lords, today. My lords, may kindly have it on Monday, my lords.
We'll be able to do that. Today is as requested.
Grateful.
Number 6. Somshekhar.
Lord, in this case, I appear for the petitioner. We have engaged senior counsel, but my lord, what happened yesterday? They have sent a statement of objections. I have to brief. Yesterday night, I got it by email. I have taken a printout. I have to brief the senior counsel. Next week, it may kindly be taken up.
Consideration of interim prayer.
That's right, madam. Yesterday, they have sent the statement of objections by email. I have taken a copy, but I have to brief the senior. Next week, may kindly be taken.
So, list on next week. 5/4.
5/4.
Which date, madam?
5/4.
Much obliged. Much obliged. Much obliged.
ಹೇಳಿದೆಲ್ಲ 10th.
Number 8. Sanjeev PL.
K-waiter notice ಹೋಗಿತ್ತಾ ಹಿಂದೆ? One. Since you are the K-waiter, since Shri Sekhar L has appeared for the K-waiter, services have insufficient. Okay.
On issue of if there's a regular repair on issue limits 6 passage the checking spot number 2,400 rupees at the time. In spite of that, the labor code comes to the conclusion page 43. There is the award of back wages. Consequently, second one is directed to reinstate the first party service within 4 weeks. So back wages with continuity of service last drawn date drawn by 43 in spite of that, the charges are going to be too. It won't settle
And annual increments were ಈಗ you are seeking interim stay of this. Reinstate ಮಾಡ್ಕೊಳ್ಳಿ. Yesterday you only were asking, then they will come with 17B application. Application?
gainfully employed, you cannot make it. He has to make an application.
Sir, yes, what do you say? Application ಆಗ್ತೀರಾ? Interim order ಆಗಿರಲ್ಲ. He is seeking interim stay. What do you say for that? Yes, ಏನು ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾ ಹೇಗೆ ಮಿಸ್ಟರ್? Inquiry was held fair or not? The inquiry was held fair and proper. Interim stay of the interim award till next hearing date. Next hearing date, only till next hearing date. You file the counter, huh? Call for TCS. This doctor receipt to TCS. Yes.
Correspondent.
You have filed application. IA1 of 2021 is filed by whom?
What is this serial number 11?
Serial number 11. Yes.
Well, I am for the respondent in this matter.
Yes.
But there are two IAs that are filed.
That's what are the IAs who has filed them?
Well, one IA is filed by the petitioner, one is filed by the respondent. Both are asking for the same relief. There is a deposit that is with the court today, about 4,27,778 rupees. Both parties are asking that amount be released in their favor. IA number 2 of 22, 1 of 22, my lord, is filed by me. I am the liquidator representing, my lord, the petitioner company.
What is the award challenge here?
My lord, the background of this matter is the respondent in the writ petition is an employee of the petitioner company. He was not paid certain dues from the company. He approached the labor tribunal, which passed an order in his favor for 8,59,788 rupees. That order, my lord, is challenged before this court by filing a writ petition. And in this writ petition, my lord, the stay was granted and 50% of the amount was required to be deposited by the company. Then, my lord, the petitioner company, my lord, came to be wound up by an order of the National Company Law Tribunal. Pursuant to the winding up of the company, my lord, the liquidator has been appointed. I represent today, my lord, the liquidator. Now, if my lord could also take the order, this writ petition was disposed of on 16th of March 2021. 16th March 2021. Taking on record the fact that the company has been wound up, the High Court disposed of the writ petition. 16th March order has, it says during the pendency of the present
urged before the NCLT.
Any claims is required to be urged before the National Company Law Tribunal. Then, my lord, while disposing of this order, what was not paid attention to is the fact that there is a deposit that is lying in this court today. 50% of the award amount, my lord, is lying in the court. It is deposited by the company which has now been wound up.
Let him complete so that he can. Yes.
The company that is wound up, my lord, has deposited this money in the court today. That 4,27,000 rupees has been deposited by IDEP Projects Private Limited, which company has been wound up. Now, my lord, what has happened is the respondent has filed an application saying that that amount is lying in the court. You please release that amount in my favor is the request of the respondent. That is the earlier IA that was filed. I have, my lord, filed objections to those to that IA. My contention, my lord, on that IA.
You are not come on record. You are not on record. You are a party.
I am not a party to the writ petition, but I am the liquidator of the petitioner company. I have filed a separate wakalat on behalf of the liquidator as well. I step into the shoes of the company that is in liquidation.
No, he says he represents the liquidator, Akshay liquidator. So he has filed the appeal. Let him complete. You completed your side. Let him
No,
complete.
madam, no, I have to.
Which is your IA1 of 2021 is filed by you. Advocate for respondent. Yes.
On their IA, my contention is that the rights of the parties have not been adjudicated finally by the court. Though the labor tribunal decided that the respondent is entitled for a certain amount, that is in challenge before the High Court, and the High Court did not adjudicate the matter on merits. While the matter was pending, my lord, the company was wound up. Therefore, the High Court passed an order simply directing the parties to approach the company law tribunal to determine what their rights are or what their entitlement is. Therefore, the application of the respondent that the amount should be released in his favor should not be entertained, because the entitlement of that amount is not decided by the High Court today. There is still a question mark on whether the respondent is entitled for the amount or not. In that circumstance, my lord, the amount should not be released in favor of the respondent. On the contrary, my lord, I have filed an application to release the amount in favor of the liquidator. If my lord could, if my lord has the Insolvency and Bankruptcy Code, I would just like to point out one provision of that law, the Insolvency and Bankruptcy Code.
Bankruptcy Code.
IBC 2016.
IBC 2000?
2016, my lord, Insolvency and Bankruptcy Code 2016.
Which is that provision?
My lord, section 36, my lord, speaks about the liquidation estate. And I will only read this one clause of 36, 3E, 3E. My lord, it says, I mean, 36 identifies which are all the liquidation estate. Once a company is wound up, what are all the estate which the liquidator can take over for the purpose of liquidation of the company is what is described in section 36 of the Insolvency and Bankruptcy Code. 36 3E says this, my lord, assets subject to the determination of ownership by the court or authority. Now, the asset in question before this court today is that 4 lakh rupees that has been deposited. Now, the validity or the ownership of that asset, my lord, is not determined as on date, because the High Court has not passed any order on merits. It has asked the NCLT, the parties to approach the NCLT and file their claim before that. The asset subject to determination or ownership of the court, my lord, becomes a liquidation estate. In the sense, the liquidator needs to take over that asset and then distribute, because there are several claimants on this company which is under liquidation. There are secured creditors as well as unsecured creditors. I need to assess what is the total estate that is available with the company that is in liquidation. And thereafter, there are claims which I have already received from the banks, as well as statutory authorities, as well as the employees. So therefore, my lord, I have filed that IA, where I am asking that that amount be released in favor of the liquidator, so that the liquidator can take over the estate of the company that is in liquidation. And then in accordance with law, my lord, whatever is the method in which it has to be distributed, not just to the claimant here, but also to everybody else who have made a claim against this company. And my lord can also see that I have furnished the order of liquidation as well. It is there along with my IA. This IA was filed on 24th of January 2022. In that, my lord, at page number 7, there is the order of the NCLT. My lord will see that it is between Mr. Velayudham Jayavel. He is the liquidator who has also filed his application, which my lord is presently considering. He was appointed as the interim resolution professional, and when the company could not be revived, they passed the final order winding up the company itself. I will request my lord to kindly take the operative portion of this order. If my lord will kindly take page number 16, paragraph number 9, they say in the result, IA number so and so and CP number is hereby disposed of with the following directions. We hereby order that IDEC Projects Private Limited to be liquidated in the manner as laid down in Chapter 3, liquidation process of Part 2 of the Insolvency and Bankruptcy Code. We hereby appoint Sri Velayudham Jaivel, registration number so and so, as liquidator, subject to the terms and conditions to be agreed upon by the parties in the light of the extant provisions of the IPBI, Insolvency and Bankruptcy Institution. So this Velayudham Jaivel has been appointed as a liquidator. The company has been fully wound up, and it has been ordered to be wound up. And the liquidator today, my lord, is considering what are all the assets and liabilities which this company has. And my lord, this amount that is deposited in the High Court is also an asset of the company which is in liquidation, and which would have to be a part of the liquidation estate, as I pointed out from section 36(3)(e). It says any assets that are pending adjudication before a court or an authority forms a part of the liquidation estate. So, my lord, my request is that the IA that I have filed, IA number 1 of 2022, that is filed by the liquidator, that IA may be considered, my lord, and the amount that is lying in deposit may be ordered to be released in favor of the liquidator, so that it becomes a part of the liquidation estate, and then the liquidator can go ahead with the liquidation process itself.
Yes.
Company is simply harassing no response. It's a very good company. Even in the payment of gratuity, forcing the respondent to lodge an application before the Assistant Labour Commissioner, who is the controlling authority for payment of gratuity. Here also, petitioner did not pay the gratuity even after not was passed, forcing the respondent to correct the same as gradually moved to the good offices of the London Capital. So that is that. He is only a preamble, a gesture, how he is grasping to his workmen. When an attachment warrant was taken to the doors of the petitioner, it issued an invalid check and it took several months for the respondent to get the gratuity amount awarded by the controlling authority. Whereas already the petitioner company has recorded payment of arrears of charges for more than 12 years. He was working in Bangalore. He is a Bangalorean. He has got a family in Bangalore. He was posted to Delhi. For 8 months, they did not pay a single fine. 8 months or 22 days. They did not pay a single money, single fine to him. And he submitted the resignation. But the resignation was not accepted by them. See the timeline. I just wanted to touch the very application of number IA1 of 22 submitted by the liquidator. It is not the petitioner who has submitted the application. Only the number this application is signed by him. But affidavit is sworn to an liquidator. They are both adversaries. You will actually kindly tell us the counter statement I have submitted to IA1 of 22. Is not thinking into either in law or practice. Even according to your actually kindly produce the application. Again, one of here, he clearly says the petitioner company has no local standard to sue or be sued once the appointment of the liquidator is approved by the national company law framework. According to him, according to the liquidator himself, his appointment as a residential professional liquidator was approved by the National Company Law Tribunal on 8/11/2019. 8/11/2019, the writ petitioner from this very day, the writ petitioner collapsed. And became infectious. From this very day, the writ petitioner ceased to have any local standard to continue the proceedings, even according to the liquidator. The cause of the petitioner is different, and the cause of the liquidator is altogether different, separate, and independent, my lord. Even according to the liquidator. My lord, this appointment of the liquidator was hardly contested by the liquidation company, and if the lie of law, both have become adversaries to each other. The application is filed by the petitioner, and the affidavit is formed by the liquidator. My lord, when the resolution professional liquidator does not come on record in this situation, he has not yet come before the Honorable Court. The moment
He is in charge of the company. Now he will be in charge of the company liquidator.
Yeah, as part of the he has to file. I will come to that.
Yeah, he said
yes. I have submitted all the documents. I have explained. I have filed processing certificate and he has filed and I have submitted several documents before him. I will come to that. You are actually trying to tell this particular owner statement.
Once now the case is under company is under liquidation, whether this court can decide the claims of the parties.
I am only for because liquidation was right.
Yes.
He is not correct. At that time, this honorable court passed this day, and I have suffered this day. I have suffered this day.
See,
yes,
the claim was against the company.
I have suffered this day, and on the condition that he will deposit 50% of the award.
Correct.
He has not fully remitted the 50%, but 1,4,17,000 also here. The award amount is 8,55,000, and my execution petition is for 15 lakhs.
Subject to payment of 50% of the amount. Yes.
He did not even pay 50% then.
No, what was the award?
The amount was 15 lakhs. According to him, 15
No,
lakhs.
what was the award amount?
Award amount 15 lakhs. Award amount 8,89,000, including 9% interest, it comes to 15 lakhs. I have execution.
Pending disposal of the writ petition, there shall be an interim order of stay subject to payment of deposit of 50% of the amount. So that is not clarified.
I am entitled for it. So when the writ petition collapses, I am entitled. He cannot claim on
Writ petition was not decided on merits. It was. What is the effect of winding up?
Injuries that is likely to be suffered by you. Just about this particular outer state.
Correct. What? Once a company goes into liquidation, correct. Correct. Even both of you are not showing us the law. You are seeing only emotional submissions you are doing. Mr. Counsel for the liquidator, tell us which provision bars the jurisdiction of this court if once the liquidation proceedings start.
Which bars the writ petition is already disposed of, my lord. I read out that order earlier, where my lord has already considered that the company is in liquidation and has directed the matter to be placed before the NCLT.
Reserving liberty to respective parties to make necessary application before the National Company Law Tribunal. This petition stands. So this amount should have been remitted to the transfer to the NCLT while disposing of the matter. Both of you could have executed your rights,
Not to the NCLT, my lord, but because the NCLT cannot hold that, because the NCLT is not deciding today the claims of the parties. It is a liquidator that needs to decide the claims of the parties.
Correct.
And then report
See, the
to the
order is like
tribunal.
that. Reserving liberty to the respective parties to make necessary application before the National Company Law Tribunal that this petition stands disposed of. So amount also should have been remitted to the said authority. Not to the liquidator. Then if he was entitled, he was filing application. If you are entitled, you should have filed application.
My lord, the liquidator, my lord, is not a private party who is holding on.
Now then you have to file application to recall both of you to this order.
My lord, may I submit this, my lord? My lord,
go and see, we will not release it to the liquidator. You go and... Paragraph 4 of? Counter statement, which of? Paragraph? Paragraph, yes.
Along with the claim petition, respondent has furnished the order passed in application number 17 of 2010 on 7/9/15 by the Labour Court, Bangalore. A copy of the execution petition number this particular petition, 21/88 of 2016. Copy of this petition, a copy of the stay order, 22/3/17, etc. On 25/11/2019, the resolution professional expeditor has admitted the claim of this respondent for 15 lakhs. He has already admitted the claim. So he was well aware of the writ proceedings pending before this honorable court, but he did not choose to come on record for the reasons explained in the succeeding paragraph. It is clear that the writ petitioner company has set him up by his instant application in order to continue to harass this respondent further and more. Your Lordship will kindly see that I have explained clearly why he did not come on. Number 5, Your Lordship. It is further submitted that as per the insolvency and drafted bankruptcy court, the respondent is an operational creditor. The workman is an operational creditor. In distribution of the process, operational creditors have first claim and workmen have priority. Therefore, even if the amount of the FD amount of 4,27,778 is released to the respondent, neither the petitioner company nor the liquidator will do any hardship or injury whatsoever. On the other hand, this respondent is expected to unfold the great hardship. This middle-class family is something worse to injury, especially for the last 2.5 years. In settling the case, they can deduct so much of amount paid here and pay the balance to the respondent company will still be due to the respondent about 13.75 lakhs. The resolution professional liquidator was well aware of these acts and the law, and hence did not choose to come on. He was very well aware.
When the company went into liquidation? 8/11/2019.
Oh. 30.75 lakhs still.
This order was
Because
passed.
of this, he did not come on.
Interim order was passed on
22nd March 2017. Madam.
no, this interim order.
22nd March 2017. Madam. That's the date of the interim order.
The petition itself is disposed on 16th March 2017. The interim stay was granted on
The petition was disposed in March 2021. My lord, interim stay was granted on 22nd March 2017.
2020. Oh, yeah, right.
And hence did not choose to come on. Now it is clear he has been set up by the.
So from 2019 to 2021, you did not come on record in this case.
I did not come on record in this case, my lord, from the time of the winding up.
Then why did you not come on record? The petitioner only got disposed to the matter, driving
My
them
lord,
towards the NCLT.
My lord, when the matter was disposed of, my lord, the lawyers who were representing the
right,
company in
now-
liquidation were on.
Now this court has directed both of you to NCLT. Go and file application there.
My lord, may I point out a couple of aspects, my lord?
Only I went there to file an application. Because it is my money.
Yes. No, we cannot say that. Even if he files, the court will decide that.
My lord, I may I just point out a couple of aspects, my lord, which may
Right.
answer my lord's
See,
queries.
we cannot stay his hands. If there is no merit, they will dismiss it. That's all. See, this court has said reserving liberty to the respective parties. This court has said reserving liberty to the respective parties to make necessary application before the NCLT. This petition stands disposed. Not before this court, before NCLT. You have already filed. You have already filed before NCLT. Then ಬರ್ದಿದ್ದೀರಿ. ಯಾರ? When? ಎಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ? Where have you filed that claim petition? Liquidator ಬಂದ. NCLT.
My lord, may clarify a couple of aspects, my lord.
We do not want to hear you further.
through the paper publication. He asked
Orders and IA, one of 2021 and one of 2022. The above petition was filed. Challenging.
He's already admitted for 15 lakhs. The creditor has already admitted for 15 lakhs.
Annexure D is award. Annexure D was challenged in this petition.
What was challenged was the order dated 7/9/2015 of the second additional labor code.
Annexure D is
Annexure D. Yes,
33C2 application. Order Annexure D dated 7/9/2015. By the said order, the labor code allowed the application of the respondent under section 33C to PD Act, claiming rupees 8,55,555 with interest at 9% per annum from the date of the application till the date of payment. On 22/3/2017, this court granted interim stay to the said order, subject to deposit of 50% of the amount. Pursuant to that, the petitioner deposited rupees 4,27,778 before this court. Pending the proceedings, the petitioner company was wound up. 21. Recording the wound up on 8/11/2019. 8/11/2019. Recording the same. This court post of the writ petition, reserving liberty to the respective parties to make necessary application before National Company Law Tribunal interpreted NCLT. However, no orders were passed regarding the amount in deposit.
The creditor has already filed the admitted claim before the NCLT. I need not even go to NCLT because my claim has been already admitted to the creditor. The creditor who has no process.
A1 of 2021 is filed by the respondent for release of the said amount. The option liquidator has signed A1 of 2022 for release of the said amount to him.
The claim has been admitted.
So both counsel submitted at length about the entitlement of the said amount. The option liquidator was not a party to this petition. Moreover, when the petition was disposed of, none of them made any claim. None of them sought any orders with regard to the amount in deposit. Since the petition is disposed of, reserving liberty to the respective parties make necessary application before NCLT, the amount in deposit shall be transferred to NCLT. All right, liberty to claim, make their claim before the NCLT. Yes, the applications are disposed of accordingly. ಅಲ್ಲೇ ಹೋಗಿ ಮಾಡ್ಬೇಕು, ಅವ್ರು ಯಾಕೆ ಕೊಡ್ತಾರೆ? How can we pass? We have transferred the amount to the NCLT. We have transferred the amount to the NCLT. This court, they cannot release that amount unless and until it decides the eligibility of both of you. Next person, sorry. Next person. Now, what is IA1? What is IA1 of 2021 in 704? IA1 of 2021. Please to pay minimum wages of so and so in terms of official memorandum dated so and so. Later or during the pendency of this petition, further direction to pay difference of minimum wages. June, July, August, September 2021 and continue to pay the same. Now this. What was the interim order? Date of interim order?
Date of interim order 4/3/2021.
4/3. One second. Date of interim order ಹೇಳಿ. ಹೇಳೋ ಸ್ಪೀಡ್ ಅಲ್ಲಿ ನಮ್ಗೆ ಹುಡುಕಕ್ಕಾಗಬೇಕಲ್ಲ ಇಲ್ಲಿ. Said reinstatement ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. Date of order. Date of order. 4/3/2020. That was after service. Therefore, there can be no justification for response not to reinstate these petitions.
They are paying 3,000, 4,000, one ಕೊಡ್ತಾರೆ. That's why I'm filing the direction. Actually, you want to see the and it's a law matter.
Now, you say these matters are connected to?
1574 of 2020, which has been ordered to be listed on 12th of April.
ಇಲ್ಲೇನೋ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆಲ್ಲ ಡೀಲಿಂಗ್ ಮಾಡೋದಕ್ಕೆ.
So many cases connect ಆಗ್ತಿದೆ ಅಂತ ಎಲ್ಲ confusion ಆಗಿದೆ. That is the reason why the our report deal with the all matters with batch wise ಇದೆ. Batch wise one case in the different nature of case.
ಮೂರು ಜನ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮಾಡ್ತಿದ್ರೆ ನಾವ್ ಹೇಗೆ ಕೇಳೋದು ಅಂತ ಗೊತ್ತಾಗೋದಿಲ್ಲ ನಮಗೆ. ನಮ್ಮ ಕೋರ್ಟ್ ಆಫೀಸರ್ನ ಸೇರಿಸ್ಕೊಂಡು 3 ಜನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿದ್ವಿ. ಅಲ್ಲ ರೀ, ನೀವು ಯಾವ್ದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಂತ ಹೇಳಿ, ಬಿಕಾಸ್ ದೇರ್ ವಾಸ್ ಎನ್ ಆರ್ಡರ್ ಟು ಡೀಲಿಂಗ್ ಸಮ್ ಮ್ಯಾಟರ್ಸ್. ಅದು ಒಂದ್ಸರಿ ಡೀಲಿಂಗ್ ಮಾಡೋದಕ್ಕೆ ಆರ್ಡರ್ ಆಗಿದ್ರೆ ಅದನ್ನ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. Which are those connected matters?
12 to 12.9 are arises from the same batch matter.
12 to
12.9.
Illidalla, you said there are some connected matters which are listed. Correct. Why don't you understand? On 21/1/2022, some matters were dealing to saying that they are not connected. If you are saying again those matters are connected, how do we come to know that? Yenadu, what is the order challenge?
The order termination. They are challenging before the labor court. The labor court has directed the petition on the reinstatement.
Bescom has challenged. What is the order challenge here?
The order challenge the order termination.
What is this? Was one James Fowl. Is the award passed? Arrangement is set aside. Second party is hereby directed to reinstate the first party workman in the same place as he was working prior to termination or refusal order dated 1/3/2015. Whether several workmen were together terminated under the common order, refusal.
Individual order passed by the labor code.
Not labor portal. ಇದು ಎಲ್ಲರದು oral termination all workmen on the same day all were terminated 1/3/2015. ಮತ್ತೆ ಕನೆಕ್ಟೆಡ್ ಹೇಗಾಗೋದಿಲ್ಲ ಹಾಗಿದ್ರೆ ಒಂದೇ ದಿವಸ several workers were terminated by orally terminated or what is that? ನಿಮ್ಮದ್ರಲ್ಲಿ ಈಗ ಇದರಲ್ಲಿ all those 12 matters have come up today. What are the other matters?
12.11 and 12.12.
2010. Common ಅಂದ್ರೆ ಏನಾದ್ರು something in this case 1/3/2015. ನಿಮ್ದು ಯಾವಾಗ? October 2010. ಅದು ಹೇಗೆ ಕಾಮನ್ ಆಗುತ್ತೆ then? How it becomes common? They were terminated in October 2010. And in this case, they were terminated on 1/3/2015. 28/2/2016. ಇದೆಲ್ಲ ಬೇಡ ಒಂದು ಕೇಸಲ್ಲಿ ಜಡ್ಜ್ಮೆಂಟ್ ಆದ್ರೆ that applies to the other case also if the issue is the same. Why all those the cases should be connected? This court already has dealing with some matters. Then you want another order to circumvent that order? I ಈ application now you submit in this application. Non-compliance of ಏನು ಸಹ ಕೆಲವೊಂದಿಷ್ಟು ಕಂಪ್ಲೈನ್ಸ್ ಇದೆ ನೋಡಿ. 12.1 non-compliance of office subsections raised in scrutiny ban. IA 1 of 2021 ಯಾರು ಹಾಕಿದ್ದಾರೆ? 707 of 2019. ಅದು ಡೈರೆಕ್ಷನ್ ಇದೆ IA 1 for 2021 ಅಲ್ಲಿ ಕಂಪ್ಲೈನ್ಸ್ ಇದೆ ನಿಮ್ದೇ ಇರ್ಬೇಕಾಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ಬಿಟ್ಕೊಡ್ರಿ. IML objection ಇಲ್ಲ.
IML ಅಲ್ಲ ಅದು ನೆಕ್ಸ್ಟ್
IML ಅಲ್ಲ. ಓ ರಿಟ್ ಪಿಟಿಷನ್ ಮೇಲೆ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಅಂತ IML ಅಲ್ಲಿ. ಇದರಲ್ಲಿ ನೋಡಿ IA 1 ಏನಿದೆ ಇದರಲ್ಲಿ 707 of 2019. 707 ಹೇಳ್ತಾ ಇದೀವಿ ನಾವು. ಅದರಲ್ಲಿ IA ಏನಿದೆ? ಕಂಪ್ಲೇಂಟ್ಸ್ ಬರಲಿಲ್ಲ ಅಂತಂದ್ರೆ ನೋಡಿ IA 1 ಮೇಲೆ ಇರ್ಬೇಕದು ಅಬ್ಜೆಕ್ಷನ್ ರಿಪಿಟಿಷನ್ ಅಲ್ಲಿ ಇರ್ಬೇಕಿಲ್ಲ. ನೋಡಿ ಹೇಗೆ FR ನಂಬರೇ ಕೊಡ್ತಿದ್ರಲ್ವಾ ಇಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್.
ಅದ್ರ ಮೇಲೆ
ನೆಕ್ಸ್ಟ್ IA 1 ಯಾವುದು 12.4 rectification of office subsections raised on IA 1 of 2021. 721 of 2019. It will not run. Which one dismiss ಆಗಿದೆಲ್ಲ 12.4 ಅಲ್ಲಿ. ಅದ್ರ ಮೇಲೆ ಆಫೀಸ್ ಸಬ್ಸೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ವಿ. That will be dismissed. Application will be dismissed. ಅದನ್ನ 2020 ಎಲ್ಲ ಹಾಕಿದ್ರಂತ IA ನಂಬರೇ ಕೊಟ್ಟಿಲ್ಲ. Application then next WP 728 of 2019 ಅಲ್ಲಿ rectification of office subsections raised on IA 1 of 2021 ಅದರಲ್ಲಿ ನೀವು ಮಾಡಬೇಕು. ಅಪ್ಲಿಕೇಶನ್ 728 ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ ಅಲ್ಲ. ಅಲ್ಲ 12.6 ಯಾರಿದ್ರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಚಂದ್ರಶೇಖರ್ ಯಾಕೆ ಹೂ ಸ್ಪೈಲ್ ಮುಕ್ಕಣ್ಣಪ್ಪ ಸ್ಪೈಲ್ ವಕಾಲತಿ ಹಾಕ್ಲಾರ್ದೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ
ಅಬ್ಜೆಕ್ಷನ್ ಸರ್
ಅಲ್ಲ ನೀವೇ ಮುಕ್ಕಣ್ಣಪ್ಪನ ಇದೆಲ್ಲ ಮಾಡ್ದೇನೆ ಮತ್ತೆ ಬರೀ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ. ಈಚ್ ಕೇಸಲ್ಲಿ ಏನೇನ್ ಮಾಡೋದಿದೆ ಮಾಡಿ ಲೆಟ್ ದೆಮ್ ರೆಕ್ಟಿಫೈ ದಟ್. ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ದೇರ್ ಇಸ್ ನೋ ಕಂಪ್ಲೈನ್ಸ್. 12 ಅಲ್ಲಿ ಅದು ಒಂದು ಡೇಟ್ ಹೇಳಿದ್ರೆ ಲಿಸ್ಟ್ ಅದು ಉಳಿದ್ರು ಅಷ್ಟಕ್ಕೆ ವೆಕೇಶನ್ 24/5 ಅದನ್ನ 12 ಅಲ್ಲಿ 12.1 ಅಲ್ಲಿ ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್. ಇವ್ ರಿಟ್ ಪಿಟಿಷನ್ ಮೇಲೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ. ಅದರಲ್ಲಿ 4 weeks ಕೊಡೋಣ. 4 weeks time is granted to do the needful, failing which the petition shall stand dismissed. 12.2 ನಲ್ಲಿ ಅದನ್ನ ಒಟ್ಟಿಗೆ ಲಿಸ್ಟ್ ಕೊಡ್ತಾರೆ. ಯಾವ್ದು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲದೆ ಇರೋದನ್ನ ಲಿಸ್ಟ್ ಆನ್ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ 12.2 24/5 12.2 24/5 ಇವನ್ 12.3 12.2 12.3 ಎಲ್ಲ ಒಂದೇ ದಿವಸ ಲಿಸ್ಟಿಂಗ್. 12.4 ಅಲ್ಲಿ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅನ್ನ ಅದಕ್ಕೆ ನಂಬರೇ ಕೊಟ್ಟಿಲ್ಲ. ಡ್ಯಾಶ್ ಆಫ್ 2020 ದಟ್ ಈಸ್ ರಿಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಇಟ್ ಸೀಮ್ಸ್. 721 ಕೊಡಿ ಅಲ್ಲ ಅದ್ರ ಬೇಲಿಂದ ಇಟ್ ಅಪಿಯರ್ಸ್ ನಂಬರ್ ಇಸ್ ನಾಟ್ ಗಿವನ್ ಟು ದಟ್. ಇವ್ರು IA ಡ್ಯಾಶ್ ಆಫ್ 2020 ಅಂತ ಬರ್ದಿದ್ದಾರೆ. If you do not comply, application will be dismissed. Consequently, your petition dismissal of your petition stands. IA 1 of 2020 wakalat to be filed in respect of respondent. This is IA 1 of 2020. This was filed by recipient. Please to direct. IA 1 of 2020 is your application, not their application for wages. Call to be filed in respect of respondent. Why you have filed two applications for wages? ಎರಡರಲ್ಲೂ objections. IA 1 of 2020 is your application, not their application. Application ಅದೇ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದಕ್ಕೆ ಅವರೇನು ರಿಕಾಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡೋಗಿಲ್ಲ ಇದರಲ್ಲಿ. There is no mention for that. Have you filed application to recall the order in order of dismissal in WP 721 of 2019? Order sheet ಕೊಡಿದ್ರು. This petition stands dismissed against unserved respondent. Unserved respondent was private respondent only. ಇರೋದೇ ಒಬ್ಬ ರೆಸ್ಪಾಂಡೆಂಟ್. ಅನ್ಸರ್ವ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಯಾಕೆ ಮಾಡಿದ್ರು? ನೀವು ವಕಾಲತ್ ಹಾಕದೆ ಎರಡೆರಡು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀರಾ. ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿರೋ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಅಲ್ಲ, ಅವ್ರು ಡಿಸ್ಮಿಸ್ ದೇ ಆರ್ ನಾಟ್ ಫೈಲ್ಡ್ ಎನಿ ಅಪ್ಲಿಕೇಶನ್ ಟು ರಿಕಾಲ್ ದಟ್ ಆರ್ಡರ್, ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್. ನೀವು ಪ್ರಿಸ್ಯೂಮ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರಾ ರಿಕಾಲ್ ಆಗಿದೆ ಅಂತ? ಅದನ್ನೆಲ್ಲ ನೀವು ಮಾಡ್ಕೊಂಡಾಗ ಬರುತ್ತೆ. ಎಷ್ಟು 12.721. This petition was dismissed for non-prosecution and non-compliance on 28/8/2019. That order is sorry. Neither application is filed to recall that order, nor the order is recalled. Despite that, IA 1 and 2 of 2021 are filed by the respondent, filed by Shri S.B. Mukkannappa for the respondent without filing the wakalat. Since the petition is dismissed, IA 1 of 2020 and 1 of 2021 are not maintainable and disposed of accordingly. 721, unless that is recalled, it can't be listed. Since the petition is dismissed for non-prosecution, the registry shall not list the said matter along with the other matters. Okay. Iದೇನು ಇಷ್ಟೊಂದು 12.5 ನಲ್ಲಿ ಏನಿದೆ IA 1 of 2021 ಫಾರ್ ಡೈರೆಕ್ಷನ್. ಇದನ್ನು ಕೂಡ ಅಬ್ಜೆಕ್ಷನ್ ಇದು ಮೊದಲಿನ ಏನು ಲಿಸ್ಟ್ ಅಂತ 12.5 ಅದ್ರ ಜೊತೆ 12.6. 12.6. Rectification of office objection raised by finally 4 weeks time is granted to the pending which IA 1 of 2021 shall stand dismissed. ಅದನ್ನು ಅಷ್ಟೇ ಲಿಸ್ಟ್ ಆಗಿದೆ. IA 1 of 2020 ಎರಡು ಇನ್ನೊಂದು 731 ಅಲ್ಲಿ ಅದರಲ್ಲೂ ಅಷ್ಟೇ ನೀವು ವಕಾಲತೆ ಹಾಕಿದ್ರೆ ಇದನ್ನ ಮಾಡಿದ್ರಿ ಅಂತ ಕಳ್ಸಿಲ್ಲ ಎಲ್ಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಟೈಮ್ಗೆ ಎಲ್ಲಾನು ಸರಿ ಮಾಡ್ಕೊಡಿ. ವಾಟ್ ಇಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇನ್ ದಟ್ 20 and why you have filed two applications? Wakalat to be filed, to be mentioned as respondent in the index. ನೀವೇ ಹಾಕಿರೋ ಅಪ್ಲಿಕೇಶನ್ CS ನವೀನ್ ಕುಮಾರ್ ಅಂತ ಇದೆಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ 1.7 ಅಲ್ಲಿ that request finally 4 weeks time is granted to the needful failing which IA 1 and 1 of 2021 shall stand dismissed. 12.8 ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಏನೋ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ಸೊ ಇದನ್ನ ಕಾಮನ್ ಆಗಿ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆನ್ ಅಂತ ಸೇರಿಸಿದ್ರಲ್ಲ 12.8 12.9 ಎರಡು ಅರ್ಲಿಯರ್ ಮಾಡಿದ್ರಲ್ಲ ಲಿಸ್ಟ್ ಆನ್ ಅಂತ ಅದರಲ್ಲಿ ಬರ್ತದೆ. 12.10 IA 2 of 2022 rectification of office objection on IA 2 of 2021 and statement of objection filed by advocate for R1. What is IA 1 of IA 1 of 2020 no ade IA 2 of 2021 no adena IA 2 of 22 I have some report directed to possibly wages ಎಲ್ಲ ಹೇಳಿದ್ವಲ್ಲ we have to hear all of you but office ಇದ್ ಕೇಳಬೇಕು. when is that ರೀತಿ ಬೇರೆ ಅಪ್ಲಿಕೇಶನ್ ಬೇರೆ ಇಡೋದು ಲಿಸ್ಟ್ ಒಂದು ವೇಳೆ ಡಿಸ್ಪೋಸ್ ಆಗಿರೋ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಯಾಕೆ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ ಬಟ್ ಅವ್ರ ಪ್ರಕಾರ ದೀಸ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಆರ್ ಡಿಸ್ಪೋಸ್. ಯಾವ್ದದು 2848 ಅಲ್ಲಿ registry showing 3 applications are pending. IA 2 of 2022, IA 2 of 2021 and IA 1 of 2020. You are saying some of these IAs are disposed of. Which is that type? Yavattu? Yes, ಅಲ್ಲಿ ಯಾವತ್ತು ಅಂದ್ರೆ ಆರ್ಡರ್ ಆಗಿಲ್ವಾ ಐ ಮೇಲೆ ಸರ್ವೈವ್ ಆಗೋದಿಲ್ಲ ಅನ್ನೋದು ಒಂದ್ ತಿಂಗಳು. ಅಯ್ಯೋ IAS ಕೋರ್ಟ್ ಆಫೀಸರಿಗೆ ಎಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ಸ್ ತಗೊಂಡ್ಕೊಳ್ಬೇಕಲ್ಲ ನೀವು 1 of 2020 ಅಲ್ಲ ಇದು 2 of 2020 ಇಲ್ಲಿರೋದು 1 of 2020 ಎಲ್ಲಿದೆ ಇದನ್ನ ನೀವು 2 of 2020 ಅಂತ ಹಾಕಿದ್ದೀರಿ. ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಹೀಗಾಗುತ್ತೆ ನೋಡಿ. 1 of 2020 ಆಯ್ತು ಇದ್ರಲ್ಲೇ ಹೋಗುತ್ತೆ ಇಡೀ ದಿವಸ. ಒಂದ್ಸರಿ ಚೆಕ್ ಮಾಡಿ ಇದ್ರಲ್ಲ IA 1 2 ಯಾವ್ಯಾವ ಇದೆ ಅಂತ ಹೇಳಿ ಇಲ್ಲಿ ಪಾಸ್ ರಿಸ್ಕ್ ಮಾಡ್ತಾರೆ ಯಾಕಂದ್ರೆ ಅದು ನೋಡೋ ಸ್ವಲ್ಪ ಟೈಮ್ ತಗೊಳುತ್ತೆ. ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟದು 12.10 ಅದನ್ನ ಚೆಕ್ ಮಾಡ್ಬೇಕು ಅಂಕದಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ IA 12.11 rectification of office objection and IA 1 of 2021 filed by the Advocate for petitioner. It is IA 1 of 2021, 82 of 2020. I1 of 2021. The advocate for respondent ಹಾಕಿರೋದು. ಫೈಲ್ ಕೊಟ್ಟಲ್ಲ ಅಂದ್ರೆ ಐಎಗಳದೇ ಒಂದು ಬೇರೆ ಫೈಲ್ ಇಟ್ಟಿರ್ತಾರೆ. ಇಲ್ಲಿ ಏನಿಲ್ಲ, ಎಲ್ಲಾನು ಒಟ್ಟಿಗೆ and you will locate them easily. IA 1 of 2021. So kindly please to allow the petitioner to withdraw and disperse the amount deposited in pursuance of the order passed by this court. That is it pending or?
Amount has not been released, whereas payment has been made to the respondents. Therefore, the judge had tried one more application.
There is office objection on this application. 2021 pending ಇದೆ.
Because I tried subsequently I tried one more application of 25 to 2022.
ಇದನ್ನ ಡಿಸ್ಪೋಸ್ ಮಾಡಿಸ್ಕೋಬೇಕಿತ್ತು. Why kept that matter? Now whether you are pressing this application or not, IA 1 of 2021. If you are pressing, you have to complete. IA 2 of 2021 is filed by you. Respondents Council has filed it. K. Srinivas. So there is no office objection on your application. Okay. Really? IA 1 of 2021. At request serial number 12.11. At request finally 4 weeks time is granted to do the needful, telling which IA 1 of 2021 shall stand dismissed. Based on the same place 24. ಅದಕ್ಕೆ ಬರ್ಲಿ ಬಿಡಿ ಎಲ್ಲ. No, they are reinstated. They are not reinstated.
Last one salary at the rate of 4,400, which is not.
Let us decide all the matters together because there are so many matters clubbed together. This 12.12 only any office objection is it is same listing answer. Yes, date is 24 file. 24 file. ಇಲ್ಲ ಮಾಡೋದಿಲ್ಲ ಈಗ ಇಷ್ಟೊಂದು. How they become similar? Orders were on different dates. It is passed. ಇದು ಒಂದೇ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಅದು ಏನಿದೆ ಅಂತ ಚೆಕ್ ಮಾಡೋಣ ಅದನ್ನ. Because that's very confusing.
Millards, it's a Provident Fund matter.
Appearing for respondent.
Yes, sir.
Yeah, Millards, this is a Provident Fund matter where your Lordship has granted interim stay for recovery of certain amount as contribution according to the PF department. Now, Millards, the other side has filed an application for vacating of the interim order. Millards, I do not know what their arguments would be for me to counter.
So it was the order was passed on hearing both of you.
How though?
Yes, Learned Counsel for the respondent.
I am appearing on behalf of respondent. Today, respondent's counsel, Srimati Nalini Venkatesh, is gone for medical checkup. Kindly have it on 11th, your lordships.
After vacation, ಆಗಿದ್ರೆ. See, it was the order was passed on hearing both sides.
I was told that there are some chances of settlement. So it may be taken up after June 3rd because she is not in station during vacation.
As requested by response counsel, list after 4 weeks.
Interim order may be extended.
Earlier is extended to next hearing. Yes.
Much obliged.
Interim order may be extended, Millards.
Extended.
Much obliged.
Yes. Who are the respondent here?
Respondent, I am representing
Yes.
counsel for respondent.
Yes.
Serial number 14, my lord.
Yes, serial number 14.
Yes, no, I am appearing for respondent's counsel.
Yes.
Ananda. The matter, all these employees have taken rupees 14 lakhs of rupees and settled their cases. After 3 years, they are filing a writ petition challenging the settlement. This honorable court by division bench, Supreme Court, all the courts have held, when there is a settlement, you can't come to challenge the termination or seek a reference. They got a reference also. That has been stayed by this court. Kindly see, my lord, para 3 and 4 of my objection statement to the IA.
Now, what is the order challenge here? Now,
Again, they want a direction to the court to reinstate them.
sure, it call for the records in section number so and so.
They have taken all 14 lakhs of rupees each. 263 employees.
And passing the order dated 1/10/2016 and 8/2/2017 by fifth respondent. Connected. What is that first prayer in your petition? All the records of section number so and so.
Not.
Passing the order dated on the then issue writ of certiorari. Quashing the memorandum of settlement. When this
settlement was implemented
2017.
2017 it was implemented. All of them have taken the monies.
They filed it in 2021.
How do? Your Lordship may kindly see para annexure J.
Right. 1 second. First, who has filed application? Here, what are the applications you have filed? One of 2000. Reinstate the petitions with continuity of service and back wages till disposal. This is the interim order. IA2 of 2022.
I am not able to hear the counsel for the petitioner. I am not able.
To stay the memorandum of settlement. Yes. Mike, it will in your case. No, it is her application. It is her application. All right, let her argue first.
Oh, very well, my lord. Very well.
Yes.
I am not able to hear the petitioner's counsel.
She has not yet commenced. Commence Madila. Yes. Can you hear?
The petitioner, the state first IA2 for 2022. Petitioner, pray this honorable court, please to stay the operation of the memorandum settlement and section 20 sub class 3, read with section 18 sub class 3 of English Dispute Act 1947, read with rule 59 sub class 3 of the Judicial Dispute, Karnataka Rules 1957, dated 8 February 2017. Considered by the Deputy Labour Commissioner, Region 2, Bangalore, the petitioner number DHCB 2, IDACR 125, 2016 and 17, of this petition. Reason is for staying this operation. This is the memorandum of settlement settled these about 263 employees. Illegally.
Lord, may kindly ask the counsel to speak in the mic. I am not able to hear anything.
She is speaking. Munde sometimes it appears there is some. ನಿಮ್ಮ ಕಂಫರ್ಟ್ ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಾದ್ರೂ ಪ್ರಾಬ್ಲಮ್ ಇದ್ರೆ Yes. Okay.
Proceed. The agreed by the memorandum of settlement dated under section 12 subclass 3, rating so and so 18 subclass 3. And the petitioner and other employees illegally and forcibly made them enter it and sign the settlement dated into 2007. It was not an amicable settlement between the employer and employer. It was an forcibly and illegally and irregularly, because the documents and forthcoming that the documents going to be proved. So that's all illegal settlement. So the facts of the case, the industry illegally disseminated the workman of the respondent, the management regarding illegal and disengagement layoff the payment of unequal wages for equal value for the illegal and wrongful disengagement of 263 workers with effect from 16/8/2015. The petitioner were working with the board Advocate branch, Bangalore. All 263 workers raised the industry dispute before the Deputy Labour Commissioner in DLCB to DACR 98/2015 and 16. So when they have been disengaged, all the 263 employees without giving the prior notice, EKAEK 16/8/2015. So immediately all the employees then raised an industrial dispute. So under the dispute number 98/2015. When the same is pending, there are several proceedings were took place on 31/2015 to 29/9/2016, whereas failed to reach the conclusion. The Honorable Deputy Commissioner, Region 2, has referred the matter for Labour Court for adjudication on 1/10/2016. So to that effect, I filed the failure report. Failure report as filed by the petitioners. So it has been stated the reason for why the adjudicated that dispute has been failed. Why the matter was settled there itself. The reasons have been quoted by the Deputy Labour Commissioner as per annexure A large. What it states, may kindly public read this. Annexure B. Annexure B, page 71 of the main petition.
Yes.
Yes, Roshi. That is dated, failure report dated 1/10/2016. So, Vishya, ಆಡಳಿತ ವರ್ಗದವರಾದ ವಾಶ್ ಲಿಮಿಟೆಡ್ ಆಡುವಾಡಿ ಯೂನಿಟ್ ಹೊಸೂರು ರಸ್ತೆ ಬ್ಯಾಂಗ್ಳೂರು ಇವರು ತಮ್ಮ ಸಂಸ್ಥೆಯ 263 ಜನ ಹಂಗಾಮಿ ಕಾರ್ಮಿಕರನ್ನು ದಿನಾಂಕ 14/8/2015 ಕೆಲಸದಿಂದ ವಜಾಗೊಳಿಸಿರುವ ಬಗ್ಗೆ ಕಾರ್ಮಿಕ ವರ್ಗದವರಾದ ಅಧ್ಯಕ್ಷರು ವಾಶ್ ಹಂಗಾಮಿ ಕಾರ್ಮಿಕರ ಹೋರಾಟ ಸಮಿತಿ ಬೆಂಗಳೂರು ಇವರು ಸಲ್ಲಿಸಿರುವ
ನೀವು 71 ಅಲ್ಲಿ ಓದ್ತಿರೋದಿಲ್ಲ on page this is part of annexure. Yes, page number 71 is part of annexure. Already can submit in a nutshell. So according to you, the settlement was the outcome of coercion or undue influence.
Yes, because the reason why it has been coercion, undue influence, and forcible and illegal settlement, the reasons have been here, Worship. And
so you filed the petition in 2021 and filed the stay application in 2022.
No, Worship, it has been unless served the copies to the respondent. So will be heard the matter with the appearance of the respondent. So then only the matter will be. Main petition is also contained the stay application. So allow me please interim application for direction. So these applications are also having filed by the petitioner.
So as per the memorandum of settlement, some of the employees were Terminated.
263 employees, not some of it, all batch, the batch, whole batch itself. So, any TW, the new temporary workman, there is a batch. It contains 263 members. They have been disengaged. The word they have used by the management, it is called as a disengagement. So, without assigning any reasons, 14, without data, because on 15/8/2016, it was an independent day. After the Independence Day is completed, the next day it was given to the independence to all employees. And here they have been continuously work for 8 to 10 years as in the permanent nature without any interruption till illegal termination. That is here means disengagement. And
so your prayer in the repetition as well as in the applications is the same.
Regarding this, because my direction is to reinstate the employees till disposal of these cases.
Yes, sir. Yes, counsel for the respondent.
Lord, I appear for the counsel for the respondent. Kindly see under the settlement, annexure J, each of the employees who were separated from the company services were paid 14 lakhs of rupees each. The settlement dated 2017.
Page number?
Annexure J. The objection statement now we have filed.
There is a recital in that about payment.
Yes, they have taken all of them.
They have that about one-time financial settlement package amount of rupees 14 lakhs.
Yes.
Subject to deduction of taxes.
One of them. I have given the details.
We have made. They have been forcibly de-submitted.
Supreme Court says unless they deposit the money, they can't contest the case.
No, they have received it.
Sorry, my lord.
They have received the amount.
You have all of them. Yes. 2017 itself.
Yes.
I filed the statement which shows they received the payment. They don't report they are not. They have received the payment. Kindly
the amount in 2017.
Page number.
In 2022, 21. And after 1 year, they have filed the application.
Page number 26. R2 in the. All of them have taken money.
Of their statement of objection.
How? Each one of them have received. I filed page number 52.
Statement of objection. Have you produced anything along with that statement of objection? Or in a page 22 to statement of objection at the head?
Page number 26, sir.
26, sir?
Objection statement.
Objection statement. You represent respondent number 1 to 4, no?
How?
Page 26, the page 8.
No. Below the objection statement to the repetition.
Repetition is there. Objection statement filed by.
Objection statement is filed by Bosch Limited.
The objection statement filed on behalf of respondent number 1 and 18.
On 18/12/2021.
22.
18/12/2021 we have filed the objection statement.
Right. We got it.
Otherly, page number 26 R2, your lordship may see. I filed the details and signature of all the persons who have taken money.
Yes.
14 lakhs each they have taken and settled their cases.
Number 192 of 2000.
In the record of the settlement
22.
Dated February 2017. Signed before the conciliation officer.
Yes.
That settlement, your lordship, can individually signed by each employee. Your lordship will find it in Annexure J.
Yes.
Annexure J is the settlement. dated 28th February 2017.
Stated. The petitioners.
It is signed by each and every employee.
All right, the above petition is filed. Challenge for quashing the memorandum of settlement entered into between the petitioners and the respondents on 8/2/2017. And okay, next time. Sorry, okay. In the as a result of in implementation of the same memorandum of settlement, the petitioners were disengaged from the work on payment of some monetary benefits. After 5 years. 4 years. Petition is filed. The above applications are filed. The petitioners have filed the above applications seeking the reinstatement, continuity of services and back wages, and stay of the memorandum of the memorandum of settlement is sought to be quashed on the ground of fraud and coercion. As already pointed out, the petition is filed after 5 years of such settlement. The applications are filed 1 year after filing of the petition. ನೀವೇನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತೀರಾ 14 lakhs ತಗೊಂಡಿದ್ದನ್ನ
14 lakhs because it was given forcibly.
ಅದು ಆಯ್ತು
We have been interested. We have been interested. You have been asking for reinstatement.
Admittedly, each of the workmen has received 14 lakhs. 14 lakhs monetary benefits.
So we'll repeat the same logic. So we don't want that amount. We need reinstatement.
Is not deposited for this court also. Under the circumstances, there are no grounds to grant the applications. The applications rejected. Okay. Applications rejected. Application rejected.
Much obliged.
IA1 and 2 both. Connect. ಎಲ್ಲಾನು ಅದು ಸೇಮ್ ಇದೆ ಅಂದ್ರೆ ನಾವು ಒಂದೇ ಹೋಗಿ 1 of 2000 ಎಷ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ 14 ಈಗ 14.1 ಅಲ್ಲಿ the other matter ಎರಡರಲ್ಲೂ ಅಪ್ಲಿಕೇಶನ್ ಸೇಮ್ ಮೇನ್ ಮ್ಯಾಟರ್ ಮಾಡಿ ಮುಗಿಸ್ಕೊಳ್ಳಿ
ಕ್ಯಾಚ್ ಒಬ್ಬೊಬ್ರು
ಎಲ್ಲ ಅಂದ್ರೆ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಎರಡು ಕೇಸಲ್ಲಿ IA1 and 2 of 2022 ಇದ್ರೆ ಥರ್ಡ್ ಮ್ಯಾಟರ್ ಎರಡು ಎಲ್ಲ ಹಾಗೆ as requested list on certification 25 yes.
Other orders number 15 Ramohan A BS Mac respondent
but appear for respondents in all these matters.
Further orders. Further orders. What are the further orders?
ಇದರಲ್ಲಿ
ಯಾಕೆ ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ಅಂತ ಬರುತ್ತೆ
ಏನೋ ಆತರ ಅದು ಅದೇನಾಗಿದೆ ಅಂದ್ರೆ ಅದರಲ್ಲಿ ತಾವು WP-90
right why it has come for further orders for admission
admission ಗೆ ಮೂವ್ ಮಾಡಿ ಯಾಕೆಂದ್ರೆ
so records are colorful what is this connected matter WP number 15.3 dismissal of WP wide order dated 25/8/2021
ಅದೇ ದಯವಿಟ್ಟು may I request you lordship to kindly statement of objection 18,945 ತಾವು ಇಸ್ಕೊಳ್ಳಿ ದಯವಿಟ್ಟು. 18,945
ಇನ್ನೊಂದಾಗಿ ಮಾಡಿದ್ರೆ
ಅದರೊಳಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ತಾವು ದಯವಿಟ್ಟು ನೋಡಿ.
ಡಿಸ್ಮಿಸಲ್ ಮಾಡಿಲ್ಲ, ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಅಂತ ರಿಲೀಸ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಇದೆ.
ಅಲ್ಲ ಈಗ ನಾನು
Order is passed on 25/8/2021. Annexure to be shown before the competent authority. Annexure D, original photos to be affixed and marked as series and to be filed properly. Really, there are some office objection 15.3.
ನನಗೆ ಒಂದು ನಿಮಿಷ ಇದು ಕೊಟ್ಟರೆ ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ. ಅಲ್ಲ ಅವ್ರು ಮಾಡ್ಲಿ
ಕಂಪ್ಲೈನ್ಸ್ ಅವ್ರದ್ದು ಕೇಳ್ಬೇಕಲ್ಲ, ಒಂದ್ ಮ್ಯಾಟರ್ ಕಂಪ್ಲೈನ್ಸ್ ಆಗಿಲ್ಲ.
ಅಲ್ಲ ವಿಷಯ ಏನು ಅಂತ ಹೇಳ್ತೀನಿ, ತಾವು ಯಾವಾಗ ಏನ್ ಬೇಕಾದ್ರೂ ಮಾಡ್ಬೋದು. ನಾನು ಒಂದ್ ನಿಮಿಷದಿಂದ ಟೈಮ್ ತಗೊಳ್ಳೋದ. WP 18,945 ನಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ ನಾನು. 18,945 ನಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ. ಆಲ್ ದೀಸ್ ರಿಟ್ ಪಿಟಿಷನ್ಸ್ ಒಳಗೆ ಒಂದು ಆರ್ಡರ್ ಆಗಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. WP 18,945. I'm sorry, man.
Yes,
WP 18,945 ನೊಳಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ. ತಾವು ಒಂದು ನಿಮಿಷ ಫೈಲ್ ಇಸ್ಕೊಂಡ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. 18,945
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿದ್ರಿ?
ಹೇಳ್ತೀನಿ. ಏನಾಗಿದೆ ಅಂದ್ರೆ ಆಯ್ತು, ಎಲ್ಲ 8 ರಿಟ್ ಪಿಟಿಷನ್ ಒಳಗೂ ಲೇಬರ್ ಕೋರ್ಟ್ ಮಾಡಿರೋ ಆರ್ಡರ್ಸ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಫಸ್ಟ್ ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್ ತಮ್ಮ ಹಿಂದಿನ ಸಾಹೇಬರ ಮುಂದೆ ಬಂದಿರುವಾಗ ಆನ್ ಮೆರಿಟ್ಸ್ ರಿಟ್ ಪಿಟಿಷನ್ ಇಸ್ ಡಿಸ್ಮಿಸ್ಡ್. ಸೊ ಇದು ಯಾವ್ದು ಸರ್ವೈವ್ ಆಗಲ್ಲ. ಐಡೆಂಟಿಕಲ್ ಇಶ್ಯೂ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ has already held that the writ petition is dismissed. ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಅಷ್ಟೇ.
ಆಯ್ತು, ಅಡ್ಮಿಷನ್ ಮೇಲ್ ಮಾಡುವಾಗ ಮಾಡಬಹುದು ಅದನ್ನ. if the petition is not maintainable,
ನನಗೆ ತೊಂದರೆ ಇಲ್ಲ, ಬಟ್ ನಾನು ಹೇಳಿದೆ ಅದಕ್ಕೆ ತಾವು ಹತ್ರ ಡೇಟ್ ಕೊಟ್ಟು
now it has come up for admission only. Preliminary hearing B group. We have filed the statement of objection also. ಅದೇನೋ
ಹಾಕಿದ್ದೀನಿ ಕರೆಕ್ಟ್
ಮಾಡಿ ಅನ್ನೋದಕ್ಕೆ ಹಾಗಾಗಿರ್ಲಿಲ್ಲ ಅಷ್ಟೇ. ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ಅಂತ ಬಂದಿದೆ. ಯಾವ್ದು ಬೇರೆ ಪ್ರೊಡ್ಯೂಸ್ ದಟ್ ಕಾಪಿ?
18,945 18,945 ನಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ಜೊತೆಗೆ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ. ಲರ್ನೆಡ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಇದೇ ಇಶ್ಯೂ ಮೇಲೆ ಡಿಸೈಡ್ ಆಗಿರೋದು.
ಈಗ ಅವ್ರ ಪಿಟಿಷನ್ಸ್ ಅಲ್ವಾ, ಅವ್ರ ಅದು ತಗೊಳ್ಳೋಣ. ಅವ್ರ ಪಿಟಿಷನ್ ಎಲ್ಲ ಅದನ್ನ ಹಿಯರ್ ಮಾಡೋಣ, ದೆನ್ ಯು ಕ್ಯಾನ್ ಸಬ್ಮಿಟ್.
ಅಲ್ಲ ಅದಕ್ಕೆ ತಗೋಬಹುದು, ನನಗೇನಿಲ್ಲ. ನಾನು ಹೇಳಿದ್ದು coordinate bench has already dismissed one writ petition. Same issue.
Mr. Nayak, this matter has come up for admission.
Yes.
Now who has to argue for admission?
Let him argue. I will listen to. I'm sorry.
Yes. Leading to passing of the order dated 31/10/2019, passed by the Second National Labour Court, Bangalore, in serial application number so and so. Washing the order dated 31/10/2019. Yes, what order you have challenged here? Dismissal of your serial application.
Serial.
Yes.
It's a point of law that
Yes.
when disputes are pending before the court on any of if the management wants to terminate the workman, they have to seek permission from the court. Pay 1 month salary, file the application, and then get approval for termination. This is a situation where approval is sought post dismissal. This is where I respect myself. I am not seeking approval of termination. Post termination, I am not terminating. All the workmen are on the job, but they are currently on strike, as observed by this one. No, my question. By any chance.
So dismissal was only on the ground that you filed application post dismissal.
Post dismissal. My point is.
Where do we find that in the order?
The whole order is only that.
Only a reasoning.
The entire order speaks only that. That there is no termination order. Therefore, this application is not.
No termination order.
Court's observation.
The whole entire argument of the court is that if you don't have determination on order,
And it shows from the order.
I show.
Para 18 as rightly argued by the Honorable Counsel for respondent. So far, applicant management has not dismissed the respondent nor passed any discharge order or any termination order against the respondent. Therefore, prayer A is sought to permit the management to dismiss the respondent. But no misconduct of workman is proved in the inquiry conducted, if any, as per the established principles of law. The alleged misconduct of workman, if any, cannot be proved before this court directly without initiating domestic inquiry. As rightly argued by the Honorable Counsel for the applicant, prayer of the applicant in his application to lift the ban imposed in the statute of section 33(2)(b) is nothing but ridiculous prayer. As rightly argued by the Honorable Counsel for the respondent, this court has no jurisdiction. So, without passing the, not posting, trial court says that without passing the order, you are seeking, without holding inquiry.
Exactly my case. I am not seeking approval post-termination. I am seeking approval pre-termination. In other words, after getting the approval from the court, I should terminate the person for this reason.
They have given two reasonings. One is that you have not conducted any inquiry without.
All those things should come only when I get an approval from the court. Charge sheets have been already issued. The inquiry will be conducted only when I get the.
So you have not passed orders. You have not passed orders in the inquiry. Industrial disputes.
I have not conducted the inquiry.
You are seeking. You are. Read section 33. Yes.
No, there is no dispute with regard to the 33(2)(b) at all.
No. You say that you have pending inquiry. You are seeking dismissal. Is that the?
Pending inquiry.
Is it the purport of section 33? Within 33 ಓದಿ ನೋಡೋಣ ಅದು ಹಾಗೆ ಹೇಳುತ್ತಾ ಅಂತ.
33 is very clear. You must have a dismissal order in your hand before seeking approval.
During the pendency of any conciliation proceeding for the conciliation, during the pendency of any such proceedings in respect of an industry, the employer may, in accordance with the standing orders, applicable such dispute. Standing orders Yes.
There are several disputes pending. Between the workers and the landlord before various courts. Labor Commission. Now, if I have to terminate the workman at this stage, 33(2)(b) comes into picture. Because if I terminate without taking permission from the and if the termination order is not upheld or not sanctioned, the workman is due to be in service as a pay the entire.
But it may during the pendency of any such proceedings means any ID, industrial dispute.
Any ID or any dispute from any dispute. Yes, right. I have received permission. That is what I did.
Employer may anta heluttalla, he can terminate, but only after terminating you have to seek approval.
After termination, I can seek approval. If my approval is not granted, what is the consequence? The workman is supposed to be.
Correct. So you may have to challenge that if there is any illegality in that. Yes.
That comes into picture. I have to give the practice. If the business is not approved, this is a matter where I am. I'm interpreting the full bed decision
in a positive manner. Full bench decision also same thing. Before termination, you after termination, you go to court with an application, pay one salary, and seek the approval from the appropriate court. If the approval is granted, then of course your termination is valid. The approval is not granted, your termination is not valid. I am going one step. Saying, why should I suffer the consequence of paying the full back wages to the workman, considering him as in service, if my application to seek permission to terminate is null.
Right, you are presupposing something. You are presupposing something. You are presupposing something. See, the section says that you may alter the condition. Section 33 2b, which you read, itself says that you may alter the service conditions, but after altering, you have to seek the approval. You have to seek the seal of the court. Right. Yes. So you admit that in all these cases, the disciplinary inquiry is pending.
I have not initiated any inquiry.
But once you said you have issued charge sheets.
I have issued charge sheets.
Charge sheet issue ಮಾಡಿದ್ರೆ ಡಿ ಶುರು ಆಯ್ತಲ್ಲ.
I have to issue, but then I have to call for service. Only then you will start. But then that is not the point here. I can do all those things. Because the disputes were pending, by way of abundant caution, I have felt that it is seeking approval from the court. Please do not allow me to suffer the agony of paying the workmen if my termination or termination approval.
So, how many applications you had filed? Huh? 8.
He has come and taken voluntary terms.
No, he was submitting that in similar matter. This court has held held against you. He is saying that one of these employees, he challenged the very your challenge to this order is held against you.
No, one dismissed.
Where is then? It is on merits.
I have not. I did not hide anything from your order. One expedition is dismissed.
Where is that order?
All other expeditions notices have been ordered.
Where is that order?
I think
whether you have produced or he has produced.
I have produced.
Okay.
18,945 ಅಲ್ಲಿ ಹಾಕಿದೆ 18,945 ಹಾಕಿದೆ
18,943
18,945
ಆಯ್ತು ಅವರು ಹಾಕಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅವ್ರು ಹಾಕಿದ್ರೆ ನೋಡೋಣ ಹಿಯರ್ ಇಟ್ ಇಸ್ ಏನಾದ್ರು ರಿಪಿಟಿಷನ್ ನಂಬರ್
10690
ಆ ಕೇಸ್ ನಂಬರ್ ಯಾವ್ದದು 400
ಕೇಸ್ ನಂಬರ್ 10690 ಅದು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಮೋಸ್ಟ್ಲಿ ಇಲ್ಲ ಇವಾಗ
ಡಿಡಿ ಫೈಲ್ ಇದೆ ಮೇಡಂ ಡಿಡಿ ಫೈಲ್
18945 ನಲ್ಲಿ ನಾನು ಹಾಕಿದ್ದೆ
This option is considered as the same. There is no termination order. Since there is no termination order, the application is not done, not being done. But this is logical.
Yes. So you have already suffered an order in a similar matter.
Okay.
Yes. Right now,
I am not on that at all. I am.
correct. We got you. Your submission is that even before initiation of the inquiry, you can file application under section 33(2)(2). Right.
Because the disputes are pending.
Aito. Matte next day. Next. What is your next ground?
Next round is assuming if I terminate it as it is without taking approval, and if the
Well, that you have already argued.
termination is not approved by the court, I have to suffer.
Correct. That you have already argued. No.
To escape from suffering a massive loss.
Law provides for that. Yes.
That is all the solution. Only that is a major point of
Yes.
law that I am canvassing for you.
Yes.
Decision.
What is that full bench decision?
Information. AR 2002 AR SC 49. Jaipur Jilla.
The same thing we are referred in this. Jaipur Jilla Sahakari Bhumi Vikas
Refer agide.
Yeah,
It is referred.
referred. Again, whether there even before the passing of the order, approval application was filed. In that case, even before dismissal order or termination order, the petition was filed before the court. And then how that applies to obedience?
That is a full bench decision. I am seeking an amendment to the full bench decision. I can also go before terminating.
You are seeking an amendment to the full court judgment.
I am just supporting the full court decision. I am not at all opposing the full court decision. In keeping with the spirit of the full court decision, I am submitting. If I can go after termination, please permit me to go before termination also. That is the only point of law.
Yes, ನಾಯಕ್ ಅವರೇ ಈಗ ಹೇಳಿ ನಿಮ್ ಟರ್ನ್ ಇದೆ.
Yes, ma'am. My lord, for filing an application either under 33(1) or 33(2)(b, either 33(1) or 33(2)(b, there must be an industrial dispute pending where he is a concerned workman. Two things. Now, Lordship may kindly turn to the order passed by the labor court. One paragraph ಇವ್ರು ಏನು ಅನ್ನೋದು ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. ಅಪ್ರೂವಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಡಿಸ್ಪ್ಯೂಟ್ ಪೆಂಡಿಂಗ್ ಇರಬೇಕು.
No industrial dispute was pending.
ಅಲ್ಲ ಅದಕ್ಕೆ ಪ್ಯಾರಾ 27 ಅಲ್ಲ ಪ್ಯಾರಾ 27 ಆಫ್ ದಿ ಆರ್ಡರ್ ತಾವು ನೋಡಿ ಇದ್ರೊಳಗೆ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ 27 ಅದು ಪೇಜ್ 28 ಅಂತ ತೋರಿಸುತ್ತೆ ನಂದ್ರಲ್ಲಿ. ಇಟ್ ಮಸ್ಟ್ ಬಿ ಕರೆಕ್ಟ್.
Yes, para 27.
As rightly argued, your lordship gets it?
Yes.
As rightly argued by learned counsel for respondent, that is the workman, in order to maintain serial application, there must be pendency of the dispute before this court. Admittedly, no dispute is pending as on the date of filing this application. As rightly argued by the...
No other industrial dispute is pending? Between the...
ಒಂದು dispute pending ಇದ್ದು ಅದರೊಳಗೆ ನಾನು ಕನ್ಸರ್ನ್ಡ್ ವರ್ಕ್ಮನ್ ಆದ್ರೆ 33(1) ಇಲ್ಲ 33(2) ಅನ್ನೋದನ್ನ ಡಿಸೈಡ್ ಮಾಡಿ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ. ಡಿಸ್ಪ್ಯೂಟೇ ಪೆಂಡಿಂಗ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅಪ್ರೂವಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದಕ್ಕೆ ಅವಕಾಶವೇ ಇಲ್ಲ. ತಾವು ದಯವಿಟ್ಟು 33(1) ಮತ್ತೆ ಒಂದ್ಸಲ ಓದಕ್ ಪರ್ಮಿಷನ್ ಕೊಡಿ ನನಗೆ. ಐಡಿಯಾ ಆಗ್ತದೆ ಮತ್ತೆ ಒಂದಿಲ್ಲ. ಎಸ್ 33(1) ನೋಡಿ ತಾವು ದಯವಿಟ್ಟು.
ಗೊತ್ತಿದೆ ಸರ್, ಓದಿದೀವಿ ಅದೆಲ್ಲ. ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಕಾಪಿ ಇದೆ, ಅಪ್ಲಿಕೇಶನ್ ಕಾಪಿ
ಹಾಕಿಲ್ಲ. ಬಟ್ ಇಲ್ಲ ಅವ್ರ ಅದನ್ನ ಹೇಳೋದೇ ಅಲ್ಲ. ಯಾವ ಈಗ ಅವ್ರ ಲೋಯರ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಬಂದಿರೋ ಅದಕ್ಕೋಸ್ಕರ
You are right. 33 invoke ಮಾಡಬೇಕು ಅಂದ್ರೆ there should be ID should be pending.
No dispute was pending.
ಕೊಡಿ TCRs ಬಂದಿದೆ ಅಂತ.
ಅದಕ್ಕೆ TCR ನೋಡಿ ತಾವು ದಯವಿಟ್ಟು ಅದ್ರೊಳಗೆ. ಅದಕ್ಕೆ ಒಂದ್ ನಿಮಿಷ, ನಮ್ದು ಪ್ರೊಸೀಜರ್ ಹೇಗೆ ಅಂತ ಲೇಬರ್ ಕೋರ್ಟ್ ನೊಳಗೆ ಅಪ್ರೂವಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಸೀರಿಯಲ್ ಅಪ್ಲಿಕೇಶನ್ ನಂಬರ್ ಡ್ಯಾಶ್ ಇನ್ ID ನಂಬರ್ ಅಂತ ಹಾಕ್ತೀವಿ ನಾವು. ಯಾವ ID ನೊಳಗೆ ಹಾಕಿದ್ದಾರೆ ಅಂತ ನೋಡಿ ತಾವು ಗಮನಿಸಿ ದಯವಿಟ್ಟು. Our approval application.
The body of their application they should say.
ಕೇಳ್ಬೇಕಲ್ಲ ಅದ್ರೊಳಗೆ. ಅದು 33C2 ಅಂತ ರಾಂಗ್ ಪ್ರಾವಿಷನ್ ಹಾಕಿದ್ದಾರೆ, ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಎಲ್ಲಾ ತಪ್ಪು ಅದರೊಳಗೆ, ಬಟ್ ಐಡಿನ ಪೆಂಡಿಂಗ್ ಇರಲಿಲ್ಲ ಅಲ್ಲಿ. ದಟ್ ಇಸ್ ಫ್ಯಾಕ್ಟ್ ಫೈಂಡಿಂಗ್. ಫೋರ್ ಕ್ವಶನ್ ಆಫ್ ಅಪ್ರೂವಲ್ ಅಪ್ಲಿಕೇಶನ್ ಮೇಂಟೈನ್ ಆಗಲ್ಲ ಇದ್ರೊಳಗೆ. ಆಗ್ಲೇ 9 ಕೇಸ್ನಲ್ಲಿ 1 ಡಿಸ್ಮಿಸ್ ಆಗೋಗಿದೆ.
ಪ್ಯಾರಾ 10 ಅಲ್ಲಿ ಏನೋ ಹೇಳ್ತಾರಲ್ಲ, ದ ಸೇಟ್ ಡಿಸ್ಪ್ಯೂಟ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ.
ಅವತ್ತು ಹಾಕುವಾಗ ಯಾವ್ದು ಪೆಂಡಿಂಗ್ ಇರ್ಲಿಲ್ಲ. ತೋರಿಸ್ಲಿ ಅವ್ರು ಯಾವ್ದು ಪೆಂಡಿಂಗ್ ಇತ್ತು ಅಂತ. ಐಡಿ ನಂಬರು, ಐಡಿ ಏನಿತ್ತು, ಪಾಯಿಂಟ್ಸ್ ಆಫ್ ಡಿಸ್ಪ್ಯೂಟ್ ಏನಿತ್ತು ಎಲ್ಲ ಬೇಕಲ್ಲ, ಇರ್ಲಿಲ್ಲ.
So no, even in the evidence they are not produced any document to show that ID is
ಮಾಡಿಲ್ಲ. ಅದೆಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದು ಸರ್.
ಯಾವ್ದ್ರಿ ಅದು? ಯಾವ್ದು ಇಂಡಸ್ಟ್ರಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಪೆಂಡಿಂಗ್ ಇರಬೇಕು. ಯಾವ್ದು ಇಂಡಸ್ಟ್ರಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಪೆಂಡಿಂಗ್ ಇತ್ತು? ಟು ಇನ್ವೋಕ್ ಸೆಕ್ಷನ್ 33. ಅದೇ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲ, ಅದೇನೋ KA.
That is a dispute before the Labour Commission, but it also considered a dispute, my lord.
ಎಲ್ಲಿ ಅದ್ರ ಪ್ರೂಫ್ ಎಲ್ಲಿದೆ?
AAB is not disputed. AAB petition number I have given. Next one, para number 12. Again, KAB, one more dispute pending. Then para 30, one more dispute pending. And reference 2/18 is still pending. Reference 173/14.
Where is the mention of that in the application?
Application, what is the application?
ಅಲ್ಲ, ಯಾವ್ದೋ ರೆಫರೆನ್ಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳಿ. Where have you mentioned? Not in the application. All right. Evidence produce ಮಾಡಿದ್ರಲ್ಲಿ copy of issued applicant. ಆಯ್ತು, ನಿಮಗೆ just we sought a clarification. Where you have stated in a statement of objection that no industrial dispute is pending? Para 10. Nayak,
yes.
In a statement of objection, no industrial dispute is pending. Where have you controverted that statement?
ನಾವು ಹೇಳಿದ್ದೀವಿ.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ?
ನಾನು ಹೇಳ್ತೀನಿ, ಬರ್ತೀನಿ. I'll come to that. Lordship may kindly turn to para 14 onwards.
Para 14.
ಹೌದು, ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಅಲ್ಲೇ
ನಿಮ್ಮ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ತೋರಿಸಿ ಅಂತ ಹೇಳಿದ್ವಿ.
ಅಲ್ಲ, ನಾನು ಅದು ಸಪರೇಟ್ ಆಗಿ ಹಾಕಿಲ್ಲ, ನನ್ನ ಹತ್ರ ಇದೆ, ಅದು ನಾನು ಕೊಡ್ಲಿಲ್ಲ ಅಷ್ಟೇ. ಅಲ್ಲೇ ಕೋರ್ಟ್ ಮುಂದೆ ಇದೆ.
TCS ಬಂದಿದೆ, correct. TCS when we are holding your statement of objection, point out where you have said that.
That is true. My statement of objection is reproduced in that impugned order.
ನಿಮ್ಮ ಹತ್ರ ಇದೆ ಅಂತ ಹೇಳ್ತೀರಾ? ಕಾಪಿನ?
ಕಾಪಿ ಇಲ್ಲ, ನನ್ನ ಹತ್ರ ಕಾಪಿ ಇಲ್ಲ. ಅದು ಬರೀ ರಿಟ್ ಪಿಟಿಷನ್ ಒಳಗೆ ಅವ್ರು ಹಾಕ್ಲಿಲ್ಲ, ನನ್ನ ಹತ್ರನೂ ಇಲ್ಲ. ಯಾಕಂದ್ರೆ ಬೇರೆ ಕೇಸ್ ನಡೀತಾ ಇದೆ, ಅಲ್ಲಿ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ನಮ್ಮ. ಸಾರಿ, ಬಟ್ ಇಲ್ಲೋ ಹೇಳ್ತಾರೆ ನೋಡಿ.
ಹಾಗೆ ಹೇಳಿ. ಎಸ್, ಪ್ಯಾರಾ
14 onwards.
14 onwards. Yes.
Para 15.
ನೀವು ನಾಯಕ, ನೀವು ನಿಮ್ಮ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ ಮೈಕ್ ನ?
In misconduct connected with the dispute, the applicant has not discharged nor punished, for which employer with express likely to be sought before the he further argued that admittedly the applicant management has not passed any dismissal order, discharge order, termination order against
dispute ಬಗ್ಗೆ ಅಷ್ಟೇ ಕೇಳಿದ್ವಿ.
ಅಲ್ಲ, ಮುಂದೆ ಬರುತ್ತೆ.
ಬಂತು, ನಾವು ಓದಿದ್ವಿ. ಹಿಂದಿನ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಇದೆ, para 14 ಅಲ್ಲಿ. No other dispute pertains to the applicant and respondent is pending. That is in para 14. Yes.
ಅಲ್ಲ, ಬರ್ತೀನಿ. para 16 ಒಳಗೆ ನೋಡಿ, 5ನೇ ಲೈನ್ 6ನೇ ಲೈನ್ ಒಳಗೆ ಫರ್ದರ್ ಈ ರೆಫರ್ ಸೆಕ್ಷನ್ 33 so ಆದ್ಮೇಲೆ no such workman shall be discharged or dismissed unless he has been paid ಆದ್ಮೇಲೆ next sentence. by the employer to the authority before which the proceeding is pending for approval of the action taken. He further argued that no proceeding is pending before this court. ಅದು ಕೌಂಟರ್ ಹೇಳಿದೀವಿ ನಾವಲ್ಲಿ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಮುಂದೆ ಇದು ಮುಂದೆ.
Yes. Yes.
There is no pendency of the dispute where I am the concerned workman.
Yes.
And he finding ನೋಡ್ಬಿಟ್ಟೆ already my lord the coordinate bench has held that the dismissal writ petition is dismissed. And I mean ಇನ್ನೊಂದಾಯ್ತು one development I would like to submit. When this was brought to the notice of this honorable court, ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ ನಾವು ದಯವಿಟ್ಟು ಅಲ್ಲ ನನ್ನ ಪ್ರಕಾರ 10/1/22ಕ್ಕೆ ಒಂದು ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿತ್ತು.
ನಮಗೆ ಕೇಳಿಸ್ತಾ ಇದೆಯಲ್ಲ, ಅವ್ರಿಗೆ ಕೇಳಿಸ್ತಾ ಇಲ್ವಂತೆ.
ಅಲ್ಲ 10/1/22ಕ್ಕೆ ಒಂದ್ಸಲ ಕೇಸ್ ಬಂದಿತ್ತು 10th January. ಅವತ್ತು ರಿಟ್ ಅಪೀಲ್ ಹಾಕ್ತಾ ಇದೀವಿ ಈ ಜಡ್ಮೆಂಟ್ ಮೇಲೆ ಅಂತ ಅವ್ರು ಟೈಮ್ ತಗೊಂಡ್ರು. ನನ್ನ ಪ್ರಕಾರ ಯಾವ ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿಲ್ಲ ಇದ್ರ ಮೇಲೆ. ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಬರೆದಿರೋ ಆರ್ಡರ್ ಮೇಲೆ, ಜಸ್ಟಿಸ್ ನರೇಂದ್ರ ಸಾಹೇಬ್ರು ಬರೆದಿರೋ ಆರ್ಡರ್ ಮೇಲೆ ರಿಟ್ ಅಪೀಲ್ ಹಾಕ್ಲಿಲ್ಲ. 10th January 22ಗೆ ನಾನು ಒಂದು ಕೇಸ್ ನಲ್ಲಿ ಬರ್ಕೊಂಡಿದ್ದೀನಿ. Petitioner pays for time to file writ appeal against the ಅವತ್ತು ಅಡ್ಜರ್ನ್ ಆಯ್ತು.
ಸೊ ಸೀರಿಯಲ್ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಡಿಫರೆಂಟ್ ಅಲ್ವಾ?
ಹೌದು, ಅದು ಒಟ್ಟು 9 ಜನದ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡ್ರು. 9 ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರು. 1 ರಿಟ್ ಪಿಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಐಡೆಂಟಿಕಲ್ ಇಶ್ಯೂ. ಅದರಿಂದ ರಿಟ್ ಪಿಟಿಷನ್ಸ್ ಆರ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್. Coordinate bench has already held this. There is no merit.
On this case, the respondents in all these cases are the employees of the petitioner, heard of the employees of the petitioner. Petitioner find the applications against the respondents under section 33 trial court records kodi 33 1B and 33 C2 seeking permission to dismiss them from service on the ground of misconduct. The particulars of the respondents, particulars of the serial applications corresponding to these petitions are shown in the table below. Respondents contested those applications on the ground that contested those applications that tribunal by the impugned orders, tribunal recording the evidence and hearing the parties by the impugned orders rejected the said application on the ground that the petitions are not in accordance with compliance with section 33 of the Industrial Disputes Act. Section 33C ಅಲ್ಲಿದೆ. ಸಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಸಿ ಬರೋದೇ ಇಲ್ಲ ಇದ್ರೊಳಗೆ. ಏನೋ ಮೇ ಬಿ 33C2 ಬರೋದಿಲ್ಲ ಇದ್ರೊಳಗೆ. ಅದು ನಾವು ನಿನ್ನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು, ಅದು ಬೇರೆ ಕಂಪ್ಯೂಟೇಷನ್ ಮಾನಿಟರಿ ಬೆನಿಫಿಟ್ ಅದು ಅದನ್ನು ಹಾಕಿದ್ದಾರೆ. 33C2 33(1)B ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ.
Thought to dismiss the respondents on the ground of misconduct misconduct and permission for such dismissal. Section 33, 1 and 2, which is sought to be invoked, contemplates the following aspects. Seek such order. Number one, there must an industrial dispute between the petitioner and the respondent shall be pending. Number two, the petitioner should have the employer and employee. An industrial dispute shall be pending before the employer-employee. Number two, the employee must have been dismissed and terminated from service. Terminated from service, including the domestic inquiry or any other ground. So the termination order for approval is mandatory. Number three, the employer should have paid 1 month salary wages along with the dismissal termination order. In the case on hand, first of all, there is in the case on hand, even the pendency of industrial dispute was disputed. No material was produced to establish that. Further, there was no dismissal, there was no termination order for which the approval was contemplated. Number three, 1 month salary, 1 month wages was not paid. In all nine similar applications were filed against 9 workmen.
ಎಲ್ಲ ಒಂದೇ ದಿವಸ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ 1910.
Industrial tribunal rejected all those applications by the similar order.
3110.
It is on 31/10/2018. In addition to these petitions, the petitioner filed one more petition in WP number 10,690 of 2021, into bracket LRES, challenging the rejection of its application on the same grounds. This court, by order dated 23/8/2021, dismissed the said petition. On the ground that the application was not in compliance with Section 33. Jaipur Zilla Francis. Relying on the Jaipur court in Jaipur Zilla Sahakari Bhumi Vikasa Bank Limited versus Shri Ramagopal Sharma and others, year 2002, Supreme Court 643 submits that dismissal or termination order is not a precursor to invoke Section 33. The reference order there, it was not a 33 application order.
At that point, it is very sad. Whether is there a necessity of an application? Approval?
It was not on that point. Here, On the
What
order of,
happens if
on the order of reference made in Jaipur Jilla Sarkari Police also. Question that arise. Oh, reference.
If you do so, you have to enter that is after termination.
No, what were the facts of the case there?
After the case is slightly different. Other termination,
Only there was a dismissal, there was pendency of an industrial dispute. Para 12 of the judgment. Reading of the said judgment shows that in the said case there were said case the industrial dispute was pending. And after passing the order of termination, the employer had approached the court. Under Section 33. Therefore, the said judgment is not applicable to the and the present case. This court does not, since the requirements of Section 33 were not complied, the industrial tribunal was justified in rejecting the application. There are no grounds to interpret. No grounds to interpret the order of the tribunal. Therefore, petition is dismissed. Right, we have recorded this. Other ground we are rejecting. We are rejecting on the same ground. We are not terminated.
Lord, I appear for the petitioner in this case.
In point 16. Yes.
I appear for the petitioner in this case, my lord. My lord, in this, the respondent, my lord, was working as a lead operator, and he was dismissed from service from 30/12/2011 for the proved misconduct of unauthorizedly disclosing the confidential information with regard to technology design to the outsiders, my lord. My lord, the labor court held inquiry is not fair and proper, and opportunity was given to us to lead fresh evidence. Accordingly, my lord, 3 witnesses were examined on behalf of the management. The respondent got himself examined as WW1. The labor court rejected, labor court set aside the order of dismissal and directed me to reinstate him with 50% back wages. The reasoning given is there is no evidence, sufficient evidence to show that respondent was given computer, and the benefit of doubt has to be given in his favor. My lord, the labor court has arrived at this conclusion without considering my evidence on record. Evidence of MW2, which your lordship would get it at Annexure G, page 118, is very much relevant for the purpose of misconduct. Kindly come to para 12, ink page 121, my lord. It is relevant. He is the general manager, business administration. He has given extensive evidence. Para 12. He says, I state that after installing the admin ID, IT department accessed his system on November 17, 2010 and came to know that the first party has sent a lot of confidential information to his personal email ID and to other emails ID information such as. These are the details. Next, kindly come to para 13. I state that it was found that first party has passed on the above mentioned information to the following emails. About 8 emails he has indicated. Next, para 14. I state that the first party has largely used the system for this personal purpose and had shared company's data and information with others. Next, my lord, kindly come to para 15, 5th line. The first party has sent email to his personal ID and to other emails IDs via email dated 1/5/2010, 29/6/2010, 13/3/2006. Now, my lord, I will trouble your lordship to come to para 16. I state that the first party has also forwarded critical costing information about the cost of screen mesh, screen cost, frame cost, purchase orders, etc., etc. Now, para 17. I state that the first party has forwarded product information of manufacturing standard of TVS Victor so positive information through email to his personal ID and outsiders, which are at pages 165 to 180 of the inquiry book. Now, para 18, I state that the first party has furnished the information about quality system procedure of the following 3M processor. The details are shown here. Next, the above mentioned information are extremely confidential, which helps 3M get the required international quality certification to support domestic as well as international business. Next, my lord, your lordship can kindly come to para 20 in page 125. I state that the first party has extensively used the system for its personal purpose and had shared company's confidential data and information with others, which is in clearly violation of the company business conduct policy, electronic mail and instant messaging policy, and electronic resources as laid down by the company. Well, this is the evidence given by M2, General Manager, Business Administration. There is no cross-examination on this. Now, unfortunately, Labor Court comes to the conclusion, your lordship may kindly come to page 150, Annex J is the award, award intent. Now, I request your lordship to kindly come to the reasoning given by the Labor Court, which is at para 22, page 175.
175.
Page 175, para 22 of the award. Sixth line. This is the only reasoning given. No doubt some copies of mail transactions are produced and marked in the evidence of MW2 to establish that the first party sent emails to other email IDs. This court observed that as admitted by MW2, no document placed on record to show that the first party was entrusted with computer. On close scrutiny of the entire evidence, this court do not find sufficient reason to hold that the first party himself sent alleged information through mails committed and committed. This is the only reason. Milord, Labor Court has not considered the evidence of MW2 at all. MW2 has given evidence that so many emails were sent through computer. But unfortunately, Labor Court has arrived at a perverse finding saying that there is no document to show that he was produced, he was given computer. And the very next sentence, the Labor Court comes to the conclusion that it is very difficult to say that he only sent the email. This is totally a perverse finding, and nowhere MW2 evidence is the best evidence. It is not discussed, it is not considered at all. And in the matters of this nature, giving benefit of doubt would not arise. This is not a criminal proceedings. The standard of proof required in such cases is a mere preponderance of probability. And the sufficiency of evidence also cannot be gone into. On the other hand, there is overwhelming evidence on record to show that he has committed the misconduct. My lord, if such a person is reinstated, my lord, then it will be highly detrimental to the interest of the organization. And no organization can afford to accommodate such person. This is my humble submission. This is the only reason. And not at all considered evidence of MW2.
Yes. You are taking interim stay?
Yes, my lord.
Interim player is there.
Interim player is there.
Do you want to submit anything on it? He says, yeah, not file application. You have to file an affidavit for that. 17
No. In writ petition of interim player application is not required. Kindly come to page 20, my lord.
No, it's there. He was saying.
No. It is in writ appeal. It is not required in writ petition.
Correct. Or illa anta helta illa.
Third,
matter request to take consideration. Issue interim stay of the impugned award till further orders. If you want basis, you have to the TCS call for TCS.
much okay.
C. MC Basvaraju.
Managing Director. ಯಾರೋ ಒಬ್ರು ನೋಟಿಸ್ ತಗೊಳ್ತಾರೆ ಇಲ್ಲಿ. ಯಾರಿದ್ದಾರೆ? Who is there? KSRTC penal advocate. ಹೋಗ್ರೆ ರೇಣುಕಾ ಅವ್ರು ಇದ್ರಲ್ಲಿ penal advocates. ಕೇಸ್ ಕೊಡ್ತಾ ಇದೀವ್ರಿ. ಸರಿ. ಹರೀಶ್ ಭಂಡಾರಿ. ಹರೀಶ್ ಭಂಡಾರಿ. ಯಾಕೆ ಯು ಆರ್ ಚೂಸಿಂಗ್ ಓನ್ಲಿ ಮೇಲ್? ವುಮನ್ ಎಂಪವರ್ಮೆಂಟ್ ಮಾಡಿ ಸ್ವಲ್ಪ. ಹರೀಶ್ ಭಂಡಾರಿ ಅವ್ರ ಕಡಿಮೆ ಇದೆ ಅಂತಲ್ಲ. ಹೈಯೆಸ್ಟ್ ಇದೆಯಾ? ಆಯ್ತು. ಅವ್ರಿಲ್ಲಲ್ಲ. Lord Consider the petition is permitted to serve notice on Shri Harish Bhandari. Harish T. Bhandari, there are standing counsel for response 1 and 2. A list on. In urgent there. When this a date here. 19.
Number 18.
Random bus. ಇದ್ರಲ್ಲಿ ಯಾರಿಗೆ ಕೊಡಬೇಕು? Same thing, previous case. Standing counsel for response 1 and 2. Yes.
Number 19.
To provide the list of this amount of paid to Krishna or Jayam. Because they are not going to find the record. Not on Monday, not on Monday. They will be all the records and go to the record of the Jayam. But on Monday,
just 1 second. Where? We are not able to recollect any. Government of India has permission to closure of respond number 1. Service of petitions terminated. Yeah. You represent? Come on. Bharat Board Mines.
They are not the list of how much amount you have paid to this system for Jayam. They are already paid. The amount is already been paid to gratuity amount. Based on the answers of the authority and orders of this Tamil court also. Subsequently, when they were paying the other they
deducted.
Reopen case already and reduce the gratuity already.
Some 61,081 and 64,081. ಎಷ್ಟು ಟೈಮ್ ಬೇಕು? This picture itself is very old at the time. 2014. As requested, list on 31. ಅಲ್ಲ ಹಿಂದಿನ ಏನಂತ ನೋಡ್ತಾ ಇದ್ದೀವಿ. Our learned counsel for petitioners and respond number 1. Learned CGC is absent for further hearing. ಅವರು ಎಲ್ಲಿದ್ದಾರೆ? CGC ಯಾರು? ನೀವೇನಾ? ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ರೆಸ್ಪಾಂಡ್ ಅಲ್ಲ, ಅವ್ರದ್ದು ಹರ್ಡ್ ಅಂತ ಆಗಿದೆ. ಹರ್ಡ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಿಫೋರ್ ದಟ್ ಹರ್ಡ್ ಲರ್ನಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಪಿಟಿಷನರ್ಸ್ ಅಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಮರ್ತೋಗುತ್ತೆ ನಮ್ಗೆ ಆಮೇಲೆ. ಮಂಡೇ ಹೇಗಿದೆ? ಮಂಡೇ ನೋಡಿ, ನಾವು 4th 5th ತುಂಬಾ ಆಗ್ಬಿಟ್ಟಿದೆ. 4th ನೋಡ್ ಆಯ್ತು. Monday, you said Monday, it is 4th. Yes, yes. as requested by council for respondent number 1 as a final chance list on.
Number 20 adjourned.
Then you have to submit the documents to us. Council for respondent 1 seeks time on the ground that he has to submit some documents as a final chance list on.
Number 20 adjourned. Number 21 hot heading D groups. MV Kanuja, DM Sanjeev.
Heard in part ಅಂತ ಆಗಿದೆ. So his dispute is dismissed. Reference claim petition is dismissed. You to represent KSRTC. You are for the petitioner. Nim's argument ಆಗಿದೆ. Heard in part ಅಂತ ಅಷ್ಟೇ ಮಾಡಿದೀವಿ ನಾವು. ಅಲ್ಲ ಅವ್ರು ಬಂದಿರ್ಲಿಲ್ಲ ಅಂತ ಕಾರಣಕ್ಕೆ ಅದಕ್ಕೆ ನಮ್ಗೆ ನಾಟ್ ಏಬಲ್ ಟು ರೀಕಲೆಕ್ಟ್ ಏನು ನಿಮ್ ಕೊಲಿಗೆ ಹೇಳಿದ್ರು ಇಲ್ಲ ನಾವು ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಟ್ಲೀಸ್ಟ್ ನೀವು ಪ್ರೆಸ್ ಮಾಡಿದ್ರಿ ಅಂತ ಕಾಣಿಸುತ್ತೇನ ಇದೆಲ್ಲ ಬರೀ ಪಾರ್ಟ್ ಹೂ ಇಸ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ದಮ್ ಅವ್ರು ಬರೋದೇ ಇಲ್ಲ ಅವ್ರದ್ದು ಏನಾರ ಅರ್ಜೆಂಟ್ ಇದ್ರೆ ಅವ್ರದ್ದು ಏನ್ ಮೂವ್ ಮಾಡಿದ್ರೆ ಬರ್ತಾರೆ ಇಲ್ಲ ಅಂದ್ರೆ ಬರೋದಿಲ್ಲ ಮೂವ್ ಮಾಡಿದಾಗ ಇಟ್ಕೋಬೇಕು ಅಷ್ಟೇ ಕಾಸೂರ್ ಮಾಡೋಣ ಯಾಕೆ ಆಫ್ಟರ್ನೂನ್ ಎನಿ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಫ್ರೀ ನಮಗ್ ಮಧ್ಯಾಹ್ನ ಸುಬ್ಬಾರಾವ್ ಅವ್ರದಾ 6 ಹಾಕೋಬಹುದು ಬರೀ ಪದೇ ಓದಿದ್ದೆ ಓದ್ಬೇಕಾಗುತ್ತೆ ನಮ್ಗೆ ಪುನಃ 6 ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅವ್ರಿಗೊಂದು ಫೋನ್ ಬಂದಾಗ ಹೇಳಿ ಇಲ್ಲ ಅವ್ರಿಗೆ ಈ ತರ ಫೈನಲ್ ಚಾನ್ಸ್ ನಾವು ಅವತ್ತು ಪಾಠಾಡ್ ಅಂತ ಮಾಡಿದ್ರೆ ಮಾಡ್ತಾರೆ ಅಂತ ನೀವು ಅವಾರ್ಡ್ ಓದಿರ್ಲಿಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತಲ್ಲ 17 ನಾನ್ ಇಶ್ಯೂನ್ಸ್ ಅಂಡ್ ನಾನ್ ಕಲೆಕ್ಷನ್ 17 ಡಿಫಾಲ್ಟ್ ಕೇಸಸ್ ಅಂತ ಏನು ಫೈನಲ್ ಚಾನ್ಸ್ ಲಿಸ್ಟ್ ಆನ್ 6
number 22 adjourned. Number 23 Renuka Hachar, L. Shekhar.
ಶೇಖರ್ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ರು ರೇಣುಕಾ ಮೇಡಮ್ ಜಾಸ್ತಿ ಕೇಸ್ ಅವ್ರು ಕೊಡ್ಬೇಡಿ ಅಂತ ಬಸವರಾಜ ಅಲ್ಲ ಶೇಖರ್ ಅವರಲ್ಲ ಬಸವರಾಜ ಅವರು ವುಮನ್ ಎಂಪವರ್ಮೆಂಟ್ ಅಂತ ಕೊಡಿ ಸ್ವಲ್ಪ ಅಂತ ಹೇಳಿದ್ವಿ ನಾವು ಇಲ್ಲ ಶಿ ಇಸ್ ಮೋರ್ ಎಂಪವರ್ಡ್ ಅಂತ ಹೇಳಿದ್ವಿ ಮಿಸ್ಟರ್ ಸಂಜೀವ್ ಎಲ್ಲಿರ್ತೀರಿ ನಿಮ್ ಕೇಸ್ ಕರ್ಸ್ದಾಗ ಇರೋದೇ ಇಲ್ಲ ನಿಮ್ ಕೊಲೆಗಿದ್ರು ಆಯ್ತು ಇದನ್ನ ಮುಗಿಸಿ ಮತ್ತೆ ತಗೊಳ್ತೀವಿ ಬರ್ದಿಲ್ಲಲ್ಲ ಇನ್ನು ಲೆಟ್ ಹಿಮ್ ಆರ್ಗ್ಯೂ ಮತ್ತೆ ಅವ್ರು ನೀವಿಲ್ಲ ಅಂತ ಟೈಮ್ ಕೇಳಿದ್ರು ನೀವಿಲ್ಲ ಅವ್ರಿಗೆ ಅಕಾಮಡೇಟ್ ಮಾಡೋದಕ್ಕೆ ಇನ್ನೊಂದ್ ದಿವಸ ಹಾಕಿ ಅಂತ ಮತ್ತೆ ನೀವ್ ಹಾಗೆ ಹೇಳಿದ್ರಿ ತಾನೆ ಅವ್ರನ್ನ ಅಕಾಮಡೇಟ್ ಮಾಡೋದಕ್ಕೆ ಇನ್ನೊಂದ್ ವಾರ ಟೈಮ್ ಕೊಡಿ ಅಂತ ನೀವ್ ಹಾಗೆ ಹೇಳಿಲ್ಲ ನಿಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರಿ ನಾವೇ ಅದನ್ನ ಓದಿ ನಮ್ಗೆ ಏರ್ ಮಾಡಿದ್ದು ನೆನಪಿಲ್ಲ ಆ ಸಾರಿ ಮಾತ್ರ ನೀವು ಬಂದಿರ್ಲಿಲ್ಲ ಪಾಠಾಡಂದ್ರೆ ಬರ್ತೀರಾ ಅಂತ ಹಾಕಿದ್ವಿ ಅಲ್ಲ ನೀವು ಆ ವಾಲ್ ಇಫ್ ಯು ಆರ್ ದೇರ್ ಬಿಯಾಂಡ್ ದಟ್ ವಾಲ್ ಆಯ್ತು 6-4 ಎಸ್ ಇದ್ರಲ್ಲೇನು ಎಸ್ ಮಿಸ್ಟರ್ TCRs ಬೇಕಾ ಯಾವ್ದಿದು ಸೀರಿಯಲ್ ನಂಬರ್ 23 ಎಸ್ TCRs are required ಯಾರೋ somebody has moved the memo ನೀವೇ ಮೂವ್ ಮಾಡಿದ್ದೀರಾ he is reinstated Let's see.
Either salary is that.
And the matter is taken up, it is noticed that the TCRs are not received. Call for TCRs. Next after receipt of TCRs.
Number 24.
You are their pay masters. Pay ಕೊಟ್ಟೆ ಅವ್ರನ್ನ ಕಂಟ್ರೋಲ್ ಮಾಡೋದಕ್ಕೆ ನಿಮಗೆ ಇಷ್ಟು ಕಷ್ಟ ಆಗುತ್ತೆ. They are their pay masters. ಇವ್ರು ನಾವು ಹೇಗೆ ಆಡಿಸ್ಬೇಕು? That's what we said. They are their pay masters.
Number 24. Vishnu Kumar K. Sandeep PL.
Vishnu Kumar. Yes. Irregular records for this. So what is the order passed? Controlling authority. Is it payment a gratuity? No? Yes. Page number? 78. What is the order challenge here? Was the dismissal order dated 18/11/2016 passed by the disciplinary authority at Annex A? Was the impugned award dated 9/8/2017? 9/62. Dismissal was on what ground? What is that page number? Yes. First party note to the provision. Generally, this officer takes lenient view. Records maker. So disciplinary authority also indicted and the same is confirmed. That is taken up. It is noticed that the TCRs are not received. Call for TCRs.
25. P. Prasanna Kumar. Srinivas K. For respondent.
These matters have to be connected with the I-1464 of 19.
Previous ಎರಡು ಕೇಸ್ ಎಲ್ಲಾನು ರೂಲ್ ಮಾಡೇ ಮಾಡ್ಬೋದಲ್ಲ 23 and 24 issue rule call for TCRs. Yes, what is this? So there are in all 4 matters. In what way they are connected? Common order. 1 second. Common order and 1 second. We'll see. What is that page number? Page number 19. Certified copy of the award. 18. 18. ID number 18 of 2017 and is page number 19. ID number award in ID number 18 of 2017. You said common order was passed in several disputes. So separate orders. Then in what way they are connected? Evidence was recorded separately. So termination order was common. What was that order? Where do we find that? Termination order. You said whether is that correct? Is that connected to the other matters? ಇಲ್ಲಾಂದ್ರೆ ನೀವು ಸುಮ್ಮನೆ ಕನೆಕ್ಟೆಡ್ ಅಂತ ಹಿಂದೆ ಯಾವುದೇ ಕೇಸಲ್ಲಿ A by direction. What is the discrepancy? You file objections to that if there is any discrepancy. It is submitted that this are connected to WP number so and so. For application. Time to file objections to IA. One of first isn't the one. The petition 6. Time to file counter to IA 1 of 2022 in WP number 15,155/2020. It is further submitted that these matters are connected to WP number so and so. List all the matters together on. Check money. Interim order. Interim order granted earlier is extended till extending it. ಇದು ಇವ್ರು ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿದ್ವಲ್ಲ VS ನಾಯಕರದ ಆ ಫೈಲ್
Baba Mishra, Balasubramanian, 14%.
ಏನ್ ಹೇಳ್ತಾರೆ ಅವರು? Yes, what they say, he is seeking adjournment. It was a date given matter. How is it? 2020. What have we challenged here? What order is passed? Reference. Oh, what was the order passed? Was it a case of this? They are paying him wages now. 17K wages ಕೊಡ್ತಾ ಇದ್ದಾರಾ? 14% after vacation. 26. ಎಲ್ಲಿದೆ ಯಾವಾಗಿತ್ತು ಇಂಟ್ರಿ ಆರ್ಡರ್? Interim order granted earlier is extended till extended. Why this order sheet has become so bulky? Adjournment came.
Number 27, BL Sanjeev, Shekhar L.
Who has moved the memo? Shekhar avara? Yes. Yes. Sir. 9 years delay in filing this petition. Because the inquiry officer submitted his report. Respondent was issued show cause. Disciplinary authority imposed punishment withholding ensuring. Very 3 increments the ಮಾಡಿದ್ರು with cumulative effect. Government referred the dispute to the industrial tribunal for adjudication. 2019 tribunal passed the award. So 2019 ಅಲ್ಲಿ ಮಾಡಿದ್ರು. ಏನು what is delay said dispute raised what? ನಿಮ್ಗೆ ಅದ್ರ ಮೇಲೇನೂ ಗ್ರೀವೆನ್ಸ್ ಇದೆಯಾ? You had passed the order of punishment withholding 3 increments. Set aside that order. So dispute raised ಮಾಡೋದ್ರಲ್ಲಿ delay ಇತ್ತು ಅಂತನಾ? Dispute was raised after 9 years. ಈಗೇನು ಬ್ಯಾಕ್ ವೇಜಸ್ ಏನಾದ್ರು ಕೊಟ್ಟಿದ್ದಾರಾ? ಇಲ್ಲ ಅಲ್ಲ 3 increments ಅಷ್ಟೇ ಅಲ್ಲ ಬ್ಯಾಕ್ ವೇಜಸ್ consequential benefits. First party is justified in raising the dispute after lapse of 9 years from passing the punishment order. ಏನ್ justification ಇತ್ತು ಅದಕ್ಕೆ? Justified in withholding page 30. Records ಬಂದಿಲ್ವಾ ಇದರಲ್ಲಿ? Records ಬರ್ಬೇಕಾಗುತ್ತೆ. Records ಬರ್ಬೇಕಾಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಬರೀ ಇನ್ಕ್ರಿಮೆಂಟ್ಸ್ ಹೋಗಿದೆ ಅಲ್ರಿ. ನಾವೇನೋ ಡಿಸ್ಮಿಸಲ್ ಅಂದ್ರೆ ಕರೆಕ್ಟ್. ಅದರಲ್ಲಿ on what ground it was set aside? Whether inquiry was held fair and proper or not? ಅಲ್ಲ 9 years ಡಿಲೇಗೆ ಏನ್ ಹೇಳಿದ್ರು? 9 years ಮೇಲೆ ಏನ್ ಎವಿಡೆನ್ಸ್ ಸಿಗುತ್ತೆ ಅವ್ರಿಗೆ ಪ್ರೂವ್ ಮಾಡೋದಕ್ಕೆ? ರೈಟ್, ಏನ್ ರೀಸನ್ ಹೇಳಿದ್ರಿ ನೀವು 9 years ಡಿಲೇಗೆ? What issue rule? Call for TCRs. List of receipt of TCRs. Entry order granted earlier is extended till further orders.
My lord, I appear for the petitioner in first and second case. All these three cases, your lordship has directed the registry on 14/3/2000 to secure TCR, my lord.
TCS ಬಂದಿದೆ ಮೇಡಮ್, ಇವಾಗ ಬಂತು.
TCRs ಬಂದಿದೆ, ಈಗ ತಂದಿದಾರಂತೆ.
ಹಂಗಾದ್ರೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಾಗುತ್ತೆ TCR ನೋಡಿದ್ರೆ. ಇವಾಗ ಬಂದಿದೆ TCR.
You are the petitioner.
I am for the petitioner in first and second case. In third case, my learned friend is the petitioner.
You are Nagbhushan.
Nagbhushan.
That is workman's petition.
Yes, yes.
The company has been established in the year 1964. They are covered under the provision of the Indian Study Orders Act, Indian Institute Act, on 13/2/2017, they have filed a petition, they filed an application before the Excise Commissioner that they are going to close down the industry from 1/7/2017. I filed a memo for them.
Voluntary retirement and payment of amount was in 2017. June 2017 and July 2017. Then you raised a dispute saying that it was involuntary. Yes.
But the thing is, they are covered under the provision of Indian Study Orders. They are called study orders. The case has been closed by nothing. They have to give 3 months notice to the employees. But the management has issued a notice to the Excise Commission that they are going to start the production from 1/7/2017. That is way back to 6 months before. But all of a sudden on 16/6/2017, Union has signed a settlement under section 2B of the settlement. 2B of the engagement dispute. That is not valid. That 2B relates to employment and employment. On 23/6/2017, that is 7 days, they issued one more notice. The company has been shifted to Maliyur village and Narsipura village. Again, June 2017, the company has closed. We have asked for closure compensation. We have not asked for any reinstatement. We have accepted the VRS for nearly 2.5 lakhs. They have raised dispute.
3,37,000. Gratuity of 3,37,900 and compensation of 8 lakhs something.
You have raised issue before the constituted authorities.
Now the evidence has to be examined. No? Evidence has to be examined. Records are received.
But in the other 2 cases, the section 11 they have filed an application for recovery of the amount. The section 11 will not permit for any recovery. See, in the meantime, the principal labor presiding officer of the principal labor court has filed an order in favor of management, stating that what are the issues when orders were the business capital India already come to respect for Bengaluru. You would escape that of the Murthy issue of this case in 1991. ಈಗ 30 6 2017 ಕೆಲಸ ನ್ಯಾಯ ಸಮ್ಮತವೇ. See, in case of any VRS or something, there should be a voluntary retirement scheme and company has to be existed. Company has been sold to the Brigade India Limited, that it has been highlighted in the award of the labor code. See, we have challenged the award of the labor code since the additional issues they have framed by the presiding officer.
Where is the award of the labor code? Or petition? It is in the petition of both of you, or?
No, I am only for the 1991 of the petition.
Or petition for it? So records in both the cases are common.
In all the three cases, your lordship has directed.
One is interim application, the other or interim application.
17,792 cases. Although the honorable second additional labor court has rejected their IA.
Correct.
IA they have come in that 17,792.
Last time year interim order modify ಮಾಡಿದ್ದೀರಾ. Iವಾಗ it has to be heard. All the three cases have to be heard.
One second.
My learned friend is ready. I will come at 2:30 and address arguments.
The claim petition was dismissed. The government is directed to publish the
I think this is my later. By not complying the order of this honorable court, page number 60 of the award, it says the first party is able to prove additional issue number 1, but he is not entitled for the above said claim for non-compliance of the order passed by the honorable court on IA number 1. The IA number 1 now apply ಮಾಡಿಲ್ಲ ಅಂತ
What was IA one?
IA number 1 the management has filed a petition application on IA section 11. Section 11 does not permit for refund of the amount. If there is any case, they have to go under section 59 of the idea. Then
the registers placed, the records. Yes. The common name. Your application actually stay. ಎಲ್ಲಿ ಪೆಂಡಿಂಗ್ ತೋರಿಸ್ತಾ ಇಲ್ವಲ್ಲ? ಹಾಗಾದ್ರೆ ಅದ್ರ ಮೇಲೆ
ಅದನ್ನ it will be considered at the time of hearing ಅಂತ ಮಾಡಿದ್ದೀರಾ ಅವಾಗ
ಆಗಿದೆ
ಫೈನಲ್ ಹಿಯರಿಂಗ್
but this
it will be considered at the time of final hearing ಅಂತ ಮಾಡಿದ್ದೀರಾ
4/10/2021 4/10/2021
14/3/2022 ಅಲ್ಲಿ it will be considered along with main writ petition ಅಂತ
A detailed order was passed on that court. Consequently, there shall be a stay of impugned order dated 17th. So, further proceedings will be.
14/3 ಆರ್ಡರ್ ಇದೆ 17/22 of 2022 ಅಲ್ಲಿ 17/7/92 of 2021 ಅಲ್ಲಿ ತಾವೇ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀರಾ 14/3/2022
ಯಾವ ಕೇಸಲ್ಲಿ
17/7 ಸ್ವಲ್ಪ 17/7/92 of 2021 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ clean ಆಗಿದೆ IA1/2022 in WP number 17/82 be heard along with the main matter.
Order of labor court is challenged. Third petition main award is under challenge. Discipline matter already there is a stay of further proceedings.
Here ಮಾಡಿದ್ದಾರೆ last time.
Then the further proceedings for labor court amount to futile exercise. Therefore, interim stay of the further proceedings in so and so next hearing date. IA1 of 2022 shall be heard along with the main matter already.
ಮಾಡಿದ್ದೀರಾ last time ಅವಲ್ಲ
ಅದೇ ಇದರಲ್ಲಿ 17,000
this was heard.
Order ಆಗಿದೆ.
It was heard on the last case.
IA1 of 2022 in WP number 17,802 of 2021.
Now we heard along with the main matter. RTCR.
So IA 1 of 2022 ಅದ್ರಲ್ಲೇನೆ it shall be heard along with the matter ಅಂತ ಆಗಿರೋದು. ನಮ್ಮ ರಿಜಿಸ್ಟ್ರಾರ್ ಹಾಗೆ ಲಿಸ್ಟ್ ಮಾಡ್ತಾ ಇರ್ತಾರೆ ಅದನ್ನು. ಆಯ್ತು, ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಗೆ 6-4 ಹಾಕೊಳ್ಳಿ.
ಬಂದು ಐ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಐ is rejected. Since the section 11 is not maintainable according to second level. ಅದು ಎರಡು ಕೇಸ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಏನು
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಆಗ್ತಾರೆ.
ಅಲ್ಲ 19 ಅವಾರ್ಡ್ ಆಗಿದೆ. 17 ಅವಾರ್ಡ್ ಆಗಿದೆ. Still it is pending. It is reserved for orders.
Reserved for orders.
Award is reserved for award.
You have supported the award, alva?
19
ಸ್ಟೇ ಆಗಿದೆ ಇದರಲ್ಲಿ.
One second.
Since we have not compared the order of this petition.
Correct. And you want stay in your case. You don't want stay in their case.
ಎರಡು ಕೇಸಲ್ಲೂ ಆಗಿದೆ. ಎರಡು ಕೇಸಲ್ಲೂ ಸ್ಟೇ ಆಗಿದೆ.
We have already heard that it shall be heard along with the main matter. The register TCRs issued by TCRs heard issue rule for final hearing.
Interim stay.
Day 1 of 2022 is already ordered to be heard along with the main matter. This shall note the same. Interim order granted earlier is extended till further order. This done after vacation ahead. 2021 matters. Yes.
Number 29, Kalyana, Renuka Rachna.
ಅಂದ್ರೆ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇಸ್ ನಾಟ್ ರೈಸ್ ಮಾಡಿಲ್ವಾ? Correct. You can reply that.
Without filing objections.
Correct. You submit. Now it has come for preliminary hearing in these reports. You submit it. The question of law is objections. File madadene helbodu. All right. Let you submit your case. Second question. ಈಗ ಇಟ್ ಹ್ಯಾಸ್ ಕಮ್ ಅಪ್ ಫಾರ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್. ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಹೇಳಿ, ಆಮೇಲೆ ನೀವು ರಿಪ್ಲೈ ಹೇಳೋರಂತೆ. ಎಸ್ ವಾಟ್ ಇಸ್ ದ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಇನ್ ಫಸ್ಟ್ ಮ್ಯಾಟರ್? ಒನ್ಸ್ ನೀವು ಹೇಳಿದಾಗೆ ನಾವು ತಗೋಬೇಕಾ ಕೇಸ್ಗಳನ್ನ? ಮೊದಲು ನಮಗೆ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು. ರೈಟ್. ನಾವು ವಾಟ್ ಇಸ್ ದ ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಇನ್ ದ ಫಸ್ಟ್ ಮ್ಯಾಟರ್? ಫಸ್ಟ್ ಪಿಟಿಷನ್ next A certiorari quash the impugned dismissal order. So this is you have directly coming. Yes. So this will be in the second matter. What have we challenged?
That's regarding posting order. There was an interim order.
One nimsham.
Give him light nature of work.
One nimsham. What is the order? Issue writ of certiorari quash impugned transfer. So here you have challenge the transfer order.
Yes.
First you have to satisfy on this, then you can take up this matter. Second matter.
This red.
ಮೊದಲನೇ ಮ್ಯಾಟರ್ ಮೊದಲು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಯಾಕಂದ್ರೆ yes
Yes, I narrate the background.
yes ಹೇಳಿ.
Facts of the case. Because the petitioner was initially appointed as driver cum conductor. While he was in service, because he suffered an injury, spinal injury. In the year 2012, that is 6/2/2012, he underwent spine surgery at Postman Hospital. What he was asked, he was advised to take bed rest. And thereafter, doctors advised that he cannot do the heavy nature of work. Since he was working as a driver cum conductor, there was an advice not to do such a hard work. Thereafter, representations were given that was not considered. Thereafter, his case was referred to the medical board. Medical board gave a report saying that he is suffering disabled. Even thereafter, his case was not considered. A writ petition was filed before this one court seeking direction. During pendency of the writ petition, this court held that I have to obtain the disability certificate and the disability act. Therefore, the direction to upload the appropriate court. Thereafter, the disability certificate was obtained. Even then, like nature of work was not. And subsequently, one more writ petition came to be filed. There was an undertaking by the other side. And subsequently, it was the like nature. The disability assessed by the board was that the disability is progressive. The disability is progressive in nature. It is not curable. Therefore, it becomes the disability is for throughout his life. Subsequently, the transfer order came to be passed. Forcing him back, it was where as a driver. And also thereafter, I was directed to undergo medical examination. That was challenging for this one. There was a circular issued by the PMPC and KSI. The effect that wherever the board assesses that disability is being permanent in nature, they need not once again secure the medical fitness certificate or to assess the disability that there is a certificate. Therefore, when the petition was filed before this court felt that after using the petitioner shall be given light nature of the model was granted on 23/2021, directing the respondents here to assign light nature of work. That is just work. But in the meanwhile, there was a one car given by the union. That KSRTC and PMPC. Recently, I was because there was a one car given by the statewide car. The petitioner was not part of the one car given by the union. Immediately after the interim order, he approached the authorities, responded, and gave a representation and also expressed them to assign in light nature of work in view of the interim order granted by this one. They did not comply with the order of this one. Did not comply with the order. That is the order dated 23/2021. What's that connection? G, there are first case. Thereafter, meanwhile, one car was given an order, a suspension order came to be passed on 12/4/2021. This suspension order, the page number. This order is passed during operation of the interim order. The direction was to give the petitioner light nature of work. The duty of the respondents are required to comply the order passed with this one report by assigning it light nature. Instead of complying the order of this one report, the petitioner was kept under suspension. The reason given is that I participated in once. When I am suffering from permanent nature of disability, and that is injury, is a spine injury, where I had already underwent a surgery. And this was also not immediately communicated to me. Thereafter, within 3 days, articles of charge came to be issued. That is 15/4/2021.
Yes.
In 4 days, within 4 days of the issuance of the articles of charge, dismissal order came to be by the respondent.
Charge was issued on 15/4/2021. Charge was issued on the same date. Suspension and charges on the same day. Yes.
So the suspension on the order 13/14, and articles of charge is on 15/4. And dismissal order is on 19/4.
Suspension order is 15/4 ಅಂತ ಇದೆ.
Articles of charge.
15/4/2000 ಅನೆಕ್ಷರ್ ಎಚ್ ಅಲ್ವಾ? ಅನೆಕ್ಷರ್ ಎಚ್ 15/4. So articles of charges were also issued on the 15/4/2022. Dismissal order is dated. Dismissal order.
19/4.
Annexure?
Annexure A, page 19.
It's on 21/4. Yes.
In the order because of the commentator, but the respondent number 3, this is the old practice. The appointment of the inquiry officer is dispensed. Since no reply is filed on the articles of charge, pass an order dismissing the petitioner.
Annexure K is not the dismissal order. It is a very
Annexure A, page 19.
19/4. Not 21. Oh. Yes. Yes. Yeah. Para 1 of the dismissal order. We'll continue in the afternoon. ಯಾಕೆ ಕಮೆಂಟ್ಸ್ ಯಾಕೆ ಮಾಡಿದ್ರಿ ಹಾಗಿದ್ರೆ? ನಾವು we have see, even if we sit now another 10 minutes 15 minutes you need, so it goes beyond 1:45. ಮಧ್ಯಾಹ್ನ ಬಂದು ಕಮೆಂಟ್ಸ್ ಯಾಕೆ ಮಾಡಿದ್ರಿ ಹಾಗಿದ್ರೆ? why did you comments? See, she has ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ, ಮಧ್ಯಾಹ್ನ ಹೇಗಿದ್ರು ನಮ್ಗೆ ಸುಬ್ಬರಾವ್ ಅವ್ರದ್ದಿದೆ, ಅದಾದ್ಮೇಲೆ ಬನ್ನಿ. ಕರೆಕ್ಟ್. ನೀವು ನೀವೇ ಯಾಕೆ ಬರ್ಬೇಕು ಬಸವರಾಜ್? ನಿಮ್ಮ ನೆಕ್ಸ್ಟ್ ಲೈನ್ ಅವ್ರು ಯಾರಿದ್ದಾರೆ? ಜೂನಿಯರ್ ಬಸವರಾಜ್ ಇದಾರಲ್ಲ, ಕಲ್ಯಾಣ್ ಬಸವರಾಜ್. ನೀವ್ಯಾರು? ನೀವು ಕಲ್ಯಾಣ? ಓಹೋ, ನೀವು ಯಾರನ್ನ ಜೂನಿಯರ್ಸ್ ತಂದಿಲ್ವಾ ಇನ್ನು? ಇವಕ್ಕೆಲ್ಲ ನೀವು ಕಳಿಸ್ಬೇಕು, ಒಂದಿಷ್ಟು ಟ್ರೈನ್ ಮಾಡ್ಬೇಕು ಬೇರೆಯವರನ್ನ. ಆಯ್ತು, ಟುಮಾರೋ ಆಯ್ತು. 5/4 ಈಗ ನೋಡಿ, ಪಾಠ ಮಾಡಿಸಿದ್ರಿ, ಅದನ್ನ ಬಿಡ್ಲಿ. Third in part for further hearing as requested by petitions council list on 5/4. ಅಲ್ಲ, ಈಗ ಮಧ್ಯಾಹ್ನ ನಿಮಗೆ ಒಂದಿದೆ, ಸುಬ್ಬರಾವ್ ಅವರು ಶುರು ಮಾಡ್ಕೊಳ್ಳೋರಿದ್ದಾರೆ. ವೇಟ್ ಮಾಡೋದಿದ್ರೆ ಮಾಡಿ. ಅದಕ್ಕಲ್ಲ ಆಯ್ತು, ಒಂದ್ ವೇಳೆ ನಿಮಗ್ ಅರ್ಜೆಂಟ್ ಅಂದ್ರು ಮಿಸ್ಟರ್ ಶೇಖರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಯ್ತು. ನೀವು ಅವ್ರಿಗೆ ಏನಿದೆ ವಾಟ್ ಡಿಸ್ಮಿಸ್, ಏನಿದೆ ಡಿಸ್ಮಿಸ್ ಅಲ್ಲ ಏನಿದು? As requested by the financials, 2 weeks ಆದ್ಮೇಲೆ 24. ಯಾವಾಗ್ರಿ ನಾವೀಗೆಲ್ಲ ತಗೊಳ್ಳೋದಿಲ್ಲ, ನೀವು ಬೇಕಾದಾಗ ಬಂದ್ ಕೊಡ್ತೀವಿ ಅಂದ್ರೆ ಹೇಗೆ? 135 134 ನೀವೆಲ್ಲ ಏನ್ ಕಲಿಸ್ತೀರಿ ಅವ್ರಿಗೆ? ಅಲ್ಲ ಕರೆಕ್ಟ್ ಸಿ, ಪದೇ ಪದೇ ನಾವು ಒಂದೇ ಎಕ್ಸಾಂಪಲ್ ಕೊಡ್ತಿರ್ತೀವಿ. ನಿಮ್ ಮಕ್ಳು LKG UKG ಇರ್ತಾರೆ, ಅವ್ರ ಸ್ಕೂಲಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗ್ತೀರಿ, ನೀವು ಕೈ ಹಿಡಿದು ಬೆಲ್ ಹೊಡೋದ್ರೆ ಒಳಗ್ ಕರ್ಕೊಳ್ಳೋದಿಲ್ಲ. ಮಕ್ಳಿಗಿಲ್ದೇ ಇರೋ ಡಿಸ್ಪ್ಲಿನ್ ನಮಗೂ ಬೇಡವಾ?
ಅದು ಹಿಂದೆ rectification of statement of objection ಹಾಕಿದ್ರಲ್ಲ, ಅದರೊಳಗಡೆನೆ statement of objection. ಅದು statement of how they will office objection. 1 of 20.
Yes, I will dispose that. I will dispose it. Dispose it. అలాగే అకౌంట్ స్టేట్మెంట్ రికార్డ్ తಗೊಂಡ objections to the application.
Application and objection. Statement of objection.
ಇದು ಪಾಸ್ 1.10 ಅದನ್ನ IS ಫ್ಲಾಗ್ ಹಾಕಿದೀವಿ ನೋಟ್ಬುಕ್ ಮಾಡ್ತೀವಿ.
ಅವರ ಈಸ್ ಅಡ್ವೊಕೇಟ್ ಹತ್ತಿರ
ಅವರು ಅಶ್ವಥ್ ನಾರಾಯಣ್
You said that they are not pending. Correct. Pending is dispose ಆಗಿದೆ. IA1 and section 2. But number is pending. Date. What is the date of order? 39. 39. He has instructions to submit that same has been paid to the respondent workman till August 2021. Or same clarified from respondent workman. It's therefore necessary that petition place and record the material information. And thereafter, till August 2021. Okay. The application is disposed of anta helilla. So you had sought here August 2021 ವರೆಗಿನ ಕೇಳಿದ್ರ ನೀವು ಇದರಲ್ಲಿ direct the petition aforesaid last on ways per month with effect of 30 days from the date of publication of order 15/10/2018. All workmen till challenge to the award is finally decided. So illa ನೀವು we had sought till the final disposal. So
particularly till final disposal because we were not paying regular salaries.
So this is to be heard now.
ಅದರಲ್ಲಿ current salary current wages ಕೊಟ್ಟಿದ್ದಾರೆ subsequently they are paying salary regularly.
So now this will not survive on the
And does
disposal.
not survive consideration.
Both sides are with that the arrears of wages under section 17B was paid up to date till 4/10/2021 and thereafter the same is being paid. Therefore, this application does not survive for further consideration and disposed of accordingly. The orders on IA number 1 of 2020. Now IA 2 of 1 of 2021 is also pending.
Section 17.
First one is also section 17B only.
First 17B, they paid only part of the amount. Few facts are just
Okay, this is said that this court please to clarify the interim order dated 14/2/2020.
14/2/2020, this honorable court was pleased to pass an order directing him to pay back wages and also reinstate them within 2 weeks. They have not reinstated me within 2 weeks. I filed several applications. Again,
Now,
on
as on today, they is
they are reinstated. I have been working on 15/10. So let me 15/10 now. They get interested in work interest
So,
order.
ಇದು application survive ಆಗೋದು 15
These dates are important. 14/2/2020.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಪ್ರೇಯರ್ ಇದ್ದದ್ದು ಈ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ಓನ್ಲಿ ಫಾರ್ ರೀಇನ್ಸ್ಟೇಟ್ಮೆಂಟ್. Honorable court please to clarify the interim order dated in the above petition in order to reinstate these 24 workmen directly under the petitioner. Okay, what is the order dated 14/2/2020? We'll see. Maybe just confusion ke
This application can be considered final year. This application.
Few facts are just
Final year because they are seeking for reinstatement.
14/2/2020.
14/2/2020. Okay.
Just need to fill up their
One second. 14/2/2020 order 1611. 14/2 ಯಾವುದು ಡೇಟ್ ಆರ್ಡರ್ ಇದ್ದಾಗಿಲ್ವಲ್ಲ? ಸಿ 17/2 2020 ಇವು 2 ವರ್ಷದ ಹಿಂದಿನ ಆರ್ಡರ್ ಹಾಗಾದ್ರೆ ಅವ್ರ ಎದುರಿಗೆ ಹೋಗ್ಬೇಕಲ್ಲ. So if at all you want clarification, you should go before the same bench.
What's the serial number? What's the cost?
14/2/2020. Hard serial.
Subsequently, they filed an application for release of funds. In obedience with that order, we release the amount by seeking the particular bank details for it because the respondents here are not direct workmen. It is this Hanga. So a direct workman, the bank account deposit master. Now, what's their claim is for a period of 7 months.
Again, the order was to deposit the arrears of wages under section 17B of the Act relating to 24 workmen till date. Petition shall reinstate the workman with the applicable wages to the gangman paid at the time of the alleged termination, subject to result of the petition. Then, any clarification?
Within a period of 2 weeks. This order was passed on 14/2/2020. Within 2 weeks, they have not deposited amount, not reinstated me. I filed an application. Several applications that took time and effort. On 29/9/2020, this honorable court passed an order. That is order 29 September 29/9/2020.
If this matter is going to take some time, we'll adjourn it because we have already adjourned the connected matters. 2:30.
This is different.
ಇಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಇಷ್ಟು ಡೀಟೇಲ್ ಹಿಯರಿಂಗ್ ಬೇಕು ಅಂದ್ರೆ ನಾವು ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಆಮೇಲೆ ತಗೊಳ್ತೀವಿ. ಯಾಕಂದ್ರೆ ನೀವು ಬರೀ ಮೇನ್ ಮ್ಯಾಟರ್ ಡಿಸ್ಕಸ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋದು ಬದಲು at a certain intervals we go on passing orders and
nearly 40 lakhs.
ಆಯ್ತು ಅದನ್ನು if you are entitled you recover it. There is an order.
Yes, 17 pages mandate the law that they can't post for it.
ಕರೆಕ್ಟ್. ನೋಡಿ ನಮ್ಗೀಗ 230ಗೆ ಅಲ್ಲಿ ಸುಬ್ಬರಾವ್ ಅವರು ಮೊನ್ನೆನೂ ಒಂದ್ಸರಿ ಹೇಳಿದ್ದಾರೆ ನಮ್ಗೆ ಮ್ಯಾಟ್ರ್ ಇಲ್ಲಿಲ್ಲ ಅವ್ರು ಅಲ್ಲಿದ್ದಾರೆ ಆನ್ಲೈನ್ 230ಗೆ ಲಿಸ್ಟ್ ಮಾಡಿ ನಮ್ ಮ್ಯಾಟ್ರ್ ತಗೊಳ್ಳೋದಿಲ್ಲ ಅಂತ ಹಿಂದೆ ಒಂದ್ಸರಿ ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದಾರೆ ನಮ್ಗೆ. ನೀವು ಡೇಟ್ ನಮಗೆ ಉಳಿದಿದ್ವಲ್ಲ 24/5 ಅಂತ ಕೊಟ್ಬಿಟ್ವಲ್ಲ. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ವಿ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ IML ಇದೆ
2 of 21 ಮತ್ತೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್.
ನಿಮ್ಮ IML ಅಬ್ಜೆಕ್ಷನ್ ತರ ಇದೆ ಅಂತ ಏನು ನಮ್ಮ ಲಿಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ ಇದು ಎಷ್ಟು? ಸೀರಿಯಲ್ ನಂಬರ್ 12.10 IA2 rectification of office objection on IA2 of 2021 and statement of objection filed by advocate for R1. ಅದರ ಮೇಲೆ IA2 of 2021 ಮೇಲೆ ಏನೋ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಕಾಪಿ ಸರ್ವ್ ಆಗಿದೆ ಅಲ್ವಾ ನಿಮ್ಗೆ? ಹಾಗಾದ್ರೆ ಸರ್ವೈವ್ ಆಗೋದಿಲ್ಲ ಅದು. ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ನಲ್ಲಿ ಅಫಿಡವಿಟ್ ಹಾಕಿಲ್ಲ ಅಂತ ಯಾರು ಹಾಕಿರೋದು? ನೀವು ಹಾಕಿಲ್ಲ ಅಂತ. ಸೊ IA1 ಕಾಪಿ ಸರ್ವ್ಡ್. IA2 of 2021 is filed by ಸರಿ ಅದು counsel for the petition submits that the copy of IA2 of 2021 is served on. Therefore the said objections do not survive for further consideration. Statement of objection ಮೇಲೆ objection comply ಮಾಡಬೇಕಲ್ಲ.
But IA ಏನು not proceed regularly can be controlled.
ನಾವೇನ್ ಕಂಟ್ರೋಲ್ ಮಾಡೋದಿಲ್ಲ. ಅಫಿಡವಿಟ್ ವೆರಿಫೈಯಿಂಗ್ ಅಫಿಡವಿಟ್ ಹಾಕ್ಬೇಕಲ್ಲ ನೀವು. 4 weeks time is granted to ಯಾರ್ದಾರ ಹಾಕ್ರಿ ಮೆಮೊರಾಂಡಮ್ ಹಾಕ್ರಿ ಏನಾದ್ರೂ ಫೈಂಡ್ ಮಾಡಿ. 4 weeks time is granted to comply the office objection on statement of objection of respond number 1. List on 24. ಒಟ್ಟಿಗೆ ಬರ್ಬೇಕು ಬಟ್ ಎಲ್ಲಾನು ಏನಂದ್ರೆ ಕನೆಕ್ಟ್ ಮಾಡಿಸ್ಕೊಂಡು there were so many problems. ಈ ಮ್ಯಾಟರ್ಸ್ ಡಿಸ್ಕನೆಕ್ಟ್ ಅವೇನು ಬೇರೆ ಕೇಸಸ್ ಇದೆ ನೋಡಿದ್ವಿ ಹಿಂದಿನ ಬೆಂಚ್ ನವ್ರು ಮಾಡಿದ್ವಿ. ಬಟ್ ವೆದರ್ ದಿಸ್ ಮ್ಯಾಟರ್ಸ್ ಇನ್ನೊಂದ್ಸರಿ ಬಂದಾಗ ಹೇಳ್ಕೊಳ್ಳಿ. ನಾವೀಗ ಬರೀ ಮಿಸ್ಲೇನಿಯಸ್ ಕ್ಲರಿಕಲ್ ವರ್ಕ್ ಮಾಡೋದಕ್ಕೆ ಟೈಮ್ ಅದೇನಾರು ಇರ್ಲಿ ನೆಕ್ಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಮಾಡಿಸ್ಕೊಡ್ರಿ. ಮಾಡಿದ್ರೆ ನಮ್ಮಲ್ಲಿ ಹೋಗಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ ಹತ್ರ ಕಂಪ್ಲೇಂಟ್ ಕೊಡಿ ಈ ತರ ಮಾಡಿದ್ದಾರೆ ಅಂತ. ಆರ್ಡರ್ಸ್ 230 ಅವ್ರು ರೆಡಿ ಅನ್ನೋರಿಗೆ ಬೇಡ. 230 ಏನ್ ಮಾಡ್ರಿ ತಗೊಳ್ಳಿ.
Lord, one submission, serial number 32 in B group, my lord. If it, I wanted a yes, serial number 32. If it is adjourned, my lord, then otherwise I'll.
It is not adjourned. You are part petitioner.
Yes, I am.
You want adjournment? You want adjournment?
Not. I mean, it could be taken up on 11th, my lord, because if 230 matter is taken up, it is the reason.
As requested, list on
11/4.
11/4. Only.
Obliged.
Orders 230, number 34, Dinisha Kabhi.
ಎಸ್ ಏನ್ ಹುಡುಕೊಂಡು ಬಂದ್ರು? ಆಯ್ತು. NI Act 362 ಏನು ವಾಟ್ ರಿಸರ್ಚ್ ಯು ಕಂಡಕ್ಟೆಡ್?
One case there is a technical problem is there, not that whether compromise can be had after the conviction. In another case, it's still the conviction is pending.
What is that other case? 495 against the same order.
There are two cases, two proceedings. Two conviction cases. The other case is a matter of not pending.
ಇದರಲ್ಲಿ ನಾವು ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರೆ ಇನ್ನೊಂದನ್ನ ನಾವು ವಿ ಆರ್ ಆಲ್ಸೋ ವಿಲಿಂಗ್ ಟು ಡೂ ದಟ್ ಶೋಸ್. ಯಾಕಂದ್ರೆ ಈ ತರ ಯಾವ್ದಾರ ಒಂದಾದ್ರೆ ಮೆನಿ ಮ್ಯಾಟರ್ಸ್ ವಿಲ್ ನಾಟ್ ಗೋ ಟು ದ ಅಪೀಲ್. In the second matter, you want us to record the settlement? $495. Very silly that. This HK Ismail and VB Wonkar. It's also against the order of conviction. Just one of the simple imprisonment of 6 months. Fine of rupees 2,01,000. ಎಲ್ಲಿದ್ದಾರೆ ಪಾರ್ಟಿಸ್? ಎಲ್ಲಿದೆ ಜಾಯಿಂಟ್ ಮೆಮೊ? ಇಲ್ಲ ಜಾಯಿಂಟ್ ಮೆಮೊ ಇಲ್ಲ. ಜಾಯಿಂಟ್ ಮೆಮೊ ರೆಡಿ ಇಲ್ವಾ? ಜಾಯಿಂಟ್ ಮೆಮೊ ರೆಡಿ ಇಲ್ವಾ? ಫೈಲ್ ಮಾಡಿ. ಇಲ್ಲ ಫಾರ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಇದೆ. You said the parties are settling the matter.
6 ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಹಾಕಿದ್ದಾರೆ.
496 ಡಿಸ್ಪೋಸ್ ಆಗಿರೋದಲ್ಲ. 496 maintainability of fire to set aside the sentence. ಆಯ್ತು, ಅದ್ರಲ್ಲಿ ಏನ್ ಹುಡುಕಿದಿರಿ ಹೆಗಡೆ? ಏನ್ ಹುಡುಕಿದ್ರಿ ಅದ್ರಲ್ಲಿ? ವಾಟ್ ಡಿಡ್ ಯು? No, see, in 495 I have not filed any memo. ಇವತ್ತು ಯಾಕೋ ಎಲ್ರದ್ದು ಬರೀ ನಮ್ಗೆ ಕ್ಲರ್ಕಲ್ ವರ್ಕ್ ಮಾಡಕ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ. 496 have to satisfy whether we can exercise that power after disposal of the case. The other one is 6438. ಅದೇನು ರಿಗಾರ್ಡಿಂಗ್ ಮೆಂಟಲ್ 482 ಹಾಕಿದ್ದೀರಾ? So connected to 496. So you are seeking quashing of the order of this court in the hands of this court. ಅದನ್ನ ತೋರಿಸಿ ಅಂತ ಕೇಳಿದ್ವಿ ನಾವು. ಮಾಡಿದ್ರೆ ಎವ್ರಿಥಿಂಗ್ ಬಿಕಮ್ಸ್ ಈಸಿ ಫಾರ್ us. ಯಾರು ಕಂಪ್ಲೇನೆಂಟ್ ಅಲ್ಲ, ಕಂಪೌಂಡ್ ಮಾಡ್ಕೋಬೇಕಾದ್ರೆ ಇರ್ಬೇಕಾದವ್ರೆ ಕಂಪ್ಲೇನೆಂಟ್. ಅಕ್ಯೂಸ್ಡ್ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೂ ಕಂಪೌಂಡ್ ಮಾಡೋದು. ಮತ್ತೆ ಇವ ಇಷ್ಟೊತ್ತಿನವರೆಗೂ ಯಾಕೆ ಹೇಳಿರ್ಲಿಲ್ಲ? ಬೆಳಿಗ್ಗೆನೂ ಹೇಳಿಲ್ಲ. ಏನಿದೆ ಅವ್ರ ಐಡಿ ಪ್ರೂಫ್ ಎಲ್ಲ ಏನಿದೆ? ಆ ಕೇಸಲ್ಲಿ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕಿದೆನಾ? $495. Petitioner and respondent are present. Petitioner, respondent, and their respective counsels and their counsel are present. The parties are duly identified by their counsel. ಅವ್ರ ಹತ್ರ ಸಿಗ್ನೇಚರ್ ತಗೊಂಡು ಒಂದು ಮೆಸೇಜ್ ಮಾಡಿಸ್ಕೊಡ್ರಿ. ಬಿಕಾಸ್ ಕಂಪ್ಲೇನೆಂಟ್ ಹ್ಯಾಸ್ ಟು ಕಂಪೌಂಡ್ ದ ಮ್ಯಾಟರ್. ಅವ್ರದ್ದು ಮೆಮೊ ತಗೋಬೇಕಾಗುತ್ತಲ್ಲ, ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾವ್ ಹೇಗೆ ಕಂಪೌಂಡ್ ಮಾಡಕ್ ಬರುತ್ತೆ? ಮತ್ತೆ ಈಗ ಅವ್ರು ಕಳ್ಸಿದ್ರೆ ನೀವ್ ಹೇಗೆ ಮೊದಲು ಬ್ಲಾಂಕ್ ಪೇಪರ್ ಮೇಲೆ ಸೈನ್ ತಗೊಂಡು ಟೈಪ್ ಮಾಡಿಸ್ಕೊಂಡ್ ಬರ್ತೀರಾ? ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ, ಹಂಗಂದ್ರೆ ಮಾಡಿಸ್ಕೊಂಡ್ ಬನ್ನಿ. ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ, ಮಾಡಿಸ್ಕೊಂಡ್ ಬನ್ನಿ.
Hearing the Supati, number 35, Somshekar, HKM.
I appear for the respondent, my lord. My lord, before my friend starts, I have already filed some authorities
I just wanted to bring to your lordship's kind notice on that day. I did not bring it to your lordship's kind notice. Please, I'll take only 10 minutes before my learned friend starts.
Authorities are submitted.
I have submitted, my lord, on 16/3/22.
Yes.
16/3
Yes, ಕೊಟ್ಟಿದ್ದೀರಾ? Yes, we got them.
ಅದರಲ್ಲಿ one point, my lord, which on that day, I should have brought your lordship's notice. My learned friend contended that he is not a concerned workman.
Please accommodate us for 1 minute.
Yes, sir.
Signature. Scan ಮಾಡಿ ಮತ್ತೆ ಕಳಿಸಬೇಕು.
Yes, sorry. Yes.
With your lordship's kind leave, my lord, one argument, my lord, which my learned friend addressed on that day, he filed the application with abundant caution. Your lordship may kindly recollect, because he is not a concerned workman under section 33(1)(a). Now please see, my lord, the ID Act. Please see that's what his argument was. In regard to a matter, that is, my lord, what he says is, matter, that is workman, he should be a concerned workman. In B, during the pendency of, this is, my lord, workman concerned. A, your lordship has got it.
Yes.
He said, I am not a concerned workman. Similarly, in B, subsection 2, please see, during the pendency of any such proceeding, in respect of an industrial dispute, the employer may, in accordance with the standing orders applicable to a workman concerned in such dispute. So his emphasis is that he is not a concerned workman. Therefore, he was not obliged to file the work. And with abundant caution, my lord, he filed it. Your lordship may kindly recollect. This argument, my lord, is fallacious on the very face of it, because concerned workman, the earlier dispute was in respect of my case alone. Who else can be a concerned workman? That dispute also pertains to me. My termination, my severance of a status, which I questioned. Your lordship may kindly see. This question has been answered by a lordship's, my lord, of the Supreme Court a long time back. And it's rather surprising that an argument of this should be addressed. Anyhow, please see, my lord, I have produced that authorities your lordship has got. That is New India Motors Private Limited versus KT Morris. 60 AIR 8075. That please see. This is a judgment of 3-judge bench. Justice K.C. Gupta, Gajendra Gadkar,
Serial
and
number?
Vanchu.
Serial number?
ಅದೇ ಫಸ್ಟ್ ಕೇಸ್ ನೋಡಿ.
ಫಸ್ಟ್ ಕೇಸ್ ಇಸ್ ವೆಟ್ಲ್ಯಾಂಡ್ ಟರ್ಕಿ. ಫಸ್ಟ್ ಕೇಸ್ ಇಸ್
ಫಸ್ಟ್ ಇದೆಯಲ್ಲ, ಫಸ್ಟ್ ಅಲ್ಲೇ ಇದೆಯಲ್ಲ, ನ್ಯೂ ಇಂಡಿಯಾ ಮೋಟರ್ಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್. ಫಸ್ಟ್ ಪೇಜ್ ನೋಡಿ. ಇದು ಇದು ಅಥಾರಿಟೀಸ್ ಯಾವತ್ತು ಅಂತ ಹೇಳಿದ್ರೆ 16/3 ನೋಡಿ.
16/3 ಕೊಟ್ಟಿದ್ದೀವಿ. 16. ಯು ಹ್ಯಾವ್ ಗಿವನ್ 2 ಕಂಪೈಲೇಷನ್.
16/3 ಒಂದು
ಕರೆಕ್ಟ್. On 16th we have given 2 compilations.
Possible.
2022 or 2022 and 2021. Yes.
I am on New India Motors Private Limited.
Yes.
Your Lordship got it. Now, my Lord, I am only invite your Lordship's attention to only the argument addressed is, my Lord, at page 4.
Yes.
Paragraph 4, my Lord. It has, however, second paragraph.
Yes.
Yes. It has, however, been argued before us by the appellant that the complaint made by the respondent under section 33A is not competent. It is common ground that a complaint can be made under section 33A only if a section 33 has been contravened. And so the appellant's argument is that the 33(1)A is inapplicable because the respondent was not concerned in the main industrial dispute, and as such, his dismissal cannot be said to be to contravene the provisions of the said section. Indeed, the principal point urged before us by the appellant is in regard to the construction of section 33(1)A of the Act. Was the respondent a workman concerned with the main dispute, industrial dispute? That is the point of law raised for our decision, and its decision depends upon the construction of the relevant words used in section 33(1)A. Section 33(1)A, as it stood prior to the amendment of 1956, provided inter alia, and during the pendency of any proceedings before a tribunal, no employer shall alter to the prejudice of the workman concerned in the said dispute the conditions of service applicable to them immediately before the commencement of the said proceedings, save with the express permission in writing of the tribunal. Section 33 has been modified from time to time, and its scope has been finally limited by the Amendment Act of 1956. With the said amendments, we are, however, not concerned. The expression, the workman concerned in such dispute, which occurred in the earlier section, has not been modified, and the construction which we would place upon the expression under the unamended section would govern the construction of the said expression, even in the amended section. What does the expression workman concerned in such dispute mean? The appellant contends that the main dispute was in regard to the discharge of 7 workmen, 7 apprentices employed by the appellant, and it is only the said 7 apprentices who were concerned in the said dispute. The respondent was not concerned in the said dispute, and so the termination of the services cannot attract the provisions of section 33(1)A. Prima facie, the argument workman concerned in such dispute should be limited to the workman directly or actually concerned in such dispute appears to be plausible. But if we examine the scheme of the Act and the effect of the material and relevant provisions of this limited construction of the clause in question cannot be accepted. Let us first consider the definition of the industrial dispute prescribed by section 2K. It means inter alia, any dispute or difference between the employers and the workmen which is connected with employment or non-employment or terms of employment or with the conditions of labor of any person. It is well settled that before any dispute between the employer and his employee or employees can be said to be industrial dispute under the Act, it must be sponsored by a number of workmen or by a union representing them. It is not necessary that the number of workmen of the union that empowers the dispute should represent the majority of them. Even so, an individual dispute cannot become an industrial dispute at the instance of so and so. This aspect of the matter, now 2A has come in. Your Lordship may kindly see section 2A, there is a deemed industrial dispute. Even an individual workman pertaining to his termination, he can now raise a dispute. When he raises that dispute, my lord, it becomes an industrial dispute. Your Lordship may kindly say section 2 capital A. I will invite your Lordship's attention but your Lordship is familiar with that. Section 2 capital A. ಇದು ಜಡ್ಜ್ಮೆಂಟ್ ಆ 2A ಬರುವ ಮುಂಚೆ ಇದು ಬರೆದದ್ದು, but the principles of law, my lord, do not change.
Yes.
2A, it's a deemed dispute.
Yes.
Now, adalli matte section 18. I'll just read, my lord, it's not much, 2 or 3 paragraphs. That's it clinches the whole issue. Section 18 of the Act is also relevant for this purpose. It deals with the persons on whom awards are being made binding. Section 18(3) provides, inter alia, that if an award of a tribunal which has become enforceable shall be binding on all parties to the industrial dispute or all other proceedings to appear. Tribunal records and the opinion
There is some problem with your connectivity.
referred to in clause A or clause B is composed of workmen, all persons who are employed in the establishment or part of the establishment as the case may be, to which the dispute relates to, the date of the dispute, and all persons who subsequently become employed in the establishment or part. It is thus clear the award passed in an industrial dispute raised even by the minority union binds not only the parties to the dispute, but employees in the establishment as a part of the establishment. Is important. Even a minority, as in the case may be, the date of the dispute, and even those who may join the establishment or subsequently. Thus, the circle of persons bound by the award is very much wider than the parties in the industrial dispute. This aspect of the matter is also related to the construction of the material words in section 33A. In this connection, the object of section 33 must be also borne in mind. It is plain by enacting section 33 of the legislature wanted to ensure a fair and satisfactory inquiry of the industrial dispute undisturbed by any action on the part of the employer or employee which would create fresh cause of action, fresh cause for disharmony between them during the pendency of an industrial dispute. Status quo should be maintained and no further element of discord should be introduced. That being the object of section 33, the narrow construction of the material words used in section 33A(1) would tend to defeat the said object if it is held that the workmen concerned in the dispute are only those who are directly or immediately concerned with the dispute, it would leave the liberty to the employer to alter the terms of conditions of remaining workmen, and that would inevitably introduce the complications, which it intended to avoid. Similarly, it would leave liberty to the other employees to raise disputes. That again is not desirable. That is why the main object underlying section 33 is inconsistent with the narrow construction sought to be placed by the appellant on the material words used in section 33A. Even as a matter of construction, pure and simple, there is no justification for assuming that the workman concerned in such disputes must be workman directly or immediately concerned in all the disputes. We do not see any justification for adding the further qualification. The further qualification of immediate concern, which the narrow construction necessarily assumes in dealing with the question to whom the workman can be said to be concerned in industrial dispute. We have to bear in mind the essential condition for raising the industrial dispute itself. And if an industrial dispute can be raised only by a group of workmen acting on their own through their union, and it would be difficult to resist the conclusion that all those sponsored by the dispute are concerned in it. As we have already pointed out, in this construction is harmonious with the definition of section 2S and with the which contained in section 18 of the Act. Therefore, we are not prepared to hold that the expression workman concerned in such a dispute can be limited only to such workmen, who are directly concerned with the dispute in question. In our opinion, the expression includes the workmen on whose behalf the dispute is raised, as well as those who would be bound by the award which may be made in the said dispute. Now, my lord, the other thing is not necessary. Now, my lord, this decision also has been followed in the decision of the Kerala High Court in Dalmia, that is serial number 5, my lord. I am not going to read it. Serial number 5. This decision, my lord.
When you are relying on the Supreme Court judgment, why are you relying?
Yes, sir, that is why, my lord, I am guarding myself, my lord, before your lordship.
No, why did you submit also that? This is.
ಅಲ್ಲಲ್ಲ ಅದೇನು ಹಾಕಿದ್ದಾರೆ ಇಲ್ಲಿ ಅಂತ ಅಷ್ಟೇ. ಮತ್ತೆ ಇನ್ನೊಂದು ಡಿಸಿಷನ್, ಇನ್ನೊಂದು ಕಂಟೆನ್ಷನ್ ಮಿಲಾಟ್ ದಟ್ he has said is, I have filed it with abundant caution ಅಂತ. ಅದಕ್ಕೆ there is a principle of law, my lord, in that is jurisprudence, that you cannot blow hot and cold. That is, my lord. Or in other words, you cannot approbate and reprobate. Your lordship may kindly see that principle, my lord. I have cited a decision before your lordship in, that is, R.B.R. Deshpande versus that is, my lord, Balram Haibatti, page 16, my lord.
Page 16 is the same compilation.
ಹೌದು.
What is ಏನದು? Parties name?
ಪಾರ್ಟೀಸ್ ಹೆಸರು ಇಟ್ಟಿದ್ರಮ್ಮ. ಇದು ಪಾರ್ಟೀಸ್ ಹೆಸರು B.R. ದೇಶಪಾಂಡೆ. P.R. ದೇಶಪಾಂಡೆ ವರ್ಸಸ್ ಮಾರುತಿ ಬಲರಾಮ್ ಹೈಬಟ್ಟಿ. 16ನೇ ಪೇಜು.
Yes, got it.
Then first thing.
Yes.
Last paragraph, my lord, at page 11, 16, the preliminary objection. Last paragraph.
Yes, got it.
The preliminary objection raised by the learned counsel for the respondent is that the tenant is precluded from approaching this court under Article 136 of the Constitution after giving the aforesaid undertaking before the High Court in support of the said objection. The learned counsel cited the decision of this two-judge bench of Justice Jayathan Reddy and Justice Agarwal, so and so. By furnishing the undertaking, the petitioner elected to avail the protection from eviction from the premises, and he enjoyed the said protection till passing of the order by the Supreme Court on staying dispossession of the petitioner. Having done so, the petitioner cannot be permitted to invoke the jurisdiction of the High Court, Supreme Court, under Article 136 of the Constitution and assail the said judgment of the High Court. Learned judges found support to the said view from the three decisions of this court rendered in the benches of Vidhi Shankar versus Hirlal, then Ramachandra Jain versus so and so, then my lord Thakkar versus Hariram Motiram versus Balakrishnan, so and so. In all these three decisions, Justice Sabyasachi Mukherjee, speaking for the bench, adopted a uniform approach that wherever the merits of the case, it would not be proper after such an undertaking was given in the High Court and a time was taken on the basis of such an undertaking, so and so. Relying on these decisions, Justice Agarwal, speaking for the two-judge bench, law does not permit a person to both approbate and reprobate. The principle is based on the doctrine of election, which postulates that no party can accept and reject the same instrument, and that a person cannot say at the one time that the transaction is valid and thereby obtain some advantage to which he could only be entitled to the footing that it is valid, and then turn around and say it is void for the purposes. A passage from the Halsbury's Laws of England was cited by the learned judges, so and so. Then, my lord, the following observations made in the reference, so and so. Then, my lord, I think after, my lord, they have referred to various decisions of the English courts. I think I should not trouble your lordship at this stage. That is Lord Atkin and my lord, various other decisions. I think, of course, to read, of course, it will improve our English language, but my lord, I do not want to waste the time of the court. I'm only relying upon, my lord, the principle that is it is only
election and
purpose
of estoppel.
Yes. It is one aspect of the estoppel, my lord. Then, my lord, one more decision in that is Dhanoha versus Municipal Corporation. This is, my lord, the question, my lord, that arose for these cases. One argument, my lord, my learned friend said is that Deputy Director of Education, he went and visited the school and prepared a report. Your lordship may kindly see. He relies upon that document to prove that the certificate which I have produced is not correct. Of course, even though he speaks about subsequent events than before when I left the school, apart from that, on the question of law, my lord, I want to say, even if a public servant discharges a duty, he can only, my lord, it can be a duty which is bound under law to discharge. If he performs a private duty, which has nothing to do with that. Now, my lord, he is not called upon by law. Some person asks him to go and visit and give a report. That does not become, my lord, a public document. This question, my lord, has been considered. My lord, here, whether an IAS officer, this page, 21, page 21.
Yes, sir.
Please take page 21, my lord.
Yes, I got it.
Yes, yes. The question is, whether, my lord, the question that arose was, a public servant, when the grant of permission, that is, my lord, to prosecute under section 197. That is how, my lord, the question that came up for consideration before their lordships. This is what they say. Public servant services of an officer belonging to the administrative service lent loan to a cooperative society prior to the approval of the central government under section 97 if required for prosecution under the prevention of food and adulteration of officer whenever a public servant within the meaning so and so. Penal clauses. Here, my lord, he, please see the head note. The services of the appellant, a member of the Indian Administrative Service, were placed at the disposal of the Cooperative Stores Limited for being appointed as the central manager of the super bazaars run by the cooperative stores. On a complaint being filed against the appellant for commission of the alleged offense, punishable under section 7, read with section 16 of the Prevention of Food Adulteration. 54, before the Metropolitan Magistrate Delhi, the appellant contended that he was a public servant within the meaning of clause 12 of section 21 of the Penal Code. That act complained of was done by him in the discharge of duties of a public servant, and that since, as required by section 197 CRPC, the previous sanction of the central government has not been obtained, the court was not competent to take cognizance of the offense. The magistrate rejected all these contentions. He held that the appellant could not be regarded as a public servant within the meaning of clause 12 of section 21, and that at the relevant time he was neither in service or pay of the government, nor he was employed in connection with the affairs of the union. What he has to do is, he must be discharging the duties in connection with the duties of the affairs of the union or the state government of the union. The High Court on appeal upheld the view of the magistrate. Before this court, it was contended that the terms corporation used in the 12th section of the section 21 is wide enough to include not merely a statutory corporation, but also a body corporate such as cooperative stores established under the State Act like the Bombay Cooperative Societies Act 1925, and that as a general manager, he was employed in connection with the affairs of the union by reason of the fact that the central government had advanced a huge loan to the society for carrying on commercial activities, dismissing the appeal. Then, my lord, these contentions were all rejected. Dismissing the appeal, mere incorporation held the appellant does not answer any of the essential requirements of clause 12 of section 21 of the IPC. He was neither an officer of the service or pay of the government, nor that of a legal authority, a corporation established by or under the act of the government company. Mere incorporation of a society under the Central or the States Act does not make a body corporation within the meaning of the clause section 21 of the expression corporation must in this context mean a corporation created by the legislator and not body of the society, brought into existence by an act or a group of individuals. A cooperative society is therefore not a corporation established, so on and so forth. I don't want to read further. I only submit that this was a private visit only to oblige this massive organization, my lord, that you oblige and give that report. So no reliance, my lord, that can be placed upon that. My submission to your lordship is that I have, my lord, I have submitted and I do not want to repeat. And my lord, as far as Michael's case is concerned, which I have is there, I have, in my main arguments itself is I have submitted that is hitting the below the belt and trading legal phrases is not industrial law. I may not, I buy, that is the sum and substance of the case, this present case, my lord. Much obliged to the court.
My lord, before I go to the reply, my lord, the first thing is KT Morris versus New India Motors, my learned friend, referred, my lord, your lordship's first judgment in the list dated 16/3/22. That judgment is in my favor, therefore I just refer to that, my lord. Because senior is relying on that, it is just, therefore, you'll have to kindly say, para 1 of the judgment, my lord, about few sentences before para 2, my lord, about 8 sentences. KT Morris, New India versus KT Morris, my lord. Just about 10 sentences before the para 2, my lord. Because the paras, I mean, the pages are not.
Pages are not correct.
For me, what is given to me, my lord, because they gave me only the list. I have taken this judgment from other sources. Therefore, it may not tell. Before para 2, my lord, before the tribunal, the appellant urged. Before that, my lord, the first previous para.
Para starts as?
Before the tribunal, my lord, is the second para, but before that 10 sentences.
So in this case, that is 1. Yes, before the
You last me kindly see the first para, the appeal by special leave, but last 10 sentences I will rely on that. The judgment starts at this appeal by special leave.
And para 2 we got before the tribunal, the appellate.
Then previous to that 10 sentences. There is a date dated the 18th. The complaint was filed on July 18, 1956. Lordship got it, madam? Yes. Just 10 sentences. The complainant was filed on July 20th. The respondent invoked section 33 because his case was that at the time of his services were terminated, an industrial dispute was pending between the appellant. Industrial, you like me kindly see, this is not an individual dispute. An industrial dispute, this is very, very important, was pending between the appellant and 7 of his employees, and the respondent was one of the workmen concerned in the industrial dispute. It was not an individual dispute like the present one. the said industrial dispute had reference to the termination of the service of the said employees who were working in the appellant firm. Therefore, it was not an individual dispute, but an industrial dispute referred under section 2K for adjudication to the court. Now you last me kindly come to para 7, my lord, because para 7 starts in my judgment. Let us first consider the definition. Let us first consider the definition of industrial dispute.
Paragraph.
It has, however, at the start of one para, next section 33(1)A.
Yes.
Let us consider the definition. Just this para I will read. Let us consider the definition of prescribed 2K. You lot it is not 2A or 10(4)A or anything. It means inter alia any dispute or difference between
There is
the
no
employees.
fragment there. This let us consider. There is no fragment there.
Yes,
it is the continuation of section 33(1) as it stood anta ide alla allinda continuation ide. Alli paragraph.
Therefore, let us consider the definition of industrial dispute prescribed under section 2K. Last again, the 2K is industrial dispute. It means inter alia any dispute or difference between employers and workmen. It's plurality, not an individual workman. It is not workman, workmen, which is connected with the employment or non-employment or the terms of employment or with the conditions of labor of any person. It is well settled that before any dispute between the employer and the employee or employees can be said to be an industrial dispute. Your last mechanism is very important. 2K. Under the Act, it must be sponsored by a number of workmen or by a union representing them. It is not necessary that the number of workmen or the union, the sponsor of the dispute, should represent the majority of workmen. Then next sentence, even so, an individual dispute cannot become an industrial dispute at the instance of the aggrieved individual himself. In this case, what was pending when I filed the 32B was a MA, an individual dispute between Mayana and Vakaligara Sangha. It was not an industrial dispute under section 2K. Therefore, Supreme Court clearly says, even so, an individual dispute cannot become an industrial dispute at the instance of the aggrieved individual himself. In this case, it was only Mayana between Raju and me. There was no other workman. It was not a. It was a single dispute. I mean, individual dispute, not an industrial dispute. Now coming to the, therefore, other judgments, my lord, appropriate, reprobate, and all that, they are not relevant at all. Therefore, I am not going to refer to them. I leave it to my lord whether it is a relevant judgment to consider in this case. Now coming to the, my lord, the first case, my lord.
Yes.
The first and second cases, my lord, in the list, 33, 35 and 35.1 have been already answered. That is, first is a compulsory retirement order has been inferred after holding a domestic inquiry is valid, and therefore only prima facie case should have been looked into, but the court has looked into other aspects of the matter, and therefore it has to be set aside and the approval application should be granted. Then second application 35(1), second writ petition is 33C1, it is filed. It should have been filed under 33C2. We have paid the admitted amount, but because of DLC stated that to negotiate, we further agreed to pay another 4 lakhs. 4 lakhs admitted amount we had paid. Another 4 lakhs we agreed to pay because the DLC said, why don't you settle the matter? We wanted to settle, but he did not agree. He said, no, I want 15 lakhs, 17 lakhs, what he claimed. The third case is, my lord, I will just refer to that, 12,515 or 230, where domestic inquiry is challenged, my lord. Only that I will refer, my lord, now and complete my argument. 12,515 2013 may kindly be taken.
No. Yes.
Yes. 12,515 of 2013, my lord. Now the first reply is they have challenged the DA, validity of DA in this case, domestic inquiry, which is held to be legal and valid on the ground that the list of witnesses and documents not enclosed to the charge sheet. I concede to that point, my lord. Yes, it was not enclosed to the charge sheet. But whether it will render invalid, I will refer to some judgments also. You will not kindly see page 19 of the judgment. I mean, this writ petition, my lord. Page 19. My case is that we have furnished the list of documents and list of before commencing the evidence of two witnesses, AW1 and AW2. Page 19, page 19, my lord.
Yes.
But PO furnished the last parameter. PO furnished a list of documents and witnesses in the sixth sitting of the inquiry held on 24/4/2007. Copies of the said documents were handed over to the CSE under acknowledgement. The CSE, through a letter dated 11/4/2007, had made false allegations against me that he had not mentioned the name of Mr. Puttaswamy as his co-employee, but the same was recorded on my own. However, the CSE in the seventh sitting of the inquiry held on 34/2000 had apologized for having made the said false allegation and requested to ignore the same. Next is important. PO had also furnished additional documents during the course of inquiry. Copies of such additional documents were also handed over to the CSE under acknowledgement. So therefore, it is not a case as though before commencement of the evidence being the domestic inquiry, I had not enclosed. My humble submission is, before commencement of the evidence in the domestic inquiry, list of documents, additional list of witnesses were given, and in his presence, witnesses were examined, these documents were marked. Therefore, it does not render the domestic inquiry invalid because of the reason. I will just rely on the 2-3 judgments. What the Supreme Court is now stating is, yes, there may be some technical violations, but what prejudice is caused by not furnishing that at the time of charge sheet thing is looked into, my lord. Today, my lord, I have sent the list of authorities, my lord.
Written arguments. Have you submitted the synopsis of your arguments?
What?
Have you submitted a synopsis of the arguments, both of you?
No, madam. I will say if your lordship require, I will.
Citation.
Citations, madam. Today I have filed citations.
No, citations is there. Which citation you are referring? In which context?
I think a list of witnesses and documents. If it is not enclosed to the charge sheet, if it is submitted subsequently, the workman should show that it caused him prejudice. That is what the Supreme Court says. I am referring to 3 judgments. That means it is not a technical violation. Just it will make it the domestic inquiry invalid. But the workman should explain what prejudice was caused to him by not supplying it along with the charge sheet. That's what the Supreme Court says, that the technical violations will not render the domestic inquiry invalid or the disciplinary authority. On that, I have 3 judgments. I will refer it because the workman should show the burden shift to the workman. Once I show that I have furnished the list of documents, list of witnesses before the commencement of the inquiry, burden shifts to the workman to show that even then it caused him any hardship or prejudice. Important is prejudice.
Yes.
The first judgment is the State Bank of India versus Narendra Kumar Pandey. 2013 2 SCC 740.
Yes.
Para 12 in that matter at page 6, ink page 6, madam. Ink page 6, para 12.
Yes.
Para 6, page 6, ink page 6, para 12, madam.
Yes.
The first information pointed out by the High Court was that charge sheet did not mention anything about the documents or the witnesses whom it proposed to reply to the prove the charges, nor appended any list of documents or witnesses. The presenting officer had also, according to the High Court, failed to provide the list of documents and witnesses to the charged officer. Further, the High Court also pointed out that minutes of the proceedings would indicate that 48 more documents were produced before the inquiring authority, and the rest of the documents were permitted to be produced on 7/11. On 7/11, 34 more documents were produced and marked as 51 to 84. The High Court has also pointed out that no witness was examined by the bank in support of the charge, and hence to hold the charges relating to the government business branch proved was in fact a finding supported with no evidence. Then the relevant parameter at page ink page 8, para 21, Miller. Only relevant paras I will refer. Para 21 at page 8, Miller.
Yes.
The inquiring authority has examined each and every charge leveled against the charged officer, and documents produced by the presenting officer came to the conclusion that most of the charges were proved. In a departmental inquiry, the disciplinary authority is expected to prove the charges on preponderance of probability and not on proof beyond reasonable doubt. Reference may be made to the judgment so and so. The documents produced by the bank, which were not controverted by the charged officer, supports all the allegations and charges leveled against the charged officer. In a case where the charged officer has failed to inspect the document in respect to allegations raised at the bank and not controverted, it is always open to the inquiring authority to accept the same. Para 23, Miller. The High Court, para 23, Miller. The High Court, in our view, under Article 226 of the Constitution, was not justified in interfering with the order of dismissal passed by the appointing authority after a full-fledged inquiry, especially when the service rules provide for an alternative remedy appeal. It is a well-acceptable principle of law that the High Court, while exercising powers under Article 226 of the Constitution, does not act as an appellate authority. Of course, its jurisdiction is circumscribed and confined to correct an error of law or procedure error, if any, resulting in manifest miscarriage of justice and violation of principles of natural justice. Though other judgments are also to that effect, my lord, I will not refer, my lord. Now, the second point is, my lord, the authors of the documents are not examined. Authors of the document. For that, my lord, I have already referred to 2000. This is a public, both are public documents, madam. My friend saying that that officer is a government officer, he is a government employee. He has been requested by the department to come in, visit the school and give a report. He has given the report. To say that you will automatically in the judgment, my learned friend referred to, he IAS officer was posted to a cooperative society. Therefore, the Supreme Court has come to the conclusion a cooperative society officer is not a public servant. It is not so. He was an employee of the government. He was the assistant director of primary education who was in charge of all these primary schools in the whole state, not only for the Bangalore. Therefore, to say that, therefore, it's a public document. Therefore, that judgment is not. Therefore, I have relied on 2021 2 SCC Merit. I already referred para 13 Iqbal Basit case, where it is said that in a public document is produced, to rebut it, it is the burden shift to the employee to say that the document is not correct. Then, my lord, now in this regard, my learned friend has referred to Petland case, my lord. Petland case saying that the author should have, in that case, my lord, Petland, Turkey Red Cafe Red case, Petland, Turkey Red case of the Supreme Court, AR 1960 SC 106. In that case, my lord, it was a balance sheet, not a public document from a public officer. Here, the principal, the headmaster of the school writes a document, the assistant director of primary education writes a document. Therefore, both are public servants. In this case, balance sheet is a private document. Therefore, Supreme Court comes to the conclusion, unless the balance sheet, the auditor or the manager are examined who is well aware of it, therefore, if the authors of that private document, you will not forget it, balance sheet is a private document, not a public document. Therefore, in that case, it is referred, it has no relevance. Therefore, my humble submission is the author of the documents was not required to be examined. These are public documents. You will not make any say here in this case, he says, my father gave me this fake transfer certificate. He does not know where this school is, where his house he was. It does not explain anything. He doesn't know anything because his house is in Kumaraswamy layout. From his father had bought that house. He was in that house, which is the address, even the present address also is residing. How can you go to Munireddy Palya? Now, last week, there are a number of cases coming up before this honorable court producing the fake certificate. They should explain, well, how did you get it? Where did he say, my father gave me, I do not know. When he has not studied in the school, his father gives that certificate. Therefore, it is a public document. So therefore, the examining of those authors was not necessary. Now, we let me see these two aspects. The third argument in this respect of these two documents, Mellor, that is the list of witnesses and documents, and the authors are not examined. If Lordship holds against me, then domestic inquiry should be set aside. On these two grounds, if your Lordship does not accept my argument, it has to be set aside. Then, if your Lordship set aside this inquiry on this ground, what should happen? I will just request your Lordship kindly refer to the other writ petition, because only one para I will. 43643 of 2012. Just one para I will read on the page 120, Mellor. If the domestic inquiry is set aside by this honorable court, accepting the arguments of my learned friend on these two grounds, that is, the list of documents and list of witnesses is not given, the authors of the documents are not examined, therefore the inquiry is vitiated, the labor court was wrong in upholding such an inquiry, then my alternative submission is at page 120 of this judgment. I mean, the writ petition 43643 of 2012 may kindly be seen. 120, page 120, para 5.
Yes.
Mellor, I will not read the whole thing. Last sentence I will read, my last but one sentence in that page 120. However, Lordship gets it, Mellor?
Yes.
However, if for any reason this honorable comes to the conclusion that the inquiry held against the opposite party is not fair and proper, or that the report and findings submitted by the inquiry officer is perverse, the applicant reserves its right to lead evidence before this honorable court and justify the order of compulsory retirement to be issued to the opposite party. Therefore, on these two technical grounds advanced by my learned friend, if your Lordship holds that the domestic inquiry is to be set aside, then matter has to be remanded for me to lead evidence on the merits of the charges, which I have reserved. Now, in this regard, my lord, I refer to the judgment now that your Lordship has got the list of authorities today I have given, my lord.
See, both of you have given. One second, both of you have given several compilations.
Today, no, my lord. Just
you argued crisscrossing. ಒಬ್ರು ಮಾಡಿದಾಗ ಇನ್ನೊಬ್ರು ಮಾಡೋದೇನು? No, we are requesting you. Please submit the synopsis of your argument.
Yes, I will do it.
In which context you are relying on which judgment?
Within 2 days, I will submit. I will tell you. Just I will refer now, my lord. The today's, my lord, 33/2022. The first case I read to my lord. The State Bank of India was an
judgments are not in at one side. One adrallide, one idrallide.
No, I will give a gist of my the judgment and the comment, my lord. I will give it.
Yes.
No, page 44 of this today's list may kindly be seen, madam. Page 44.
Yes.
Bharat Forge Company versus ABS Dodge, madam.
Yes.
1996 4 SCC 374. Relevant para is para 7, my lord. At
Para
page
7.
46. At page 46. This is only to support my pleading, my lord, to page 120, 121 of the writ petition, that if the domestic inquiry is set aside, I should be given an opportunity to lead it. Para 7, my lord, at page 46. A domestic inquiry may be vitiated either for non-compliance of rules of natural justice or for perversity. Both I have pleaded in that para. Disciplinary action taken on the basis of a vitiated inquiry does not stand on a better footing than a disciplinary action with no inquiry. The right of the employer to adduce evidence in both situations is well recognized. In this connection, the reference may be made to the decision of this court in Workmen of Motipur Sugar Factory and State Bank of India, so and so, Louth Busing. The stage at which the employer should ask for permission to adduce additional evidence to justify the disciplinary action on merits was indicated by this court in Delhi Cloth and General Mills case. In Shankar Chakraborty's case, the contention that in every case of disciplinary action coming before the tribunal as a matter of law must frame preliminary issue and proceed to see the validity or otherwise of the inquiry, and then serve a fresh notice to the employer by calling him to adduce further evidence to sustain the charges. If the employer chooses to do so, by relying on the decision of this court in the case of Cooper Engineering, so and so, has not been accepted. The view expressed in Delhi Cloth General is that before the proceedings are closed, an opportunity to adduce evidence would be given if a suitable request for such opportunity is made by the employer to the tribunal, has been reiterated in Shankar Chakraborty's case after observing that on the question as to stage, as to when leave to adduce further evidence is to be sought for, the decision of this court in Chimdu has not overruled the decision of this court in Delhi Cloth. There is no dispute in the present case that before the closure of the proceedings before the tribunal, prayer was made by the employer to lead evidence in support of the impugned order of dismissal. Hence, denial of opportunity to the employer to lead evidence before the tribunal in order to dismiss it cannot be justified. I have made a plea, my lord. I have referred, yes, I have reserved my right. Then para 8, in that view of the matter, the impugned judgment cannot be sustained and the same is sustained. It will be open to the parties to reach such evidence as they deem proper before the inter tribunal where the matter is to be reheard. Since the proceeding is pending for a long, we direct that the proceedings before the tribunal should be completed as early as possible, but not beyond 6 months from the date of communication of this order. In order to expedite the proceeding before the tribunal, we direct the appellant Bharat 4 may lead for such further evidence as the said company may desire within a period of 2 months from today, and the workmen may also lead evidence if they so do within 1 month thereof. Therefore, my humble submission is, if your lordship accept the argument of a learned friend that not providing list of documents, list of witnesses along with the charge sheet, and that the authors are not examined, if the inquiry is set aside, my humble request is to kindly remand the matter for me to lead evidence before the tribunal. Now, the last question in this case, my lord, is regarding 1 month wage. That is also pleaded in this case. Regarding 1 month wage. Well, 3 dates I just give it. The accident happened to him on 10/2/90. 10/2/90, he suffered an accident where both his legs were injured, and he said that he cannot drive the vehicle. Therefore, compensation was also given. A challenge made in the High Court was also dismissed. The management challenge to that order, and therefore, from that day, he has not been driving the vehicle. He was dismissed on 24/4/90, my lord. 24/4/90. When the dismissal was pending, my lord, on 8/9/2000, we reinstated him. 8/9/2000, we reinstated him. After reinstatement, he was compulsory retired on 3/6/2008. From 8/9/2000 till 3/6/2008, he was not driving any vehicle. He was not doing any work. He used to come and sit idle. My senior counsel said, no, he has been given only 1,685, whereas other drivers, SDC, all other first division clerks, assistants have been given. He did not work, therefore only 1,685. The last done salary was being paid to him. Now page 104 and 105 of this writ petition may kindly be seen, my lord. The writ petition, my lord, 122515 of 2030.
Yes.
Page 104 and 105, my lord.
Yes.
Para 16 in page 104, my lord. ನಾನು ಆಡಳಿತ ವರ್ಗದವರ ವಿರುದ್ಧ ರೆಫರೆನ್ಸ್ 8496 ಪ್ರಕರಣ ದಾಖಲಿಸಿದ್ದೆ ಹಾಗೂ ಸದರಿ ಪ್ರಕರಣ ನಡೆಸಿದ್ದ ಸಮಯದಲ್ಲಿ ನನ್ನನ್ನು ಪುನರ್ ನೇಮಕಾತಿ ಮಾಡಿದರು. ದಟ್ ಈಸ್ ಆನ್ 8/9/2000 ವಿ ರೀಇನ್ಸ್ಟೇಟೆಡ್ ಇಟ್. ನನಗೆ ಕೊನೆಯದಾಗಿ ದಟ್ ಮೀನ್ಸ್ ಇನ್ ಜೂನ್ 2008 1628 ಸಂಬಳ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸಾಕ್ಷಿ ನನಗೆ 17,000 ಸಂಬಳ ಬರಬೇಕಾಗಿತ್ತು ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನನಗೆ NR 14 ಅಂದ್ರೆ ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಆದೇಶದ ಜೊತೆಯಲ್ಲಿ 1682 ಚೆಕ್ ಅನ್ನು ಕೊಟ್ಟಿದ್ದರು ಎಂದರೆ ಸರಿ. Now you last may kindly that he admits this is the evidence of the workman, my lord. Now you last may kindly refer to page 89, my lord, of the same writ petition.
Yes.
Page 89, para 7, my lord. My witness says, my lord, this is referred by the senior counsel also. 3/5/2008. In fact, it should be 36 or 35 because 36 is the compulsory date of retirement. ರಾಜುವಿಗೆ ಕಡ್ಡಾಯ ನಿವೃತ್ತಿಯಾದಾಗ ಅವನಿಗೆ 8,900 ಸಂಬಳದ ಬಗ್ಗೆ ಪಾವತಿ ಮಾಡಬೇಕಾಗಿತ್ತು. ರಾಜುವಿಗೆ ಕಡ್ಡಾಯ ನಿವೃತ್ತಿ ಮಾಡಿದಾಗ ನಮ್ಮ ಸಂಘವು ಅವನಿಗೆ ಎಷ್ಟು ಹಣ ಪಾವತಿ ಮಾಡಿದ್ರೆ ನನಗೆ ನೆನಪಿಲ್ಲ. ನಮ್ಮ ಸಂಘ ತೋರಿಸಿದ ಲೆಕ್ಕದ ಪ್ರಕಾರ ಹಣ ಪಾವತಿ ನಿಜ. ಪ್ಯಾರಾ 8 is important. ನಾವು ರಾಜುವಿಗೆ ಕಡ್ಡಾಯ ನಿವೃತ್ತಿ ಮಾಡಿದಾಗ ಅವನಿಗೆ 1 ತಿಂಗಳ ಸಂಬಳ ಸರಿಯಾಗಿ ಕೊಟ್ಟಿಲ್ಲ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. Black kindly see if that was what he has said is 8904 was correct, then you could not have answered this like this, because what was paid to him from 2000 to 2008 when he was working idling, we have paid what we have given is correct. Therefore, assuming salary of 8,904 which was paid when the negotiation took place, that is not the wage that can be paid to him under 32B when an application is filed. In this regard, Mela, I just request your lordship to the statement of objection filed by me, just 2 paras, I will close my case. Mela. Statement of objection is filed in this case, my lord, by me on 19/1/2015.
Yes. Yes.
Para 4, page para 6, page 4, my lord, of the statement of objections. Just this, kindly permit me to read this because this is very crucial. Para 6, my lord. The contention in para 15 of the writ petition, the management witnesses admitted that a sum of 8,904 required to be paid as 1 month wages. However, only 1,682 was paid is totally untenable and baseless. The statement of the witness at para 7 of the deposition at page 89 of the writ petition is taken out of context because in para 8, the cross-examination, the witness clearly has denied the suggestion that 1 month's salary is not correctly paid. In this regard, it is relevant to note that the petitioner workman was compulsory retired by order dated 3/6 as per copy R5. The salary of the petitioner from January 2005 to May 2008 was 1,000. We are given the details, my lord. Gross was 1,682. Net was 1,496, which he has admitted 1,682 has been paid. Witness has admitted. The net salary was remitted to the petitioner's savings bank account available with the Punjab. The 5 statements of salary details for the months of January 2008, February 2008, March 2008, April and May of the some of the employees, including that of the petitioner, produced as annexure R6, R7, R8, R9, R10, respectively to the object. Therefore, it is clear from the above that the last drawn gross salary of the petitioner workman was 1,682 as on 3/6/2008, date of compulsory retirement of the petitioner. Therefore, the payment of rupees 1,682 is 1 month wage, while 530 is factually and legally correct. Next parameter, this one you will have to kindly just permit me read this para where I have explained how this 8,904 came. Para 7, my lord. The respondent submit the reference made to the deposition of K. Mayana, legal officer of the petition institution, at para 7 of the annexure D at page 18 of the petition, that wages payable to the workman was 8904 is quoted out of context. The second additional labor code, Bangalore, in reference number 82 by award dated 8/2/2006, reinstated the petitioner with full back wages. The petition was reinstated. However, regarding back wages, there was dispute. On 3/12/2008, workman had claimed 17,69,958 before the Deputy Labour Commissioner towards arrears of salary on the basis of the award dated 8/2/2006. A copy of the petition filed before DLC claiming 17 lakhs is produced R11 to this statement of objection. During the discussion before the DLC, Deputy Labour Commissioner, my lord, the matter was negotiated. The respondent manager offered a sum of rupees 4,37,366 in full final settlement as per settlement, which is at annexure G to the writ petition. The management, as per negotiation, agreed to refix the pay of the petitioner from April 1990 to June 2000 in a sum of rupees 4,37,366. Thus, for May 2008, the wage fixation agreed was 8,994 per month. You will have to kind of say he was compulsory retired in June 2008. This negotiation went on in June 2009. After 1 year, this negotiation was going on. This was during June 2009, after 1 year of his compulsory retirement. However, the petitioner was not ready to accept the same in full and final settlement on the ground that the petitioner has to get a salary of 15,000 per month for May 2008. For 1 second, my lord, therefore, the DLC dismissed the claim application of the petitioner by order dated 30/11/2000, which is under challenge in WP, the second writ petition, which is pending before them. In view of the above, the statement of Sri K. Mayana, legal officer, during cross-examination, the salary of the petitioner during May 2 was agreed to be paid is based on the said negotiations and the statement at annexure G. Hence, the said admission of MW1, which is based on the negotiated statement at annexure G for settlement, cannot be taken out of contest and claim that salary of the petitioner was 8,009 for in May 2008. In fact, the petitioner has claimed 15,000 salary for May 2008 in his claim of 17,69,958 before the DLC. Therefore, there are three figures. 1682 we have paid, 8904 was the negotiated wage we said we will pay in June 2008, that is after 1 year of compulsory retirement. But he said, no, I have to get 15,000 in June 2008, May 2008. Therefore, he did not accept. Therefore, how can that figure of Mayana be taken as the wages paid to him? That wages is not, 8904 is not paid even to this day. Therefore, however, the actual salary of the petitioner is correctly paid salary slip. Therefore, 8904 per month cannot be construed as lost drawn wages of the petitioner for May 2008, since the settlement did not materialize between the parties and the claim application of the petitioner was dismissed on 3/11. Therefore, my humble submission is this figure, negotiated figure, cannot be the basis for payment of 33 to be 1 month wages. What he drew from January to May, June, we have given 1,680. The negotiated wage cannot be an admitted amount saying that yes, your witness, that is what he admitted. Yes, and the negotiation as per the statement is 8904, which is not paid even till this day. Therefore, my humble submission, my lord, the writ petitions of both the writ petitions of the P. Raju may kindly be dismissed. The writ petition filed by the management may please be allowed, my lord.
Lord, I have got one clarification. Your Lordship may kindly see, my learned friend, that the new Morris case, my learned friends made a distinction. Industrial dispute means that judgment, my lord, the principle remains the same. Now, please see, the judgment was delivered before section 2A came. 2A came, my lord, on 1/12/2065, 1965. Please, your Lordship may kindly refer to Industrial Disputes Act. Dismissal of an individual workman to be deemed to be an industrial dispute.
Capital A.
2A, 2 capital A.
Yes.
Otherly, that definition, my lord, that it was inserted in the statute book with effect from 1/12/1965. ಇದರಲ್ಲಿ ಏನು ಹೇಳುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ, where an employer discharges, dismisses, retrenches, or otherwise terminates the services of the individual workman, any dispute or difference between the workman and his employer connected with or arising out of such discharge, dismissal, retrenchment, termination shall be deemed to be an industrial dispute. Industrial dispute ಅಂತ ಹೇಳಿದ್ರೆ 2K. So their lordships, my lord, what their lordships decided was pertaining to the industrial dispute. Now, individual workman, my learned friend says, by virtue of 2A, it becomes an industrial dispute within the meaning of section 2K. So the law laid down, that is, my lord, in New Morris case, which I read to your lordship for today in extenso, what is meant by, my lord, concerned workman, my lord, does not in any way is affected. My learned friend's argument, this 2A, the individual and third one, my lord, it is unfortunately, my lord, it is a little misleading. That's all right. That is, my lord, as far as that is concerned. The principle of law laid down in New Morris case still holds good. Yes, yes. My learned friend, my lord, I only want to reply to this in my case is this, my lord. Your lordship may kindly see in his report, he says, my lord, what he read is, in his report, he says all the documents were given, witnesses were given, everything was given. Now, please see, my lord, is cross-examination. Cross-examination of the witness at page 71 of the paper book. That is my writ petition, paragraph 19. My lord, this ಅದರಲ್ಲಿ 71ನೇ ಪೇಜು ಪ್ಯಾರಾಗ್ರಾಫ್ 19, ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 12515 2013. ಅದರಲ್ಲಿ 71 ಪೇಜ್ 71 ಅದರಲ್ಲಿ 19th paragraph ನೋಡಿ. I conducted the domestic inquiry by observing principles of natural justice and also allowing service rules of the management. Copies of exhibits A1 and A2 were not given to the opposite party. I do not know whenever the management served the copies of exhibits A1 and A2. I do not know whether the opposite party was given copies of all the documents, list of witnesses, statements of witnesses, and the imputations of misconduct along with the charge sheet. He definitely categorically states, I do not know the cross-examination ನಲ್ಲಿ ಹೇಳುವಂತದ್ದನ್ನು ನೀವು ರಿಪೋರ್ಟ್ ನಲ್ಲಿ ಏನ್ ಬೇಕಾದ್ರೂ ಬರಿಬಹುದು. So, but in the cross-examination, this gentleman, my lord, is fair enough to admit what he has done. And he has also said, I have not daily, my lord, the order sheet I have not written. My lord, that's what he has said. So, my lord, these are all inquiries, my lord, which are called made to order inquiries. And there is no doubt about it that he has not given anything. Now, my lord, only one aspect which I would like your lordship to kindly see. My learned friend read his objection statement. I am grateful to him for that. Please see, which he just now read at paragraph 6 of his objection statement. Page 6. Now, May 2008, he says, my lord, 4,37,366. Now, please see the sentence. Thus, for May 2008, the wage fixation agreed was 8,904 per month. This should have been paid to him, even according to them, even as per the negotiations. Let us see, my lord, negotiations. Thus,
he did not accept. That's what we are
I
saying.
need not accept, I say.
Yes,
It is
sir,
your responsibility.
No,
It is your responsibility to
prior
pay
to that,
the.
we have paid 4 lakhs.
Mr.
We have paid 4 lakhs.
Yes. 4 lakhs for 20 years. That is another aspect. My lord, he is an employer of a organization with according to him, 2,000 people. He says, I will pay 1,600 for 20 years. Even though, even according to him, he is obliged to pay 8,904. That's what his witness also has said.
That is negotiated. That's what I am submitting. DLC said you negotiated.
I think you have made your argument.
Yes.
Please allow me to make my submissions.
Sorry.
Both of you.
Yes.
You are repeating this is senior counsel. You are repeating this. You are repeating this. And second thing is, you are arguing to each other, not for the court.
My submission to your lordship is this.
Because both of you are in charge of the case since 2008.
Yes, my lord, that is the unfortunate part of it. That is, we should not allow cases, my lord, to hang on, my lord, for such a long time. My lord, they themselves say they have made a mistake. 8,904.
No, you argument previously. I
am sorry, my lord. I am sorry, extremely sorry. I have just tried your lordship.
We are seeking only one help from you, both of you, because the judgment compilations are in several bits.
Within 3 days,
ನಿಮ್ಮ colleagues ಬಂದು ಅದನ್ನ ಒಂದೇ compilation ಒಂದು ಸಿನಾಪ್ಸಿಸ್ ಯಾವ ಕಾಂಟೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ರಿಲೈ ಆಗಿದ್ದೀರಾ.
That is one, my lord. That is one more thing, my lord, which I wanted to make my submission. My learned friend produced today's authorities. They all arise out of 226 petitions where parties, my lord, filed directly, bank employees directly filed petitions. Your lordship knows there is a fundamental difference between an adjudication under the industrial law and a petition under Article 226. Industrial law, not only, my lord, it enforces the existing right, it can also make a contract. It can also see if there is an injustice. It can set right that injustice. Whereas 226 says, where is the infraction of your legal right? It cannot go beyond that. But industrial law, industrial adjudication, industrial jurisprudence says, I can, wherever there is injustice between the employer and the employee, I can set right that injustice. My lord, there is a difference. And ever since, that is, my lord, what you call that, Western India Automobile versus Workman, the decision of the Supreme Court in AIR 1949, Federal Court, page 111, my lord, that says the distinction between, my lord, an industrial adjudication and the other law. So now, as far as those decisions, my lord, cannot be relied upon at all. And as far as the synopsis is concerned, my lord, we will furnish it.
I will also furnish within 3
There
days.
is no argument thereafter.
Much obliged. Much obliged. Much obliged. I will furnish within 3 days. I will furnish within 3 days the synopsis.
And both sides. Both counsel shall submit the written synopsis of their arguments. Yes, arguments with reference to the judgments relied on by them.
Much
Very
obliged.
well, my lord.
Much
Based
obliged.
on what?
Much obliged.
When are you going to do that?
I think we have really tried your lordship's patience.
Right, so we'll reserve it after doing that. Vacation and when do you submit the written synopsis?
My lord,
Monday,
within 3 or 4 days, during the
Monday.
course of the week, my lord. ಮಂಡೆಗೆ ಹಾಕೊಳ್ಬಹುದು ಅವತ್ತು ಕೊಟ್ಟು ಬಿಡ್ತೀವಿ.
By Monday we will submit.
5-4.
5-4. Much obliged. Much obliged.
ಅವ್ರು ನಿಮ್ ಕೊಲೀಗ್ಸ್ ಬಂದು ಇಲ್ಲಿ ಸೈಟೇಷನ್ಸ್ ಬೇರೆ ಬೇರೆ ಮಾಡಿದಾರಲ್ಲ ಅದನ್ನೆಲ್ಲ ಒಂದೇ ಕಂಪೈಲೇಷನ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಆಯ್ತು.
We'll do it. Yes.
Orders to
Number 31, 34, Girisha Kunti, CTS, Associates.
ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ರಾ? ಸಬ್ಮಿಟೆಡ್ ದ ಮೆಮೊ ಯಾವ್ದದು? 495 ಕೊಡಿ. ಮೊದಲು ಹೇಳಿದ್ರಲ್ಲ ಪಿಟಿಷನರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಇನ್ನೊಂದು ಸರಿ ಹೇಳಿ. Petitioner, respondent, and both counsel present. What is the duty identified by their respective counsel? What is submit? The compromise restriction under section 147 of the Act. And the compromise petition. 1,80,000 ಕೊಟ್ಟಿದ್ದಾರಾ? Deposited 90,000 before this court and sum of 90,000 before. The sum of 90,000 is paid to the respondent by way of cash. The respondent is permitted to get the amount released. Receipt of and discharge. ಏನೀಗ ಅವ್ರಿಗೆ ಅಂದ್ರೆ 90,000 he is still to withdraw ಮಾಡಬೇಕು. Okay. 80,000 cash ಅಲ್ಲಿ ರಿಸೀವ್ ಮಾಡಿದೀರಾ? Who is that? VP ಓಂಕಾರ್. ಓಂಕಾರ್ ಅಂದ್ರೆ ನೀವೇನಾ? ಏನಂತ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? ಏನಂತ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? 90,000 ರೂಪಾಯಿ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರೋದನ್ನ ವಿತ್ಡ್ರಾ ಮಾಡೋದು, ಇನ್ನು 90,000 ರೂಪಾಯಿ ನಗದು ರಿಸೀವ್ ಮಾಡಿದ್ದೀರಾ? ಬಂದಿದೆ ನಿಮ್ಗೆ? ಅವ್ರನ್ನ ಕೇಸಿಂದ ಬಿಡುಗಡೆ ಮಾಡ್ಬೋದಾ? ರೆಸ್ಪಾಂಡೆಂಟ್ agrees for compounding the matter. Agrees for compounding the matter. This petition arises from the order of conviction and sentence passed against the petitioner. Whether passed against the petitioner. The offense punishable under section 138 of the Act. Sentence to fine of this 2,01,000. Sentence of imprisonment of 6 months. You are sentenced to imprisonment of 6 months and fine of this 2,01,000. Said offense is a compoundable one. 137 are the compounding provision. 147. Enacted. As per section 147 of Act, the said offense is compoundable one. He admits the receipt of the respondent admits the receipt of ₹90,000 from the petitioner, as mentioned in the compromise petition. the circumstances. Compounding of the offense is permitted. The circumstances permitted. The fiction is allowed in terms of the compromise. Fiction is allowed. The impugned order of conviction and sentence passed against the petitioner by the trial court and confirmed by the first appellate court is hereby set aside. Acquitted of the charge for the offense of discipline 138 of the NIA. Acquitted of the offense punishable under section 138 of the NIA. The trial court shall release rupees 90,000. 90,000. ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ ತಾನೆ 90,000 ಬಿಫೋರ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಟು ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕಂಪ್ಲೇನೆಂಟ್. ಒಂದು ಮುಗೀತು. Yes, 496. ಈಗ this 496 6 for 6438 is to quash the order passed in 498 496 ಅದು ಕೊಡಿ ನನಗೆ 6438 ಕೊಡಿ. So this judge ಇದು revision petition. This order was passed on 16th day of January 2021. With quashing again ಕೇಳ್ತಾ ಇದ್ದೀರಾ ಅದೇ ಆರ್ಡರ್. Please to allow this petition by quashing the conviction and sentence passed by the civil judge confirmed by the honorable principal civil judge. That's all. Yeah, read. ಯಾವ ಕೇಸಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ 6438 ಅಲ್ಲ
496 ಅಲ್ಲ
496 ಅಲ್ಲ. ಅಪ್ಲಿಕೇಶನ್ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಅಂತ ಇದೆ application is when you have filed the application IA1 call for records of criminal revision IA1 ಅಂತ ಹಾಕಿರೋದಾ page number 52 ನಲ್ಲಿ 6438 ತಾನೆ page number 52 52 482 So signed on which date? Subsequent. Judgment.
Now this is numbered as a separate petition.
This is numbered as a separate. 496. Oh, either copy ಇಲ್ಲ ಹಾಕಿದೀರಾ 496 2017 ಒಳಗಿನ ಪಿಟಿಷನ್ ಕಾಪಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇದರಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ವಾಟ್ ಇಸ್ ದಟ್?
Once my lord had disposed of 496. Then we try to approach this on and my lord writes this my lord. Once I dispose of, I cannot review. And then my lord we find a separate application under 482 which is given to be numbered as a criminal petition. And that criminal petition is also placed before my lord. So that now revision petition and disposal of matter is also there. And a separate criminal petition is also there. Now the simple question is my lord, whether my lord can accept the power under 482 and with the 147. Now first is
CRPC 482.
First I will go to 147, then I will go to 482.
147. ಹಿಂದೆ ಯಾವ್ದಾರ ಹಾಕಿದ್ರೆ ತೆಗೆದಿದ್ಯಾ ಇಟ್ಕೊಂಡು Nothing in this code shall be deemed to limit or affect order in a disk. Abuse of the process of
This one partition is new provision.
Which one is it?
One partition is new provision. It was not there earlier. It was inserted.
The criminal procedure, every offense punishment this will be componable.
Offenses will be componable. And it's the worst used.
Notwithstanding.
Anything containing the code of procedure. Every offense punishment of this section is componable. Now this section, CRPC, override CRPC. Every offense.
It overrides 462 or what is that? Amendment provision 362 or 462?
362. So my submission will be like this. Submission.
We got your point. You say that this overrides all the provisions of CRPC.
Yes, it overrides complete CRPC class. And next, the very important question is what stage is component. This section is totally silent about the stage.
Notwithstanding, notwithstanding anta ide
Stage as a stage also comes from the very inception till the end, until he completes the sentence. This is speak of a, according to my submission. It is not spoken of.
Yes.
So what is non-obstinate by virtue of non-obstinate cross method? This is component. Here is not a given. But my context of that number one, this is two set not. Next 320 subsection 9 megawatts.
320, 1 second.
320 megawatts. Subsection 9 megawatts provides. No offense is possible except provided by this section.
1 second. Save as otherwise provided by this code or by any other law for the time being in force. It saves antira ನೀವು 147 saves it anta.
Now because this is not now 147 it makes component because
we are also trying to find out some way for this. Yes.
Now
Section 320.
And this is to say I provided. 320.
Yes.
Is an exception to 362. 320 is entirely independent provision.
320 ಏನು 3 ಏನು ಅಂತ ಹೇಳೋದು. No, you were referring to particular section of 320, no subsection. The offense is componable under this section. The abatement of such offense. Subsection 9.
No offense will be component except for this was the provision 2002 amendment. So 130 was
No offense shall be compounded except as provided by this section.
Provision 320 did not contain any provision for compounding 130. There was no provision for compounding 130. Then because of the various reform committees they report to the government that there should be a provision for compounding 130. So till then, opposition was published only under 48 or 142. Yes. Now we will check this amendment. The subsection 9 is not taken again. That special provision is made.
Interplay of 147, 320 and 362.
Yes, exactly.
ನಮಗೂ ಇಂಥದ್ದೊಂದು ಏನಾದ್ರು ಮಾಡ್ಬೇಕು ಅಂತ ಇದೆ ಅದ್ರ 147 ಯಾಕಂದ್ರೆ there are judgments of the Supreme Court. These are the economic offenses. So ಇದ್ರಲ್ಲಿ ಏನು ಆಗ್ಲಿಕ್ಕಿಲ್ಲ. ನಾಳೆ ಇನ್ನಂತದ್ದು ಯಾವ್ದೋ ಒಂದು ಕೇಸ್ ತಗೊಂಡ್ ಬಂದು that should not become precedent to other. ಈಗ this ನಿಮ್ಮದು ಇದರೊಳಗಿನ application if that is allowed first petition, so the other petition does not survive.
only one petition is already disposed of.
ಅಲ್ಲ ನೀವೀಗ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡೋದೇ ಕೇಳ್ತಾ ಇಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಅನ್ನ.
No, I am not saying for amendment. That my lord, the first moment I agree with this situation doesn't apply.
So you are seeking compounding of the offense post judgment.
That's all. The only question for my lord is to decide whether post condition offense can be compounded. That's all the question.
So it does not amount to altering the judgment antana.
It does not. It's not. Because it's obviously this issue itself starts with those words. Subject to other provisions.
So this is notwithstanding anything contained in the Code of Criminal Procedure 1973, every offense punishable under this section shall be compoundable. This is with regard to compounding. So 362 deals with alteration of the judgment. Then it can be compounded even in the execution proceedings. No, Ali compound ಮಾಡ್ಕೋಬಹುದು. Why are you insisting for compounding here? We direct the no, with all these observations, we direct the trial court to permit the compounding of this offense in execution case. ನಾವಿಲ್ಲೇನು ಆಲ್ಟರ್ ಮಾಡೋದಿಲ್ಲ. We direct the trial court to compound it. No, this we say this can be permitted post judgment stage also, where it is pending. Now it is not pending. Now it is pending with the execution court. You are trying to you are the complainant.
Yes,
You have filed application for enforcement.
Yes.
ಅಲ್ಲಿ ಕಂಪೌಂಡ್ ಮಾಡಬಹುದು ಅಂತ. ಅವಾಗ ಎಷ್ಟೊಂದು ಕೇಸುಗಳು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಂದ ಹೋಗುತ್ತೆ ನಾವು ಆ ರೀತಿ ಮಾಡಿದ್ರೆ ಅಂತ. See, we have to lay down a law here.
Yes.
So even if the matter is decided by the district court or the high court, in view of the interplay of this section 147, 362 and 320, this can be compounded even post judgment stage. But where it has to be compounded now, if we permit compounding here, it amounts to alteration of judgment. Where there is a scope for compounding, they can compound there.
Yes.
What to, you should get the relief. And in the similar cases, the party should get the relief. He say if the parties compromise, they will compound it in the execution cases. In next cases, here ಇದನ್ನ ಹಾಕಿದೀರಾ? Whether you have filed any compromise petition here, compounding application here. 482 and 47. ಇದರಲ್ಲಿ ಬರೀ ಇದು ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಇದೆ ಅಲ್ಲ ನೀವು ಕೊಟ್ಟಿರೋದು, ಒರಿಜಿನಲ್ ಎಲ್ಲಿದೆ? This criminal revision petition number 496, criminal revision petition 6438 of 2021. ಇಲ್ಲಿ ಒರಿಜಿನಲ್ ಇಲ್ಲ, ಒರಿಜಿನಲ್ ಕಂಪೌಂಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್. ಒಂದು ನಿಮಿಷ ನೋಡೋಣ. ಅದರಲ್ಲಿ ಕರೆಕ್ಟ್ ಅದ ಮತ್ತೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ರಲ್ಲ, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ, ಅದ್ರ ಜೊತೆಗೆ ಹಾಕಿದ್ದೀರಾ. In the same case,
legal hurdle also in place before my lord, so that the lord's final decision may take to be some of the citation. Before I start the citation, tell me this is what I want to say. So the same thing. Number two, as the stage is concerned, at which it will be compounded. Supreme Court in Damodar proposed case by law laid down that compromise cannot be easily allowed because I remember your lord's words. This may lead to at any stage if we give parties may start testing what the court is going to say, and then a compromise is not available. So Damodar proposed said, no, we will lay down some guidelines. The guidelines was if it is up to the high court stage, appeal stage, 15% of cost has to be up to. And if it is in the Supreme Court, 20%. Then the same matter came up before the another MP legal service authority came up before the Supreme Court. If such costs are imposed, etc., that may not facilitate compromises. Subsequently, again, the other Supreme Court said what we directed there is not a fixed formula. In the suitable cases, court have the power to reduce the costs. Subsequently, Supreme Court said so. Then This honorable court had also an occasion to consider this.
2010 is Damodar Prabhu's case. And that MP case, MP leadership, 2014.
Yes, that when they reduced, they said that this can be reduced.
It is at page number
34 is MP
34. Lovely. Whether members were the any of the member was common there. Page number 34. So, pre-judge bench judgment shall be.
In pre-judge bench judgment itself, one para was there. That para
Page
33. Sorry, page.
Para 83. Page 9 of the judgment. Yes, 9. Yes. Paragraph.
Choosing compounding as a last resort. Then my God, answer is given in last line of that page. And application compounding made after several years compounding results in the system being murdered, completely also declared.
1 second. Where are you?
Last 3 lines.
In the same para 21.
21 last 3 lines.
Yes.
Made after several years, application for compromise made after several years, results in the system being murdered. Problem is also declared. Let the following guidelines. These are the guidelines. Now, 1. A. Directions can be given that the dicta and summons is simply modified, making clear the issue that we make an application component. So, if any cost, if it does not make an application for component as a project, if the component is made before the magistrate subsequent state, component can be allowed to subsequent condition to 10%. The deposit is condition with the legal control. Such as
in revision or appeal.
15%. That is B. 20%.
Even you 20% and 15% in between is yes. Enta situation create work with children. You. Yes. Yes.
We are also conscious of the view that the judicial enforcement of the guidelines to be seen as an act of judicial lawmaking, and therefore an institution in the legislative domain. Because the case in 1967 does not carry guidelines how the possibility compound of the act. They already explained the scheme contained in China cannot be followed in the state sensitivity. We have the guidelines active. We see no hurdle to the endorsement of some suggestion which have been designed, discourage anything from until
ನೀವು ಕಾಸ್ಟ್ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ ಅವ್ರು ಇದರಲ್ಲಿ ಲೀಗಲ್ ಸರ್ವಿಸ್ ಅಥಾರಿಟಿಗೆ ನೀವು ಎಸ್
the various people imposing costs is means to encourage compromise and at least status quo. Value the food is spent on the travel use case. The parties are the proceedings are governed by the court. Even though the impact of the even though the including the parts of the distinction ends in network. The scale of cost has been suggested in the interest of uniform. The word is now suggested in the interest of uniform. Competent can of course reduce the costs regarding the specific factors of the case, while according to the reasons for such variance. One of the litigants, of course,
bona fide litigants.
This regard, the very same question regarding
it was confirmed at 3 levels now. Whether he can be called as a bona fide litigant now to compromise.
This was in the year 2010. Then, step further, in the next edition, JK Industries expanded literally from the
relevant the relevant page.
11th para, page number 29. Page 29.
Yes.
Para 60. Insertion of non-obstacle clause is a well-known legislative device in olden times. It had effect of non-obstacle, so and so. Then my lord, 64. Instance case non-obstructive clause person does not refer to the particular section of the law. When non-obstructive clause is used, the extent of impact has been found. So saying, my lord, then para 68, what they want to say is, my lord, all the provisions are not taken away. You have to see whether all the provisions are.
To what extent that non-obstructive clause shall operate, we have to see the intent and purpose of insertion.
And then para 68. Where the arguments was my lord. Entire that is taken away.
JK Industries.
Oh, JK Industries.
Next, para.
Para 68.
Yes.
It is clear from the rule of the aforesaid statement of objects and uses that offense of the act was previously non-compulsory of 20/9 is now become compulsory. That does not mean that the effect of section 1.2 is over. You correct all section provisions of section 20. Would relate to the mode and manner of compounding. Section 147 will only override 329. That's it. So saying, my lord,
We override section 329.
9 means
362 ಆಗೋದಿಲ್ಲ.
my lord, in 320.
Also.
In 320 there are other provisions.
Yes.
In 320 alone. And so saying, the Supreme Court now goes and step further, my lords, and says, kindly see para 82. This is one device adapted to the Supreme Court, my lord, to make it compoundable, even when amount is deposited by the court. At the intervention of the court, it can be compounded.
Good.
Para 82.
Good.
In the rules of section 220 makes clear the provision contains and the various subsections code by itself create compounding. It provides for the base parameters and procedures and guidelines in the management of compounding. It is code of course the content apparent that as a result of the involved compounds. Entire data of the the code are related to the compounding offense of the act. In that case, the compounding offense of the act will be left to the unguided or non-code. Such an interpretation, apart from being an absurd or argumentative one, will also be contrary to the provisions of section 4 of the code. There is no other statutory provision for compounding offense. Therefore, section 140 of the act must be reasonably construed to mean that a section offense of the act are made compoundable. Main principle of compounding every consent of the person reviewed. All the person reviewed, the complaint cannot be wished away. And so saying, my lord, the explanation, my lord. Before it starts, the portion here is para 22. That's 700.
1 second.
Running page number?
Done.
44.
45. Yes. Yes.
But for those of the law is that normally first as specified as judgment as double have to impose on the accused person by quality. And then departure that from a particular case, a good reason to record in writing. So this reason the court mentioned 3 objectives to sort of as taken over. Thus many such things are framing of evidence in the case of the issue. Here the issue of whether this guidelines are given to the court is decided. It's a bad rule. Having regard that to their opinion, even when the case is decided, the requirement of following the guidelines containing normally not be discussed. However, if there is specific one special evidence as other itself has given discretion use the specific by recording reasons in writing. Therefore, in those matters where the case has decided finds that it is felt a positive attitude of the party. In such a case, the court can always review the cause by putting minimal criteria why the same. That's all. And should it be only the last sentence that 24 says?
That is not the question. That is not the question before us.
Only one point now, the court has now found some departure is there. Now the court goes on to say, even the parties don't consent, the court can itself compromise if some was as the court decides is fixed. That is meters. Meters instruments. 46. It starts now. I can go to running page number 8.
48.
58.
Yes.
Any concept is involved that 18.2 at the top. The guidelines issued by the well-known guidelines. 18.2. The objection of the object of the provision will be primarily compensatory, as my lord just indicated before the submission began. Being compensatory. Punitive element is aiming the object of enforcing the compensatory element. Compounding at the initial stage has to be encouraged, but it's not debarred at later stage. Subject to appropriate comparison.
One second. Initial stage means the pending error has to be encouraged, but is not debarred at the later stage. Subject of this initial stage different means seems to be.
So after the course, that 18.3 can be seen. This is new concept first time. 18.3. Though compounding requires consent of both parties, even in absence of such this side, complaint has been duly compensated and it is this close the proceedings. New concept. You are this is meters.
Safer is to take the consent of the complainant because he is the affected party.
In meters, what I say, my lord, that amount the plus cost only can direction put to report. Oh, 30 action money away goes not. Commission better. Need not wait. That's what meters intention. Now, my lord, next decision and provision. How the court is considering the recent decision, bill number 60.
Yes.
One large, my lord. 3 decision. Very important decision. Discussing about the proceedings under 138, my lord. Tell my lord, instead of taking my lord all the paragraphs, my lord, permits me, my lord. I pray my lord to really permit me to refer to only the 11th paragraph in page number 73 itself, in the headnote itself. Just to show the.
In page number 73. Yes.
Now, entire my lord interplay between the NI Act and other civil proceedings, other criminal proceedings, why it's called constitutional, what is the effect, what is the purpose, everything is discussed in 3 judgments. Because the interplay between my lord under the insolvency and bankruptcy laws, whether proceedings and NI Act can be started, whether proceeding was used, once the case is admitted before the under the IB code, it says all the proceedings will be. So what is meant by the NI Act? What is the effect? That page 73, first at the top. A section 138 can be said to be a civil shield in a criminal rules clothing, as it is the interest of the victim that is not protected. Rather than the state being subsumed in the victim alone, who will be a court and check counts together, as has been seen by us in the analysis made before in chapter. The object of the so and so is to interfere in the efficacy, so and so provision is intended to prevent dishonesty, etc. Then the entire provision says last sentence will be that presumably Parliament also realized this aspect and inserted. Last 2 sentences. In such matter that normally compounding offense should not be denied. Maybe there
No, second paragraph. Yes.
That's paragraph 55.
Para?
55 there. Maybe copy second paragraph.
Page 73.
73.
Hmm.
Second paragraph.
In such matters, therefore, normally company will
Yes,
additional.
not presumably Parliament also realize this aspect and in Section 147. The gravity of the complaint of NA Act cannot be equated with an offence under the penal code or other criminal offences. Offence in 138 is almost connected to civil wrong. Is a given a criminal overdose. Chapter 5 is a unique exercise which blurs the dividing line between civil and criminal jurisdictions. Next, page number 74, only one paragraph I have to read. First paragraph. Grammar proceeding in the section 22, although quotes the language making that complaint of offence is really in order to get back. In order to get back. So, a summary, the amount contained in the government check, together with the inflation cost, expeditious activity, possible that contained plan to even the objective of this plan to proceeding. I'm reading this Supreme Court now here it says only purpose is to recover. Now in the light of these decisions, my lord, as far as the compounding is concerned, can we see page 157?
157.
157. The 3 judgments are very large. This is 9 crores. 157. This decision is often quoted.
Yes.
157. Can we break?
Yes.
Yeah, my lord.
So that is 2010.
2010. I'm putting this because this is quoted at several places for that purpose.
This Justice Nariman's judgment,
That
which
is very this 21.
2021.
My lord, I'm making a submission. Can you see the list of citations itself, my lord? First page itself. Citation page itself, my lord. At not one. Again, Roman number general principles containing 138. In that, division number 1 to 5, my lords, these are all the general guidelines. Decision number came Ibrahim, Supreme Court allowed the compromise. 138.
Serial number?
First page. First page. In Roman number 1, my lord, there are 1 to 8 divisions. 1 to 8.
1 to 8.
Only 1 to 5 all general guidelines.
General.
And the nature of 138. 1 to 5.
Prime is
Ibrahim is Supreme Court permitted compromise.
157. So the matter was pending in special
Yes.
criminal appeal.
Yes. And only one sentence in that page number 161. Para 13 only. Para 13.
Yes.
As far as the non-obstructive clause contains 147 being a special statute, provisions of 147 overriding effects. This is special statute.
Now all these cases only interplay of 320 and 147 are discussed, not 362.
This should be discussed.
Subsequent idea. ಮತ್ತೆ ನಮಗೆ we are concerned with only that. Yes.
Name of state is first page. First page. So game Ibrahim I concluded. Yancing may not have produced for this purpose.
Yancing's case.
Everywhere it's being quoted in the briefs. Only for this purpose.
Yancing's case.
For any reason, I'm not able to satisfy my law that.
No, we are not you satisfying. We should place some. We should lay down some based on these judgments. Some law.
Yes. Yancing it only says may not be power of 482 may not. But interpret 482 and 320.
ಅದಕ್ಕೆ ನಾವು 482 ನೋಡೋದಕ್ಕೆ ಪ್ರಾವಿಷನ್ ನೋಡಿದ್ವಿ. 482 ಅದೇನು ಬರೀ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇದು ಅಷ್ಟೇ ಅಂತನಾ ಏನು ಎನಿ ಕೋರ್ಟ್ಸ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಕ್ಯಾನ್ ಬಿ ಕ್ವಾಶ್ಡ್ ಅಂತನಾ 482
that interplays discussed my lords with the 320 is discussed in the Yancing.
ಅಲ್ಲಿನೂ ಆ ಸ್ಟೇಜ್ ಕ್ವಶನ್ ಇರೋದಿಲ್ಲ ರೀ. ಗಿವನ್ ಗ್ಯಾನ್ಸಿಂಗ್ ಕೇಸ್ ಅಲ್ಲಿ ಅದು ಇರೋದಿಲ್ಲ. Not nothing in this court shall be deemed to limit or affect the inherent powers of the High Court. To make such orders as may be necessary to give effect to any order under this court or to prevent abuse of the process of the court or otherwise to ಇದು ಎಲ್ಲಿ ಬರಬೇಕು ಅಂದ್ರೆ ಕೊನೆಗೆ ಟು ಸೆಕ್ಯೂರ್ ದ ಎಂಡ್ಸ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಅಲ್ಲೇ ಬರ್ಬೇಕೆ ಹೊರತು ಮೊದಲಿಂದ್ರಲ್ಲಿ ಬರೋದಿಲ್ಲ ಇದು. ಇಲ್ಲಾಂದ್ರೆ this itself amounts to abuse of the process of the court. ಇಲ್ಲಿ ಸೋತ ಮೇಲೆ ಇಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳ್ತೀವಿ ಅಂತ ಹೇಳೋದು.
Then the Lord said, where no period of limitation is provided, condoning of inordinate delay itself is a fraud on the statute. The word is itself is a fraud on the statute, my Lord.
The thing is, having regard to the object of the act, instead of flooding the courts of higher courts, like in appeal, revision, or civil appeal, it may, to some extent, it may serve the purpose of the act. Gansing bitbidi, Gansing ಅಲ್ಲಿ ಆ ಪಾಯಿಂಟ್ ಟಚ್ ಮಾಡಿಲ್ಲ ಸುಮ್ಮನೆ. Non-compoundable offenses also can be compounded if they have the civil nature. Contractual, commercial disputes ಇದೆ. ಅದು ಬಿಟ್ಟು ಮತ್ತೆ ಯಾವ್ದು ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
203 Narendra Singh also on the general business I do not have. Now directly I will go to the how this on the court has do this problem. I will go to this on court's decision. That's it. Page number 257.
257. This was pending the revision petition. Directly on the point.
My God is considering, but do not really exhaustive. Consider all these things.
Yes, wo ಎಲ್ಲಿದೆ?
258 may 258. Parties have filed an application under 1% of the enactment going to pass the sentence. Peculiarity of this case requires to consider. This case where the petition was committed with the title decision number 12 for next week. Awarded compensation, then they will challenge the fast track court, appeal to be dismissed. Agreed by the same petition, I will also approve this court to transfer. This court by the 81 dismiss the sentence. Concurrent filing conviction sentence for the trial court confirmed. Directly with the parties are compromised. Yes, my lord, the purpose of issue for the recording is compromised.
Yes.
Last sentence that came, Ibrahim is by producing. That is quoted. And next page 261. That one.
Yes.
Para 4 says one participant can include the participants.
Ultimately, what is said in the operative portion is consequently sentence passed by the trial court in CC number so and so is quashed. Any bail bonds ಅಂದ್ರೆ ನಮ್ಮ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕ್ವಾಶ್ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳಿಲ್ಲ ಇದರಲ್ಲಿ. ಪರ್ಮಿಟೆಡ್ ಕಂಪೌಂಡಿಂಗ್ ಅಂತ ಅಷ್ಟೇ ಹೇಳ್ಬೋದು. Permitted compounding and
consequently, my lord does not 328 and consequently commission practice set aside.
ಮತ್ತೆ ಇನ್ನು you want to realize some more judgments ಆಗಿದ್ರೆ ನಾವು ಇನ್ನೊಂದು ದಿವಸ ತಗೊಳ್ತೀವಿ ಅಲ್ಲ ಇರಬಹುದು ನೀವು you can submit ಯಾಕಂದ್ರೆ
I am also placing there are two views, one view of this high court, there are other high courts have 100 views, my lord, only that we cannot be done. In fact, Indian bench of Kerala High Court said it cannot be done. And Madras High Court has also said it cannot be done. And placing those also before my lord, so that my lord can take a decision. But Karnataka High Court one decision said so. And
ಬಗ್ಗೆ ಒಂದು ಪ್ರಾಪರ್ ವಯ ಮೀಡಿಯಾ ಏನ್ ಕಾಣ್ತಾ ಇದೆ ಅಂತಂದ್ರೆ it can be compounded at any stage even if the judgment is passed by the higher courts 138 ಅಲ್ಲೂ ಕಂಪೌಂಡ್ ಮಾಡಬಹುದು ಅಂತ ಹೇಳಿ so that henceforth even if they compromise they can complainant can file the execution and accused can compound it there also they have to deposit the cost because the parties are making a ನೋಡಿ ನಮ್ಮ ಟೈಮ್ ಇದ್ರ ಮೇಲೆ ಎಷ್ಟಾಗ್ತದೆ See, they should not make it a paradise of the litigants courts. They can walk anywhere here till the last nail is on their head. ಈಗ ಪ್ರೆಸೆನ್ಸ್ ಹೋದ್ರ ಅವರು ಅಲ್ಲ ಅದನ್ನ ನೋಟ್ ಮಾಡಿ ಆರ್ಡರ್ ಬೇಕಂದ್ರೆ ಇನ್ನೊಂದ್ ದಿವಸ ಮಾಡ್ಬೋದು. ಇದಾರ ಅದನ್ನ ನೋಟ್ ಮಾಡ್ಕೊಳ್ತೀವಿ. ಇಷ್ಟ ಮಾಡ್ಕೊಂಡು ವಿಲ್ ಡೂ ಇಟ್ ಆನ್ ಸಮ್ ಅದರ್ ಡೇ. ಅದು ಇನ್ನೂ ಏನೋ ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ petitioner and respondent, the respective counsel are present. The parties are duly identified by the counsel. Respondent parties ಏನಂತ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಈಗ ಇದರಲ್ಲಿ ಬೇರೆ ಕೇಸ್ 6438 ನಲ್ಲೇ ತಾನೆ ನೀವು 482 ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆಗೆ ಒಂದು ಮೆಮೊ ಹಾಕಿದಾರಲ್ಲ. ಇದೇನಾ ಕ್ವೆಶ್ಚನ್ ಇದರಲ್ಲಿ 6438 that is only citation. ಎಲ್ಲ ನೋಡಿದ್ವಲ್ಲ ನಾವು ಅವಾಗ to call for the records ಅಂತ ಹಾಕಿದ್ರ ಜೊತೆಗೆ ಇದ್ರಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್. ಎಸ್ respondent acknowledges a receipt to the said amount. Petitioner has deposited 4,40,000 before court below and is handed over the balance sum of rupees 4,41,000. So total ಏನು 8,81,000 ಆಗಿದೆ. Respondent submits that he is agreeable to compound the matter in terms of the compromise petition. And for acquittal of the petitioner. Noted the submissions of the parties and noted the compromise petition and the submission of the parties. Since the compromise petition is filed post conviction, post judgment, post dismissal of the revision petition, the matter requires to be heard about the effect of section 362 CRPC as requested. So our next time ಬರ್ದೇ ಇದ್ರು ಪರವಾಗಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಇದು ರೆಕಾರ್ಡ್ ಆಗಿಲ್ಲ. as requested list on ಇನ್ನೊಂದು ಹಾಕೊಂಡು next Thursday Friday 7
Matter request to be heard about the
request to be considered
on the effect of section 360.
Since
the compromise petition is filed post dismissal of the revision petition.
Okay. The effect of section 362 CRPC has to be considered. Heard in part, list down. For further hearing,
7-4.
ಯಾವುದೋ ಒಂದು ಕಾಂಪ್ರಮೈಸ್, ಇನ್ನೊಂದು ಕಾಂಪ್ರಮೈಸ್ ಇದೆ ಇವ್ರದ್ದು, ಯಾವ್ದು 2002 ಬರವೆಂಡ.
Am I appearing?
ಕರೆಕ್ಟಿಲ್ಲ.
Final hearing, 2:30 PM. Number 36. Am I paying for petition in this case, my lord?
Now file the memo.
Yes, my lord, I filed the memo in the counter file.
Yes.
My lord, I request one short accommodation for this matter, my lord, because senior is.
The request, the memo. What is that memo? Memo. It's not a memo of settlement. It is memo on the.
Yes, my lord, memo filed by the petitioners. This is not for settlement. Actually, this is for amendment in application hakide, my lord. Other mele one petition number 2 ge now implead ಮಾಡಿದ್ದೇವೆ. ಅದು ಇರೋದು application, my lord.
Therefore, the second petitioner respectfully prays that this court be pleased to grant various benefits.
Yes, my lord.
Memo claiming some benefits to the second petitioner.
Yes, my lord.
Okay. Okay. All right. Yeah, received the copy. Yeah, also filed the objection. It is not listed. Learned counsel for the respondent. For respondent number 2. Learned counsel for respondent number 2 submits that she has already submitted counter to the memo. Registry shall verify and list on. No, arbiter has submitted. 13.
Much of them.
230. Only. 230.
Number 37. B.S. Naik. K. Mohan Kumar.
Yes. It was not heard, Allah. Case not reached. We will list it after vacation. Yeah, you had argued before us. Let him take his chance. Next week, bitakol. 19.
Number 38, 39. A. Nagarajappa.
Is not reached. Who has filed memo here? Memo for listing. Huh? Who has filed it? Right. List date here. 3rd week. 24. ಅಲ್ಲ ಅವ್ರೇನೋ ಅರ್ಲಿ ಅಂತಾರೆ ಅರ್ಲಿ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವ್ರೇನೋ ಅರ್ಲಿ ಅಂತಾರಲ್ಲ 18, 19 ಎಲ್ಲ ಲಿಸ್ಟ್ ಆಗಿದಾವ ಈಗ 18 ಫೈನಲ್ ಹೇಳಿ 2:30ಗೆ ಬರ್ತಾ ಇದ್ದಾರೆ Who has filed memo here? Vacation ಬಂದಾಗಲೂ ನೀವು
he was not well. He is currently working as a BMTC
ಆಯ್ತು
conductor.
ಕೇಸ್ ನಾಟ್
Suspension order was set aside by the labor court. That order was challenged by the BMTC.
ಕೇಸ್ ಡೇಟ್ ಇಲ್ಲ soon after vacation ಆಗ್ತದೆ
Before that, we take chance.
ಆಯ್ತು 20th 24
41. Gopal Krishna Sri, P. Prasanna Kumar.
TCR ಸಿಸ್ಟಮ್ ಇದೆ ಇದರಲ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಕೇಸ್ ನಾಟ್ ಲಿಸ್ಟ್ ಆನ್ 20th 24
Serial number 36.
Memo filed by petitioner.
Claiming some benefits.